Good morning. How you doing? Yeah.
Juvenile already?
No, it is not. So I had still been in the office waiting for these to get printed. My colleagues in Juvenile got to get to meet her.
I have one ad for DVD.
Oh, how does that work?
Well, I did print the I did print the, where's my cover? I did print the hey,
Okay.
I just need product and a sale,
So I have to stay with right here.
but you won't have it for the ad.
Well, I'm saying that's the place they were.
Oh, you got no maintenance?
I was in non-domestic. Here, let's do the domestic right here.
Yeah, you still have some around. I just need, but the document the price. They make the price.
Yeah, we can run that for you on, of course, just real quick.
It's not problem.
Shouldn't be a problem.
And I can give you a case number. You have a copy of the phone?
Unlike the TV calendar, I think is upstairs in my car, but I'll still take case number and start filling out that man. Okay.
Out
Is that the last thing?
down, that's last year.
Well, I want to make sure down there.
No, down last
Oh,
year.
it's battery.
That
Nice.
is ours. Okay, and I can give you the identify, okay?
Thank you.
Take your time. Then we don't get to be scratching. You're ready. I think. Go ahead.
One, three, eight, two, two.
Good morning. Yeah, one. I have three, but two of them are still. Oh, you don't need to go. Yeah, okay.
All right. I'm ready to get.
Give me a sec. You know?
Oh,
Where you check out? That's the jail number. That's the jail number.
regardless though, is this bank the quarter control release?
Yes, that's it.
No, no, you're good. Me, as you can tell, I'm still getting the point to the project this morning.
Hey, it's right here and the next small bit. Let me know when you're ready.
And the application.
Oh, sure, 125, 104.75. Date of birth is 1/14/84. A black female. Height is 5'5". 160 right here. Date of birth. That's okay. 1/14/84. Black female. 5'5". 160. Yeah, we just gotta find out. Oh, I know. We just gotta find out. Is what's up, Vic? Would it be on the 8th? Okay, here it is. I got 8 plus.
Last page. Officers.
Oh,
Oh. This guy did. Mr. Collins is the victim. Let's see if we have Mr. Collins first name.
okay. 1/14/84. Okay, what's her name? Oh, actually, Peter, okay, did not.
She.
Right. Still not.
Alright, perfect. I'm going to go up with my group.
How many do you need for your guys to?
I'm trying,
So, alright, if you don't get it. Okay, thank you. No, also trying to think about my wisdom, like we're doing on the receiving for this time. I was like, okay, I don't know what it is, but I can't figure out. Oh, so. Yeah. Yeah, no, I was actually. But, right, thank you. I appreciate it. I got you. I have that. I have to figure it out. Okay, I don't want that on. I was sorry. Second. Nice to meet you too. Want to be like that? Yeah.
So, Mark, we got time to change.
All right. You should go in the order. Yeah. It's DD, there's more than there is. At least it's past that. I don't know. I didn't count. But yeah. The fact that it was still printing when I left. And you didn't print it. I did. Okay. Without me. Well, I did, but somebody. Okay. I just see as the last one. It can't be as bad as it wants to be. What's in?
And so, we should.
All right. Good morning. Thank you. And okay. I was wondering if you actually. Okay. Okay. Okay.
Corrections, are you ready? Okay. And do I click on the video button here? Let me ask great, the video that's blocked with the line on my screen, I don't need to unclick it, do I? I have audio and video down here, and video is still muted or blocked, but I see myself on the screen, so I guess I don't have to worry about that, right? Great. Thank you. At this time, the screen with respect to the public defender, that'll come up when they swear them all in. Madam Clerk, you ready to swear them in?
Yes, Judge, I'm ready. Corrections, can I please have everyone stand and raise their right hand?
Por favor, todos de pie y levanten la mano derecha.
Do you swear or affirm the testimony you're about to give today will be based on right hand? Right hand.
Swear to tell the truth?
Please say I do.
I do.
Juran decir la verdad, digan lo juro.
All right, good morning, everyone. Welcome. We're here for our weekend bond duty. This is the first appearance calendar. I'm going to be reading the charges to you. I'm Judge King, and we'll be assisted by the Public Defender's Office. And in this case, Public Defender, your name again, ma'am?
Good morning, Your Honor. Assistant Public Defender Christine Loaiza for the record.
Thank you. She's going to be assisting all of you. I advise that you not speak of your case, except if the court were to ask you, to the degree that it was background information only. In this case, you have a public defender appointed, and we're going to provisionally appoint the public defender in all cases here this morning at this time. Please remain silent, and we'll move swiftly through this calendar. Some of you may be released today. Some of you may be released pursuant to specific conditions, and we'll work diligently to make that happen if possible. Some will not be released because of certain factors related to their case. At this time, the first case is Erin Lee Gallup. Ms. Gallup, you've been charged with a misdemeanor of the first-degree battery in violation of Florida Statute 784.03. I've had a chance to review the arrest form in this case.
Sorry, Your Honor, one moment. I believe we have the wrong individual in the room.
Ms. Gomez, that was first, Ms. Gomez Ramirez.
Okay, this one was on top, so I just took it. But
She's number 5, Judge.
okay, number 5, I'll move it back.
And Ms. Gomez Ramirez will be requiring the services of the Spanish interpreter.
Connected. Good morning, Your Honor. Good morning, Ms. Loaiza.
Good morning. How are you, Miss La Rosa?
Very good. Thank you, sir. Thanks for asking.
Anything else? At this time, Ms. Gomez Ramirez is present, and she's been charged with violation of Florida Statute 784.03, misdemeanor in the first-degree battery. Taking a look at the arrest form.
La señora Gómez Ramírez se encuentra acá ya que ha quebrantado el Estatuto de la Florida 784.03, un delito menor de primer grado que es agresión. Voy a revisar el atestado de arresto.
I find probable cause in this case, state.
Your State's requesting standard bond of $1,000.
Your Honor, we would be asking for pretrial services. The arrest location and permanent address listed on the arrest form is Ms. Gomez Ramirez's residence, not the alleged victim. He does not live there.
Su señoría encuentra causa probable al delito que se le imputa. La fiscalía solicita una fianza de $1,000 y su abogada solicita el programa Pretrial Services, ya que la ubicación del incidente es la residencia de la señora Gómez Ramírez y no de la supuesta víctima.
No objection as long as they qualify, Your Honor.
Say again?
No objection as long as they qualify.
Thank you. Alternate bond set at how much standard you said?
$1,000, Your Honor.
Thank you. $1,000 standard bond, pretrial services approved. And as an alternate bond, she may be eligible for release today.
Muy bien.
Miss, you do obtain release today. You shall not engage in any criminal activity. You shall not use or possess any illegal drugs. You will not purchase, carry, or possess any firearms, guns, or weapons. And you must immediately surrender them to the nearest police station and obtain a receipt for the court if you do currently own such weapons. You're prohibited from having any direct contact with the following persons. That would be, looks like Soto Gomez, Kern. I'm not sure if I pronounced that correctly.
Your Honor, it's Kevin Delon Gomez.
Thank you, Kevin Jalón Gomez. He does not reside in the premises with you, is that correct?
El señor Yolón Gómez no vive con usted, ¿verdad, señora?
Yo sola vivo, él nada más llega a veces en cuando. La casa es mía, está mi nombre mío.
Listo. I live all alone. He just goes there to visit me.
At this time, you'll have no contact whatsoever with him, and you must remain at least 500 feet away from him at all times and his home, place of employment, or school. Thank you. Madam Clerk, you wish me to...
Muy bien, señora Gómez Ramírez. Entonces, usted sí califica para el programa Pretrial Services. Usted va a poder salir hoy mismo o, de lo contrario, va a pagar una fianza estándar de $1,000. Por favor, mientras que esto suceda, usted no puede participar de ninguna actividad delictiva. Usted no puede tener, consumir o comprar sustancias ilícitas. Usted tampoco puede portar, comprar o tener armas de fuego o munición. De tener alguna de estas, tiene que ir a la comisaría más cercana, entregarlas y luego dar el recibo de la entrega al tribunal. Además de eso, usted tiene prohibido tener contacto, ya sea directo o indirecto, con Kevin Yolón Gómez. No puede estar, en todo momento tiene que mantenerse a no menos de 500 pies de distancia de él, del lugar donde él viva, trabaje o estudie.
Thank you.
Está bien.
Sounds fine.
Morning, Ms. Francois. You've been charged with a misdemeanor of the first degree battery in violation of Florida Statute 784.03. The arrest form indicates that there was an incident alleged between you and your boyfriend. Court finds probable cause in this case. Madam State Attorney.
Your Honor, state's requesting a standard bond of $1,000.
And Your Honor, I do have a similar issue here. We would be looking for pretrial services, given that Ms. Francois has no priors and the residence listed is her residence, not the individual's. Even though the A form does say they reside together, the individual victim, John Charles, does not live there. If the court is not inclined to do that, she also has another address where she can stay at.
Your Honor, state has no objection as long as they qualify.
Thank you. Ma'am, you are eligible possibly for release today back to your home. You shall not engage in any criminal activity from this point forward. You will not use or possess any illegal drugs. You will not use, possess, or purchase any or carry any firearms, guns, weapons, or ammunition. If you own such items, you have to immediately tender them to the nearest police department and file with the court a receipt that you did so. Number third, you'll have no contact with Jean Charles, including any contact by writing, telephone, or through social media. and you'll stay away from him from at least 500 feet away from him at all time, and his home, place of employment, or school. At this time, good luck to you, ma'am. Say again?
Here are the bonds.
$1,000. Next case.
Donna, that was straight bond?
No, bond, no, alternate bond, $1,000, pretrial services approved, and the stay away order was signed. Isabella Gianchetti. Mr. Gianchetti, you've been charged with battery, misdemeanor first degree. This is a violation of Florida statute alleged 784.03 subsection 1. Taking a quick look, Madam, she does not need the interpreter, is that correct?
No, Your Honor.
All right. Court finds probable cause. In this case, bond, please.
Your state's requesting a standard bond of $1,000 and no objection to PTS that they're asking for it.
Your Honor, initially, we will make a probable cause argument in this case. Ms. Giachetti is charged with domestic violence under Florida statute 784.03. However, nowhere in the narrative does it indicate that this individual is living with her, that they have children in common. So it does not meet the standard for domestic violence under the Florida statute, so there is no probable cause.
Yeah, it is for domestic violence battery. There is probable cause for a battery, and it does go to the domestic violence courts for the administrative order, in which they do have a boyfriend-girlfriend relationship, so it is properly in the correct court, and additionally, there is probable cause for a battery.
Probable cause found in this case will provide pretrial services if you eligible. Yes, thank you. Alternate bond, $1,000. And ma'am, if you are eligible and are able to obtain release, you will not engage in any criminal activity. You'll not use or possess any illegal drugs. You'll not possess, purchase, carry any firearms, guns, ammunition, or weapons. You must immediately surrender any firearms and ammunition and concealed weapons permits to the nearest police department and file a receipt with the court. After having done so, you'll stay away from Miguel Garcia at least 500 feet at all times from his home, place of employment, place of business. You do not live with him, is that correct? That is. Good luck to you, man. I'll fix it if you want.
I appreciate it. Thank you. Oh, you did?
I did. Thank you. Next case, Julia Jackson. Good morning, Ms. Jackson. At this time, the arrest form indicates that you've been charged with a misdemeanor of the first degree battery in violation of 784.03 Florida statutes. Court finds probable cause in this case for the arrest based on the arrest form. State Attorney?
State's requesting a bond of $1,000, Your Honor.
Your Honor, defense would be asking for an ROR. Miss Jackson does not live in Florida. I mean, in Florida. Additionally, she has no priors. This incident happened at a hotel. She does not live with the alleged victim. And the alternative, we would be asking for pretrial services.
Your Honor, for corrections, she doesn't qualify for pretrial services and the state would object to ROR.
Thank you. In this case, court finds not only probable cause, but determines that there is not reasonable grounds for ROR. $1,000 bond. She's not eligible for pretrial services. And at this time, ma'am, if you are able to make bail and be released, you will not engage in any criminal activity. You will not use or possess any illegal drugs. You will not use, possess, purchase, or carry any firearms, guns, weapon, or ammunition, and you must immediately surrender any such items to the nearest police department and obtain a receipt to bring to court with you. You shall have no contact with Shauna Parker. You will remain 500 feet from the victim at all times, as alleged in this case, and you will not be within 500 feet of her place of employment, school, or home. Good luck to you. Thank you for being here. There you go. Next case. Now we're Karen Lee Gallup. Good morning, Miss Gallup. She arrived.
The next individual that I have on my calendar is Ms. Lofton.
No, it's okay.
Can we call Miss Erin Lee Gallup out of turn, please? I keep calling her. I'm not sure where she is. I put her at 5 back from the beginning. Do we know where she might be in the calendar?
Your Honor, she's an add-on, so it wasn't in our calendar.
Okay.
So I'm not sure that defense would have them either. Defense, do you need the case number?
That's okay. We'll move on. LeBra Lofton. Good morning, ma'am.
We got her, Your Honor. Ms. Gallup.
We got Miss Gallup. There we go. Thank you, ma'am. You've been charged with violation of Florida Statute 784.03, misdemeanor of the first degree battery. Court finds probable cause based on the arrest form. In this case, what is the offer by the state with respect to bond?
Your Honor, state's requesting a bond of $1,000.
Madam Public Defender.
Your Honor, we would be asking for pretrial services. The resident that is listed on the arrest form is Ms. Gallup's residence. The alleged victim is, he lives in Indiana, so he does not live with her.
Thank you. Granted. At this time, alternate bond, $1,000 pretrial services. And ma'am, if you were able to obtain release today, you'll have no engagement in any criminal activity, will not use or possess any illegal drugs. You're prohibited from having any direct or indirect contact with the victim in this case, and you may not be within 500 feet of that person, their home, their residence, in this case, employment or school. Do you understand? Yes, ma'am? I didn't hear. Thank you. Say again? Yes, please. This is marked off X for the, and I'm not sure. So is it, are you indicating they do cohabitate?
Use that one, Judge. This one is.
The victim alleged was Ryan Cobb, so you'll have no contact with Ryan Cobb, all right?
Not a problem, thank you.
Good luck to you, ma'am. Now we're back to Lofton, please. Good morning, ma'am. You've been charged with a misdemeanor battery, first degree domestic violence in violation of Florida 784.03, sub 1, sub A, Florida statutes. State, is there probable cause? In this case, there was a push.
Yes, Your Honor, push is a battery. It's an intentional touch or strike against the other person's will.
The state wants to maintain its suit in this case, Miss Loiza.
And Your Honor, I apologize. Can you repeat that, please?
Yes, I was just noting from the A form that the entire incident resulted allegedly in a push by Miss Lofton. And I was asking the state if they found reasonable probable cause in this case. They said, yes, they did. They feel that it's a battery. There are several District Court of Appeal opinions I'm aware of that indicate that potentially minor push, bumping, and things such as this don't qualify actually and rise to the level of warranting. But at the same time, why don't we do this? Does she cohabitate with him? No. Keith Gruber doesn't live with you. Is that correct, ma'am?
Your Honor, it does say that they reside together in the A form.
Does he reside, Madam Public Defender, if you know?
Your Honor, I have a note here that they do reside together. However, the address is Ms. Lofton's address. She is the one that pays the bills. Her name is on the lease.
All right.
Your Honor, we would be asking for an ROR with a stay away order from the individual, and a modified stay away order that is no harmful contact, given that the contact in this case was a push.
They live together. It's going to be hard for them to stay away from one another if we're going to do that. Any objection to a ROR?
Your Honor, the state is objecting to an ROR at this time.
You want a standard bond?
Yes, Your Honor.
That's fine. Bond, $100, alternate pretrial services if she's eligible. And to the degree that you must at all times stay away, ma'am, if you're able to be released here today, you'll not engage in any criminal conduct. You'll not have or possess any illegal drugs. You'll not purchase, possess, or carry any firearms, guns, weapons, or ammunition. And you'll have to tender those weapons to the nearest police department and file a receipt with the court if you do own such items. You're prohibited from having any direct or indirect contact with Keith Gruber Jr., including in writing or by telephone, and you'll stay at least 500 feet away from the victim and the victim's home, place of employment, and or school at all times until further order of this court. You may return one time to the residence and retrieve your personal items with the accompaniment of a police officer. Good luck to you. Thank you. Next case, McIntosh. Tiara McIntosh. Good morning, ma'am. This time, hello, we have someone in the courtroom. You are, ma'am?
Mom.
Okay, Miss McIntosh, your mother's in the courtroom.
Oh, hi. Hello.
Court. Your name for the record?
Helen Green.
Helen Green. Thank you for being here, ma'am. In this case, Ms. McIntosh, you've been charged with domestic violence in violation of Florida Statute 784.03 subsection 1. This is a first-degree misdemeanor. Yeah. Says that in this case, the alleged victim, the parties live together and they have one child in common. Actually, it looks like from the A form, Madam State, that this is the current Miss McIntosh and someone named Hyler, Hylor, who were.
That's her sister.
Yes, Your Honor, the co-defendant, the co-defendant is next.
Got it. Okay, and that they were involved in an alleged incident where they jumped the defendant, McIntosh and Hyler. Court finds probable cause in this case. What is the state's position?
Your Honor, state's just requesting standard bond of $1,000.
Pretrial service is eligible?
Yes, Your Honor. Defense is asking for pretrial services. Miss McIntosh does not live at that residence. She was just visiting her sister.
Pretrial services granted, alternate bond $1,000. If at any time, Ms. McIntosh, you're able to be released, you shall be not involved in any criminal activity. You'll not possess any illegal drugs. You'll not be in possession of any firearms, guns, weapons, or ammunition. And if you own such things, you must immediately take them and provide them to the nearest police department and obtain a receipt. You'll have no contact whatsoever with Amari Woodside. You will not be within 500 feet of this person, and you'll not contact them directly or indirectly by writing or telephone or social media. And you will remain at least 500 feet away from their home, place of employment, or school. In this case, was this defendant, Ms. McIntosh, the one who has a child in common with Mr. Woodside?
No, Your Honor.
No. Tyler does.
Yes.
Thank you. Thank you. Good luck to you, ma'am. The next case,
Your Honor, this is the co-defendant.
as anticipated, is Dewanagi Hyler. How are you, ma'am? At this time, you've been charged with a misdemeanor of the first-degree battery, domestic violence, in violation of Florida Statute 784.03. Taking a look at the arrest form, it's almost identical in terms of its facts and allegations as the previous case we just heard. I find probable cause in this case.
Your state's requesting a standard bond of $1,000.
Any eligibility for pretrial services?
Yes, Your Honor. We would be asking for pretrial services. The address on the arrest form is Ms. Hyler's address, not the alleged victim's. And she also has other addresses that she can stay at.
Granted. In this case, alternate bond, $1,000. Pretrial services granted. And at this time, ma'am, if you, Ms. Hyler, if you're able to be released, you'll have no involvement with any criminal activity. You'll not use or possess any illegal drugs. You'll not purchase, possess, or carry any firearms, guns, weapons, or ammunition. And you must immediately surrender any and all firearms and ammunition and any concealed weapons permits to the nearest police department and file and obtain a receipt filed with the clerk of court in your case. The defendant is prohibited from having any direct or indirect contact with Amari Woodside. Defendant must stay at least 500 feet away from the victim's home, place of employment, or school at all times. In this case, do they cohabitate together? Do they live together?
Oh.
No.
No, Your Honor.
Good luck to you, ma'am.
Thank you.
Thank you, Mom, for being here today to help them. More likely than not, they will both be released a little later today. Thank you. Next case. Kiara Casella. Good morning, ma'am. In this case, you've been charged with a misdemeanor of the first degree, domestic violence with harm in violation of 784.03 sub 1 sub A sub paragraph 2. This time, the court finds probable cause for the arrest. State Attorney.
Your Honor, state's requesting standard bond $1,000.
In this case, do they cohabitate together, if you know?
Yes, Your Honor, we would be asking for pretrial services given that Ms. Casella can stay at another residence.
Is the eligible? Granted. Pretrial services, alternate bond $1,000. The admonishment of the court is I'm entering an order to stay away at all times from Luis Diaz. You may not engage in any criminal activity. You'll not use or possess any illegal drugs. You'll not purchase, possess, or carry any firearms, guns, weapons, or ammunition. And if you own them, you must surrender them to the nearest police department and obtain a receipt that you did so and file that receipt with the court. The defendant is also prohibited from having direct or indirect contact with the following persons. Again, I said Luis Diaz. You must remain at least 500 feet away from the victim, his home, place of employment, or school. If you were to try to contact, you would be more likely than not rearrested. In this case, you may return to your residence one time in the accompaniment of a police officer to retrieve certain specific items such as personal or business-related paperwork and health and medication items. Other than that, if you go back without the accompaniment of a police officer, you would be subjecting yourself again to being arrested in violation of this court order. Do you understand, ma'am?
Yes.
Thank you. Good luck to you.
Yana, I'm sorry, what was the bond for Ms. Casella, please?
$1,000 alternate bond pretrial services granted.
Thank you.
Next case, Jacinda Tyler. All right. Ma'am, you've been charged with a misdemeanor of the first degree battery, Florida statute 784.03. It's involved a gentleman named Jaquan Williams. Court finds probable cause for the arrest. State Attorney.
State requesting standard bond of $1,000, Your Honor.
Pretrial services eligible. He's not eligible for pretrial services. The standard bond of $1,000 is hereby approved. Man,
If
Yes.
I can have the court proffer why she is not eligible for pretrial services. This is the arrest location is her address, not the alleged victims. He said, Miss Tyler said he was just spending the night that day.
thank you.
It
So there were some prior,
was a prior battery on a law enforcement officer. They completed PTI and it was null cross, but for corrections, it does make them ineligible. Yes.
because of that prior battery on a law enforcement officer, which was null prost, and she completed PTI. Pretrial services and their representative here today indicates she's not eligible for pretrial services. $1,000 bond. Ma'am, if you are released, you may not engage in any criminal activity, you may not use or possess any illegal drugs, you may not purchase, possess, or carry any firearms, guns, weapons, or ammunition, and you must immediately surrender these items to the nearest police department and obtain a receipt to be filed with the clerk and the court. The defendant in this case, you're prohibited from being within 500 feet of Jaquan Williams. You may not have any direct or indirect contact with him, and you may not be within 500 feet of his home, place of employment, or school. Do they cohabitate? Do you know, Madam Public Defender?
No, Your Honor. Per Ms. Tyler's indication, he does not live there.
Good luck to you, ma'am. Next case. Geraldine Fundamoro.
And Your Honor, Ms. Fundoramo requires the services of the Spanish interpreter.
Thank you. Good morning, ma'am. You've been charged with a misdemeanor of the first degree, criminal mischief, less than 200, I apologize, more than $200, less than 1,000, in violation of Florida Statute 806.13.
Muy buenos días, señor. Usted se encuentra acá y se le imputa un delito menor que es destrucción a la propiedad privada, un monto mayor a $200, pero menor a los $1,000, quebrantando así el Estatuto de la Florida 806.13.
Okay. Criminal mischief. I'm taking a look at the arrest form, and it said oh, I see. She tried to break the window. There it is. I apologize. Probable cause granted. State attorney?
Yes, Your Honor, states are just requesting a standard bond of $1,000.
Is she-
Your Honor,
Yes, she's eligible for pretrial. Yes, ma'am. Go ahead.
we would be doing a probable cause argument in this case. She is charged with criminal mischief in the first degree, which requires a finding of a monetary amount of damage, which is not stated anywhere in the narrative. Therefore, there is no probable cause for a misdemeanor in the for criminal mischief in the first degree.
Request a misdemeanor in the second degree, which is $200 or less and does not require an amount. As such, the new standard bond would be $250.
Your Honor, given that there is only probable cause for a misdemeanor in the second degree of a $250 bond, would be asking for ROR, since this is her first offense ever.
Your Honor, the state would object and request that a stay-away order be issued.
In this case, do they cohabitate together?
No, Your Honor.
One probable cause is found by the court not for misdemeanor in the first degree, only misdemeanor in the second degree. And she's going to be released on her own recognizance by the court at this time, as she has no priors. There will be no stay-away order issued in this matter. However, Ms. Funda Moro, please be aware that there seems to be alleged a problem in this case between you and your previous relationship, David Rodriguez. And if that has ended, you need to move on, because quite frankly, if you continue to go to his residence and try to break in or try to do this or that, it's just going to result in more involvement with the Miami-Dade Police Department. So I would highly recommend you move on from this situation, all right?
Muy bien, señora Fundemoro. Gracias al argumento de su abogada, su señoría encuentra motivo fundado, pero para un delito menor de segundo grado, que sería destrucción a la propiedad privada por un monto menor a los $200. Así que usted va a salir hoy en libertad bajo palabra y su señoría no va a emitir una orden de alejamiento. Como le digo, esto gracias al argumento de su abogada y porque usted no tiene antecedentes penales. Sin embargo, señora Fundemoro, quiero que sepa de que se alega que hay problemas entre usted y su expareja, el señor David Rodríguez. Le pido por favor que trate de avanzar con su vida. de que no continúe yendo a la casa de él, ni metiéndose con él, ni rompiéndole cosas a él, ya que lo único que va a crear es que usted tenga más problemas con la policía de Miami-Dade. Así que le pido, le ruego, por favor, que usted trate de avanzar en su vida.
Judge, I'm sorry for Miss Ponderomo. Is that a RR or there's no PC released outright?
To your honor, a release on their own recognizance is not a release outright. A release on your own recognizance, you can issue a stay away order. It means that they are being released, but there is PC. A release outright means that there is no PC.
Good. She's not released outright. She's released on her own recognizance, but not issuing a stay away order. I hope she follows my friendly advice. She doesn't have to if she doesn't wish to. Let's move on to the next case, the case of Ileana Cannon.
Excuse me, Your Honor, Ms. Joan Hennessy, it's representative of City Miami Beach is waiting to be admitted, please.
Thank you.
Thank you, sir.
Thank you.
Thank you. Thank you, Your Honor. Good morning.
Sorry about that. Yes, welcome again. In this case, Ms. Cannon, you've been charged with a violation of Florida Statute 784.03, subsection 1, misdemeanor of the first degree battery, domestic violence. Court finds probable cause.
Your Honor, state's requesting standard bond of $1,000.
Is she eligible? In this case, pretrial says she's not eligible. Standard bond
Okay,
1,000.
Your Honor, we would ask the court for a release on her own recognizance based on her based on the arrest form. It says here, I believe there is a very likable argument that this was a stand your ground, a self-defense case, given the two conflicting stories in the case, and given that she is not eligible for pretrial services, we would be asking for ROR with a stay away order.
State objects to ROR.
I concur. And yes, it is a fine line. Ms. Loiza has read carefully the arrest form, but under the circumstances, there were some surrounding facts that make it a little more ominous. So under the circumstance, I'm going to deny that. She has a $1,000 bond. If you're eligible for release, ma'am, you may not engage in any criminal activity. You will not use or possess any illegal drugs. You'll not use, purchase, possess, or carry any firearms, guns, weapons, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. You shall have no contact, direct or indirect, with Michael Hawkins, and you will not contact him in writing or by telephone or through social media or through third persons. You must stay at least 500 feet away from him at all times and his place of employment or school. Do they cohabitate?
No, Your Honor.
Good luck to you, ma'am. Next case, Devonna Brown. Good morning. In this case,
Your Honor, Ms. Brown also has a traffic case. She'll be on your jail arraignment calendar.
this afternoon, you mean for felony?
On your jail arraignment calendar, your misdemeanor calendar.
Okay, thank you. In this case, you've been charged with 2 counts. 1 count, misdemeanor of the first degree battery, causing bodily harm in violation of 784.03 Florida statute. Count 2, misdemeanor of the first degree, resisting an officer without violence to his person. Taking a look at the arrest form.
Your Honor, give me 1 second. I apologize. We have the wrong individual in the room.
Yes, we're looking for Devonna Lakeisha Brown.
I apologize, Your Honor. I believe there were two Browns. Devonna Brown and Crystal Brown.
Okay. Crystal may be later in the calendar, but I don't have her right now.
Your Honor, can we pass Ms. Brown, please?
Yes. Next case, Nelson Mondesir.
Your Honor, this is an added charge.
Thank you. Good morning, sir. You've been charged with misdemeanor of the first-degree battery in violation of Florida Statute 784.03. Taking a look at the arrest form.
Your Honor, on M259572, he received 2,500 plus GPS.
Thank you.
Is the other open case?
Court finds probable cause. State.
Your Honor, due to the other open case with the same victim, the state is requesting a bond of $2,000 and a level 1 GPS and a misdemeanor hold for division.
Level 1 GPS, and the last part of that was
$2,000, a level 1 GPS total lockdown, and a misdemeanor hold for the misdemeanor division.
thank
So
you.
then they'll get flagged about the new case.
On which case?
On both cases, but specifically M259572. I mean, sorry. Yes, 9572.
That case was already addressed. That's the case that he received 2,500 plus GPS.
So this case is M25-103-82.
Mm-hmm. So the misdemeanor holds on this case, but it's going to be for the other case because the bond has already been addressed in the other case.
I apologize. If I can get clarification of what level GPS Mr. Mondesir got for the case ending in 9572.
Hey, it's no hold on that case. He was already given a bond on that case. It's a hold on B24-11065.
Corrections, when was he given a bond on that? Sorry.
Repeat.
When was he giving a bond on the other case?
On 5-7.
Sure, that's why the state is asking for misdemeanor hold on this case, because since he already has another open case, then there should be a hold issue since he was given a previous.
Ma'am, it's no hold on this case. We're addressing this case now. We're addressing M25-10382.
Yes.
All right. Thank you for the input from everyone. At this time, $2,000 bond. He'll remain with a level 1 GPS, and he's got a misdemeanor hold.
Your Honor, defense would ask that you match the bond that Mr. Mondesir is getting on this case on his B24 case as well, so that he can get out today.
When you say match, what do you mean?
He has to go to division on that other case, Your Honor.
Right. Okay. Very good. Now, to the degree, Mr. Mondesir, you're able to obtain release at some future date. You'll not engage in any criminal activity. You'll not possess any illegal drugs. You'll not use or purchase or possess any firearms, guns, weapons, or ammunition. You must immediately surrender these to the nearest police department and file a receipt with the court that you've done so, should you own such items. You'll have no contact with Anel Scott. Defendant is prohibited from having any direct or indirect contacting Anel Scott, or in writing or by and through third parties. You must at all times remain at least 500 feet away from her home, place of school, or employment. I don't believe they cohabitate, is that correct?
No, Your Honor.
Thank you.
Judge, can you clarify the bond for corrections and for the clerk, please?
Yes, $2,000 bond in my case, that would be case M25-10382. Assigned to have and continue, if already has one, a level 1 GPS and misdemeanor hold. Thank you. All right, and I've signed the pretrial sentence electronic monitoring device release order. In this case, not released.
Thank you.
Thank you. Matthew Machin. Good luck, sir.
Excuse me, Your Honor. My apologies for interrupting again. It's just that your Portuguese interpreter is now connected and waiting to be promoted.
Thank you. Let's see. Do I have to do something here to allow the participant to enter the courtroom? Our Portuguese interpreter?
Good morning, Your Honor. This is the Portuguese interpreter. I believe I have been promoted and I'm ready whenever you are.
Thank you. Welcome, Ms. Yayo. Mr. Machin, you've been charged with a misdemeanor battery of the first degree, domestic violence.
Your Honor, is that the Portuguese case? I'm sorry.
Is Mr. Machin?
No, Your Honor.
No, we haven't addressed that case yet.
Okay, I'll stand by. Thank you.
That might be. Madam Interpreter, we'll be right with you in a moment. Thank you. Mr. Machin, you've been charged with a misdemeanor of the first degree battery, domestic violence, violation of Florida statute 784.03 subsection 1. This case, the court finds probable cause for the arrest.
Here's what's in your bond, $1,000, Your Honor.
Pretrial services eligible. In this case, he's not pretrial services eligible, so it'll be standard bond of $1,000. If by chance you're able to obtain release, Mr. Machin, you'll not engage in any criminal activity, you'll not use or possess any drugs, you'll not use, purchase, possess any firearms, guns, weapons, or any ammunition. You must immediately surrender any firearms, ammunition, or concealed weapons permits to the nearest police station and obtain a receipt to bring to court with you. The defendant is prohibited from having any direct or indirect contact with Casey Machin, either by writing, telephone, or social media, or through third parties. Defendant must stay at least 500 feet away from the victim's home, place of employment, school, or at all times.
Your Honor, if I could have the court proffer why he is not eligible for pretrial services?
Priors? Priors.
He's never been convicted except for a trespass.
Any kind of priors, even that one, violent.
Even cases where they were no action or no prost?
The answer is yes.
Okay, thank you, Judge.
You may return to the property with only a police officer escorting you within 48 hours of the entry of this stay away order. And you must then retrieve, if you wish, your personal belongings such as health items, medication, business related paperwork. However, you must go with only the accompaniment of a police officer. If you go by yourself, you subject yourself to being arrested. Good luck to you, sir. Thank you. Brian Alvaro Morales. Brian Alvaro Morales. Good morning, sir. In this case, you've been charged with a battery of the first degree, domestic violence, Florida statute 784.03 subsection 1, reviewing the arrest form. Court finds probable cause. In this case, the state
Bond of $1,000.
pretrial eligible.
Yeah.
He's pretrial services eligible. Court finds probable cause. alternate bond. Any objection by the public defender to an alternate bond of $1,000 with,
No, Your Honor. Pretrial services was given.
yes.
Perfect. Thank you.
If by chance, Mr. Morales, you're able to obtain release, you'll engage in no criminal activity whatsoever. You'll not use or possess any illegal drugs. You'll not purchase, possess, or carry any firearms, guns, weapons, or ammunition. You must immediately surrender any such ammunition or firearms and concealed weapons permits to the nearest police station and obtain a receipt and bring that receipt to court. Defendant is prohibited from having any direct or indirect contact with Brittany Morales by either writing, telephone, or through social media or through third parties. You must stay at least 500 feet away from the victim's home, place of employment, or school. Do they cohabitate, if you know, Madam Public Defender? Does he live with his sister?
No, Your Honor. He lives with his girlfriend.
Good luck to you, sir. Next case, Marcus Baxter.
Your Honor, I'm sorry. We have Miss Devonna Brown.
Yes, thank you, Devonna Brown. We had passed her earlier.
She also has a traffic case. She'll be on your misdemeanor calendar as well.
Thank you. Ms. Brown, you've been charged with a misdemeanor of the first degree battery causing bodily harm. Second count would be a misdemeanor of the first degree resisting an officer without violence to person in violation of Florida Statute 843.02. Court finds probable cause as to both counts. State.
$1,000 for count 1, $500 for count 2.
Your Honor,
Any-
defense would be asking for pretrial services. The address listed is Ms. Brown's address, not the alleged victims.
Until further order of the court, Devonna Brown shall not return to the residence in question unless they do not cohabitate. Do they cohabitate?
No, Your Honor.
So this property is exclusively Devonna Brown's. Yes?
Yes, Your Honor. Miss Brown's indication is that the alleged victim is homeless. She does not live with her.
All right. So under the circumstances, we're going to revisit the stay away order for a moment. First of all, if you're able to obtain release, you're not eligible for pretrial services, as I understand. Count 1, $1,000 bond. Count 2, $500 standard bond. You'll not engage in any criminal activity. You'll not use or possess any illegal drugs from this point forward. You'll not possess, purchase, or carry any firearms, guns, weapons, or ammunition. You must immediately surrender all firearms, ammunition, and concealed weapon permits to the nearest police department and obtain a receipt and file that with the court or bring it with you. Defendant is prohibited from having any direct or indirect contact with VP. In this case, I'm not sure if we have that name.
Yes, Your Honor. Venus Pantoja.
Venus Pantoja at any time, including buying through any writings, telephone, or social media or third persons. You'll remain at least 500 feet away from this individual, and you'll remain 500 feet away from this individual's home, place of employment, and school at all times. They do not cohabitate. Therefore, she may, if she's released, return to her home.
And Your Honor, if I can get a verification on the bond amount.
Bond amount is $1,000 for count 1 and $500 for count 2.
That was pretrial, correct?
No pretrial, correct? She's not eligible. Thank you. Brian Morales, I've already dealt with. How about Marcus Baxter? Sorry, this was on the previous case. Mr. Baxter, you've been charged with a misdemeanor battery of the first degree, violation of Florida Statute 784.03. At this time, state, I find probable cause.
Yes, Your Honor, state's requesting a standard bond of $1,000.
Is he pretrial services eligible?
Your Honor,
All-
defense is requesting pretrial services.
Granted. Sir, if you're eligible to be released, which could be today, you'll not engage in any criminal activity. You'll not possess any illegal drugs. You'll not use, possess, purchase, or carry any firearms, guns, weapons, or ammunition. You must immediately surrender any such firearms or weapons, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons. That would be Elizabeth Baxter. You shall not contact her in any form, writing, telephone, social media, or third parties. You'll remain at least 500 feet away from her at all times, including her place of employment, her place of residence, and school. In this case, do they both reside together?
Yes, Your Honor, but Mr. Baxter has an alternative address where he can stay at.
In this case, Mr. Baxter, you may return once to the residence where the incident occurred with the accompaniment of a police officer to retrieve certain limited personal items, medications, business-related paperwork. To the degree that you go unaccompanied back to that residence where possibly Elizabeth Baxter resides, you subject yourself to arrest. You understand?
Yes, Your Honor.
Good luck to you, sir. Next
Yeah,
case.
that was, I'm sorry, that was pretrial alternate 1,000?
Yes.
Thank you.
Valentin Gomez.
Your Honor, Mr. Gomez does require the services of the Spanish interpreter.
We have the interpreter present. Thank you. Mr. Gomez, you've been charged with a misdemeanor of the first degree, battery by touching or striking another, 784.03 subsection Florida statutes, subsection 1.
Buenos días, señor Gómez. A usted se le imputa un delito menor de primer grado, que sería agresión física por haber tocado o haber golpeado, según el Estatuto de la Florida 784.03, subsección 1.
In this case, the court finds probable cause for the arrest based on the arrest affidavit and form. State,
State requests a standard bond of $1,000, Your Honor.
pretrial eligible. Alternate bond, $1,000. Pretrial services eligible.
No objection from the defense.
In this case, I'm issuing a stay away order. In this case, Mr. Gomez, you'll not engage in the future in any criminal activity. You'll not use or possess any illegal drugs. You'll not purchase, possess, use, or carry any firearms, guns, weapons, or ammunition. And you must immediately surrender any such items to the nearest police department and obtain a receipt to file with the court. You shall have no contact whatsoever with Teresa Gomez at any time. Do they cohabitate?
Yes, Your Honor, but Mr. Gomez can stay with his siblings.
In this case, you'll have no contact with her in writing or telephone, through social media, or third parties. You must stay at least 500 feet away from the victim's home, place of employment, or school at all times. Since they cohabitate, you may return once to the residence in the accompaniment of a police officer to retrieve certain limited personal clothing, health items, medication, and business-related items, work papers. If you go without the accompaniment of a police officer, you subject yourself to being rearrested. Do you understand?
Muy bien, encuentro motivo fundado para el arresto luego de haber leído el atestado de arresto. Entonces, usted va a ser liberado bajo la supervisión del programa Pretrial Services o, de lo contrario, paga la fianza estándar de $1,000. Además de eso, señor Gómez, en esta causa voy a emitir una orden de alejamiento, lo cual quiere decir que usted no puede participar de ninguna actividad delictiva. Usted no puede tener o usar, consumir o tener sustancias ilícitas. Usted no puede comprar, portar o tener armas, armas de fuego o munición. De tener alguna de estas, tiene que entregarla a la comisaría más cercana y el recibo de dicha entrega dárselo al tribunal. Usted no puede contactar a Teresa Gómez en ningún momento. Usted no puede tener contacto con ella, ya sea por escrito, vía telefónica, a través de las redes sociales o a través de terceras personas. Y en todo momento usted tiene que mantenerse a no menos de 500 pies de distancia de ella, el lugar donde ella viva, trabaje o estudie. Ya que ustedes comparten la residencia, usted puede retornar a dicha residencia acompañado por un agente policial para recoger sus pertenencias, y solo se limita a sus pertenencias, que incluyen ropa, artículos personales, medicamentos, documentos personales o documentos de negocio. Si usted retorna a la vivienda sin ser acompañado por un policía, usted está sujeto a volver a ser arrestado. ¿Me ha entendido?
Sí.
Yes.
Thank you. Sorry, Madam Interpreter, I should have broken that up a little bit more for you.
Thank you, sir.
At this time, we'll call the next case. Good luck to you, sir. Thank you.
Buena suerte, señor.
Is Alessandro Theodoli. Good morning, sir. You've been charged with a misdemeanor battery in the first-degree domestic violence in violation of Florida Statute 784.03, subsection 1. I've had a chance to review the arrest form, and I find probable cause. State.
Your Honor, state requesting a bond of $1,000.
Pretrial eligible. He's alternate bond pretrial services eligible, Madam Public Defender.
No objection from the state, Your Honor, from the defense.
If you're able to be released in this case, Mr. Theodoli, you will engage in no criminal activity for the future. You will have no possession or use of illegal drugs. You shall not purchase or carry any firearms, guns, weapons, or ammunition. And you must immediately surrender any such firearms and ammunition and concealed weapons permits to the nearest police department and file, in this case, a receipt of same with the court. You shall have no contact with, in this case, the alleged victim. I was looking for the name. Identified as his brother. Madam State, you have the name
Yes, Your Honor.
of the alleged victim.
It is. No. For Ms. Williams, it's just. Are you for Ms. Sorry, for Ms. Theodoli?
Yes.
This is the victim. Mr. Felipe.
Thank you. At this time, do they cohabitate?
No, Your Honor.
Good luck to you, sir. You're free to go at this time, not free to go per se, but we have arranged for pretrial services for you. And I have indicated as you must stay away at all times from the alleged victim. Good luck to you. I think I got it all. Jaquan Maurice Williams. Mr. Williams, good morning. You have been charged in this case with criminal mischief of greater than $200, less than $1,000. That's a misdemeanor of the first degree in violation of Florida Statute 806.13 subsection 1. Also, you were picked up on an outstanding bench warrant, it looks like.
Your Honor, the bench warrant will be addressed in a misdemeanor calendar.
Thank you. Court finds probable cause for the count 1.
Your Honor, state is requesting an elevated bond of $2,000 due to the defendant's multiple DV priors, including a PBL kidnapping that was no action, a domestic strangulation that was no action, and a felon in possession of a firearm that was a conviction.
Bond sought is how much?
$2,000, Your Honor.
Probable cause found in this case, and the bond will be set at $2,000 as requested by the state.
And Your Honor, the defense would have an objection given that the state is stating prior arrests, not prior convictions. The only convictions were from 2013 and 2014, 1 misdemeanor, 3 felonies in the 3rd degree. So we would be objecting to an elevated bond, given that bond is to make sure that the individual can come back to court, which it seems that Mr. Williams can do that.
And Your Honor, just for record purposes, since they are domestic violence priors, the statute does permit that domestic violence can be considered, prior domestic violence can be considered. Additionally, the last one that the state did mention is a conviction for a felon in possession of a firearm.
That is a correct assessment, and both well argued by my public defender and state's attorney here today, but I'm going to overrule the objection. Thank you. $2,000 bond. If you're able to obtain release, Mr. Williams, you will not engage in any criminal activity whatsoever in the future. You'll not use or possess any illegal drugs. You'll not use, possess, purchase, or carry any firearms, guns, weapons, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons. That would be Jacinda Tyler. You may not contact her in writing, by telephone, through social media, or through third parties. You will remain at least 500 feet away from her at all time. Her place of residence or place of employment and or her school. This is a stay away order. Do they cohabitate together, Madam Public Defender, if you know? Do they reside together, Madam Public Defender?
No, Your Honor. The address is the alleged victim's address. Mr. Williams does not live there.
Good luck to you, sir. The next case on the calendar, the case of Lourdes Reyes.
Your Honor, I have here that the next case is Ken Tatiani. It's a warrant case.
I have Tatiani. We'll pass this other one. And I stand corrected. The one I called was Cosme Leyva, but I'll take Miss Tatiani Hen at this time. Good morning, ma'am.
And Your Honor, Ms. Hen does require the services of the Portuguese interpreter.
Portuguese interpreter present.
Thank you. Ms. Hen, you've been charged with a domestic violence warrant. It was issued for your failure to appear, I presume. And it's a violation of Florida Statute 996.004. In this case,
Senhora Ren, bom dia. A senhora que está aqui porque a senhora está sendo acusada de violência doméstica e não cumprir um mandado. A senhora não compareceu a uma audiência que havia sido agendada para a senhora. Isso é uma violação do Estatuto da Flórida, de número 996.004.
yes, there was a failure to appear at a hearing on April 23rd, 2025.
Foi um não comparecimento a uma audiência que estava agendada para a senhora para o dia 23 de abril de 2025.
At this time, state,
Qual a posição do Estado?
yes. At this time, any objection by the public defender, I'm going to vacate the warrant that's currently issued for her. I have an order here.
Neste momento, então, eu vou anular o mandado que foi emitido pelo Estado. Eu tenho um mandado aqui comigo.
Has she been
No
rescheduled?
objection.
She's been rescheduled for civil compliance on June 18th at 1 p.m. at the Lawson Thomas Courthouse Center in courtroom 2A.
I'm sorry, interpreter couldn't hear. Can you please repeat?
I'll repeat it slowly for you.
Thank
She
you.
is scheduled to appear for the civil violation that she missed on the last hearing.
Então, a senhora terá, então, que comparecer na próxima audiência, se tratando da audiência que a senhora não compareceu da última vez.
That would be the Lawson Thomas building, correct?
Será no edifício Lawson Thomas,
June 18th, 2025,
dia 18 de junho de 2025,
at 1 p.m.
à 1 da tarde,
in courtroom 2-8.
And that is
na sala de audiência 2A.
And she must be in person for that hearing.
E nessa audiência a senhora terá que comparecer presencialmente.
Do you understand?
A senhora entendeu?
Entendi, só falta o número do building. Please.
Yes, I did understand. I only don't have the building number, please.
Yeah, eu não consigo.
I believe she means the address of the Lawson Courthouse, Your Honor.
175 Northwest.
I'm sorry, interpreter can't hear, Madam Clerk.
Madam Interpreter? Can you hear me, Madam Interpreter?
I'll repeat it for her. 175 Northwest
First Avenue,
First Avenue,
Miami, Florida 33128.
Miami, Florida 33128. And that's right downtown Miami next to the magnificent old Dade County Courthouse, which is right next to the magnificent new Miami-Dade County Courthouse, which is called the Soto Building, of my understanding.
O endereço é 175 NW First 1 ST Avenue, Miami, Flórida 33128. Fica no centro de Miami, perto do novo prédio, o último prédio que foi feito da Justiça de Miami.
And she received that from the court only because I was born and raised here in Miami-Dade County, and I know all those buildings for many, many years. So the Lawson Thomas building is also a very nice building. It's right downtown as well. Good luck to you, ma'am. Thank you. Make sure next hearing.
E a senhora está recebendo essa informação porque eu nasci e cresci aqui perto desses prédios maravilhosos, e esse Lawson Thomas é um prédio muito bonito. Boa sorte para a senhora.
Ok, mas eu posso tirar uma dúvida?
Right, but can I ask you a question?
Tem um minuto. Eu fui lá na corte segunda-feira e sexta-feira, presencialmente. Eu nunca soube dessa audiência, eu não recebi correspondência na minha casa, e eu preciso saber se... Agora eu tenho anotado aqui, ok? E na sexta-feira apenas eles me deram um endereço, dvmotions@11.flcourts.org. Ok. E eu liguei também no número da corte e falei com a secretária do juiz. Isso na sexta. E por que eu não consegui esse atendimento nesses 2 dias que eu fui na corte, segunda e sexta? Estou muito triste e chateada.
Miss Interpreter, before you interpret all of that, since neither Miss Loaiza or myself speak fluent Portuguese, we want to make sure she's not discussing her case. She has the right to remain silent until such time as she's before, I guess, Judge Canava on June 16th. So if any of that dealt with the
Your
particular.
Honor, I apologize. I do believe she was talking about how she did not receive notice to her address, and I think she tried to reach out, but they never gave her this court date that she missed. I think that's what I got from what she said.
Correct, Your Honor. So she was mentioned that she went to, I believe she wasn't giving facts of the case. If you want me to, the interpreter to relay the information to you.
And the information was?
Well, I went to the courthouse on Monday and on Friday in person. I didn't receive any letter. I didn't receive any letter at my house. So I went to the address, and the only thing that I received was an email from floridacourts.org. That was the only information that I received. So why none of those days I was informed of that? So I'm very upset and
Yes.
sad and upset.
Yes, I'm sorry for your inconvenience, but at some point, the notice of hearing was provided to you. I'm not sure if you were unable to find the building or not. In any event, good luck to you, ma'am. I have set aside your bench warrant. You're free.
Senhora, eu sinto muito pelo inconveniente que a senhora teve, mas em algum momento a senhora recebeu essa notificação de audiência. Não sei se a senhora não conseguiu comparecer ou não encontrou o edifício, mas eu já retirei esse mandado de prisão da senhora. Agora a senhora está liberada. Não deixe de comparecer à próxima audiência. Boa sorte para a senhora.
This is a pre-trial arraignment calendar. Pre-first hearing, we do not conduct the trial or determine the merits of your case here today. That will be in June 16th, okay?
Então, esse é uma audiência pré-julgamento em relação a determinação primária do seu caso hoje. Então, não discuta, não fale a respeito dos seus casos de hoje, a respeito desse caso hoje, porque o seu caso será ouvido no dia 18 de junho, ok?
Could she please provide us her current home address so we make sure she gets notification?
A senhora pode, por gentileza, informar o seu endereço atual para a gente se certificar de que a senhora receba as notificações judiciais?
Sim, tá aqui, eu confirmei com a menina. É 1101 Southwest 12 Court, apartamento 2, Miami, 33135. Porém, a caixinha de correio no meu prédio reformado é toda aberta, todas as caixinhas são abertas. Então, não sei se eu vou receber, mas ok, tentem.
Yes, I already confirmed here with this lady. 1101 Southwest 12 Court, apartment 2 in Miami, 33135. However, the mailbox of my building is open. All the boxes are open, so I don't know, you can try.
Does she have an email address?
A senhora tem e-mail?
E por que não me enviaram no e-mail? Tenho, Amazona, de montar cavalo, Jump Horses, Amazona com 2 N's, Germany com Y, 2024, @gmail.com.
Why didn't you send me an email? Anyway, yes, it is Amazona Germany 2024 @gmail.com. Interpreter, will you spell that? AMAZONNA G as in golf, ER, M as in Mike, AN as in Nancy, Y 2024 @gmail.com.
I'd only like a correction on the first. I thought I heard her say Arizona. You pronounced it differently with the, could you respell that? Before Germany, I got everything after that.
Senhora, é Amazona ou Arizona?
Amazona de montar cavalos, Amazona.
It's Amazona as hiding horses, Amazona.
2 N's em navio.
You got it.
And then it has 2 N's, a double N as in Nancy.
Thank
So
you.
AMAZONNA, Germany 2024.
It was 1101 Southwest 12th Court. What was the apartment?
Apartment 2, Your Honor.
And is that Miami?
Miami, Florida, 33135.
All right, we've got every way to contact you. Hopefully the clerks will take that under advisement and make sure you get notice of the upcoming hearing. Good luck to you, ma'am. Thank you.
Your Honor, for
Okay.
the pen, is that a ROR?
Madam State. Any public defender? They say they stand mute with respect to mute with that.
Yes, but we need a disposition for the jail card. Is that a RR?
Yes, Your Honor, I believe the issue is with the jail card. If they don't have, I guess like a bond amount or anything that happened with the release of the individual, then that individual gets like a random hold.
ROR, it is. Thank you.
Thank you.
Next case,
Your
Cosme.
Honor, anything else from the Portuguese interpreter?
I think not. You've done an excellent job. Thank you for helping us here today.
Of course, my pleasure. Have a great day.
Thank you. I was also amazed that Ms. Loisa has some Portuguese background as well. I didn't know that. Sorry.
I do not, Your Honor, but it's fairly similar to Spanish, so I picked up words here and there.
There
You
you go.
did great. Great Sunday, everyone.
At this time, Mr. Leyva is here for the same purpose, actually. Domestic violence warrant 996.004. There was a previous failure to appear on December 4th, 2024 in front of Judge Carol Kelly, Chief Administrative Judge Carol Kelly. And this matter was issued. He was picked up. Does the state have any objection to vacating? This is a civil matter, I believe. This time, the court hereby orders the bench warrant currently in force and effect vacated and set aside. In this case, Mr. Leyva, you're going to have to appear at a hearing in the future. The reason you're here today is because you didn't appear at the hearing. Mr. Leyva, if you'll pay attention to me, please. Thank you. You didn't appear at a prior hearing, and that's why you had a bench warrant issued for your arrest. We're going to give you a new date and time to appear so that you make sure that you're there. In this case, what date and time would that be, please?
Your Honor, I'm sorry to interrupt the court, but I was just made aware that Mr. Leyva has other cases. I don't have those in front of me.
Yeah, he has jail arraignment. He also has an open felony. He'll be on all three calendars, Your Honor.
Okay.
So, Your
great.
Honor, for that next court day, I would just, in its discretion, he might still be in custody. Just wanted to make sure that the court was aware.
That's a month away, maybe or maybe not. Yes, we have to address this first, and then so June 18th.
1 p.m. at the Los Angeles Courthouse Center. In-person judge courtroom 2A for civil complaint.
2/8.
A as an apple judge.
A. Okay, thank you. He has to personally appear, correct?
Correct. And we need to update his address if it has changed.
Do we have a current address for him if it's?
650 Meridian Avenue, apartment 1, Miami Beach, Florida, 33139.
That was very fast and very quick. We're gonna have to slow that down a little. Could you, Madam Public Defender, interpret that for us?
650 Meridian Avenue, Miami Beach, Florida, apartment 1, 33139.
Yeah. If he'll write it down for us, please, and then you could read it to
Will
us.
do, Your Honor. Is it this one? Same one? Okay. Your Honor, it's 650 Meridian Avenue, apartment 1, Miami Beach, Florida, 33139.
Thank you.
Your Honor, that's the ROR as well.
Yes, thank you. And I've signed the order setting aside the domestic violence warrant. Okay. Very good. We'll see you back on our misdemeanor and felony calendars later. Thank you. Good luck to you, sir. All right, any other matters the state wishes me to broach at this time? Otherwise, we're going to take a brief recess, very brief. Thank you. All right, let's take a brief recess if you don't mind, and we'll come right back and we'll be starting with misdemeanor county. Thank you. Oh. 5 minutes, we don't have to go all the way back.
I file not this week, but next week for registered sex offender. So he is not a fan of taking some leave. And I was like, what are you gonna offer? They maybe an offer for fair management. He gave 2 options. And then he was like, no, you have to. Well, oh, I was like, you're habitual offender. I said, girl, for years, but I don't know how you get that. I'm not seeing it, but like, you're going. So we're gonna see. But
That's what I'm saying. What are you saying? I don't know.
that's so real. I swear, you so 60. Last week, so I have a day, okay? All right. You're here now. So I'm here now. So I like actually got to go up with my jacket when I came in today rather than having to bring all my own stuff. Yeah, I know. But yeah, so this will be my very last week of bond. Okay.
You're judge now.
You got it.
Really?
Yeah.
You kind of cheated.
Like, so. Well, no, that's why I got placed there. And
Yeah.
he knows me.
Okay.
And he knows mental health first specifically.
Yeah.
So I know how he works and operates.
Very to say the least.
Yeah. Communication. I'm talking about the level you're operating. This is probably a very little match. And you know, like, oh, are you just like, do you, they're not manipulated. Oh, like, our past on the very best, we still. Sounds like you're right. Well, I would like to have an application. That this is just, you should be so much. You should. But I could picture. We have a action. Walk us report you need. Rather than just think of it.
Right.
So we're working on it, we're working on it, we're doing good. I know, it's good to see you guys too. No, I wasn't doing it for like a month, or a month and a half.
How did that go?
It was good, I had press back, so I was absolutely good. I know, I love him. And I got booked so fast and got pulled with training that I didn't even say goodbye. So I had tried to be, I was supposed to have tried to be as well, but, so I went back, so I took a couple, like a little time here, they could go say goodbye and press back.
Yeah.
And yeah, so he sat me down, we talked for like 2 hours, and we were like going through life and stuff, and everything, you know, and giving advice, and it was super helpful, just to know more about him. He's amazing.
He's a great guy.
And there are people that like I'm in front of them. If I can say goodbye, I'll say goodbye. I'm not gonna go out. And he was like, oh no, I'm going to go out. But yeah, I was helping her keep the support room for that. So I was like find her, and she was like, hey, she said, you know, she was like, such a she was like, what were you doing? And she on the record, right? I was like,
Jumped at that record, too.
I don't know. Lunch. See, I got to see a couple people because I
I was like training for City Miami Police Detective. So the Dental Defense Division, so I ran like a 3-day training for them.
That's cool.
Yeah, so I was going through all like TV and we did, a simulated trial for testimony for them. So I made them the last day they came in. I got a bunch of ASAs to play victims. They got like the bare facts that they did. And then I used people that I actually had that they had to do a full interview with. Based on that interview, they got put into testimony and like we actually did one of the DV courtrooms. So I would defend another ASA state and then we had to name the judge. And I think specified, you know, for like the learning experience.
Yeah, thank you.
But so yeah.
Please be seated. Thank you. All right. All right, if the state is ready and the clerks are ready and our assistant public defender is ready.
Your Honor, if I could just announce my appearance. This is Joanne Hennessy for the City of Miami Beach for the jail arraignment calendar.
Thank you, Ms. Hennessy. And by chance, is there any way we could advance her cases on the calendar or no? Or
Your Honor, I'm monitoring just in case anything comes up, but I think the second case is one of mine, so. But thank you. Thanks,
Okay.
Judge King.
You bet. Okay, let's get started. The first case is the case of Made Aguirre. Good morning. You've been charged with a misdemeanor of the 2nd degree petty theft in violation of Florida statute 812.014. And this time taking a look at the I find probable cause set forth by virtue of the arrest affidavit. At this time, what's the state's?
Your Honor, the state would be asking for a bond of $500, given the defendant's significant priors from his prior arrests.
Thank you.
Your Honor, defense would object, given that Mr. Aguirre only has 3 prior misdemeanor convictions. And additionally, would be asking for an ROR and a place, date specific in the homeless calendar. If Your Honor did read the narrative, it was a $25 value that was stolen.
Mr. Kaufman.
Your Honor, the state would also be asking for a hold on this case, given that the defendant has 2 open cases. Sorry, Your Honor, I see 1 open case.
Under the circumstances, the bond is set at $500. And there's going to be a hold.
What are we holding? We don't usually hold this.
A hold for which case, Judge?
I apologize, I stand corrected.
No hold is necessary, Your Honor.
That was we were on, all of us were thinking of a different calendar for right now. $500 bond. In this case, stay away order is going to be entered by the court. You may not be within 500 feet of World of Smoke and Vape at 13981 South Dixie Highway, Palmetto Bay, Florida, 33176 at any time. Do you understand? Good luck to you, sir. Thank you. Next case. Case of Johnston, Doriana Marie Johnston.
Your Honor, this is Joanne Hennessy. I'm just announcing my appearance. This is the state's case at this time.
Thank you. Ms. Johnson, you've been charged with a misdemeanor of the 1st degree cannabis possession, 20 grams or less, in violation Florida statute.
Your Honor, Ms. Johnson refused.
Say again, I apologize.
Your Honor, I have a reset medical, Ms. Johnson.
Thank you. Next case will be the case of Sandrea Palmer. Ms. Palmer, you've been charged with a misdemeanor of the 1st degree trespass of property after warning, violation of 810.09 subsection 1. Count 2, criminal mischief, misdemeanor of the second degree, $200 or less, violation of Florida statute 80613. And count 3, misdemeanor of the first degree, resisting an officer without violence to his person. Looking at the arrest form, court finds probable cause for all 3 counts. State.
Your Honor, the state would be requesting a fine of $2,000. They the 500 on trespass charge, 150 on the criminal mischief charge, and the remaining to equate to 2,000 on the resisting without violence charge, given the defendant's priors.
So the last charge is $1,400.
That would be correct, Your Honor. Yes, sir.
Your Honor, we would be requesting an ROR and placed on the homeless calendar for this case.
Any objection by the state?
The state would be objective to ROR, Your Honor.
I concur. In this case, is she eligible for the TAP program, or do we do that in this case? These cases. So these will be alternate bonds. Alternate bond 500, count 1. Alternate bond count 2, 100. Alternate bond 1,400 with TAP approved.
I'm sorry, Yana, could you repeat the bonds?
Yes. Count 1, $500. Count 2, $100. Count 3, $1,400.
And Your Honor, proffer the reason for the elevated bond on the misdemeanor in the first degree for the resisting without violence. I don't believe that's the standard bond.
I overruled your objection. Thank you. But I didn't do it loud enough. Sorry. Okay, but well argued. At this time, Ms. Palmer, if you are able to obtain release, you will stay away from Motel X, located at 7000 Northwest 27th Avenue, Miami, Florida, 33147. Do you understand, please?
Yes.
Good luck to you. Thank you. Next case. Christina Thompson.
Joanne Hennessy for this via Miami Beach. This is the state's case at this time.
Thank you. Christina Thompson. Ms. Thompson, you've been charged with a misdemeanor count 1 of false name after arrest, 2, alcohol, open container possession with the intent to serve or sell on Miami Beach, Municipal Ordinance 70-87, subparagraph A, subparagraph 1. The false name after arrest, which was count 1, is Florida Statute 901.36. Court finds probable cause for counts 1 and count 2. At this time, state.
Your Honor, the state would be requesting a bond of $1,000 on count 1, given the defendant's priors, and that the first charge was an M1, and the state would be fine with the standard bond on the second charge.
I'm sorry, State, can you speak in the mic, please?
Yes, I apologize. The microphone was off. So the state is seeking a bond of $1,000 for the false name ID and a bond, standard bond of $150 for the alcoholic beverage.
Your Honor, defense would object to elevating the bond, given that the reason for bond is to make sure that an individual comes back to court, not to penalize the individual.
Your Honor, if I may, the defendant's priors are lengthy, and we would like to ensure that the defendant actually shows up to court. And this is in regard to the safety for the community, given the violent nature of many of these previous charges.
Thank you. In this case, bond is
Just one other thing, Your Honor, and I'd ask corrections. Is there a felony hold for F258832?
It's not indicated on her jail card.
there is a
I'm sorry, Ms. Hennessy, that was F-25.
It's F-25-8832.
The bond is set,
File date, yeah, sorry, go ahead.
sorry, $1,000 bond, count one, $150 bond, count two. Anything further?
Your Honor, are you placing hold on the F-25-8832?
Yes.
Thank you.
We indicate that on the document here, Madam Clerk, as misdemeanor holds.
That's a felony hold, Your Honor, F-25-8832.
Thank you. All righty. Good luck to you. Next case. Case of Stephanie Marie Lillo. Thank you.
Your
Miss-
Honor, I apologize. I don't believe we have Miss Lillo in right now.
She's a bond out.
She is a bond on, yes.
Thank you. Next case, Doya Morton. Right. We'll start with the case number B250104437. This is resisting an officer without violence in first degree misdemeanor in violation of Florida statute 843.02. Trying to leave the scene of an accident where there was property damage in violation of Florida statute 316.01. And count three, no valid license in violation of Florida statute 322.03. I find probable cause for all three counts.
Your Honor, the state would be seeking standard bond of 150 on the leaving the scene of the accident. State would be requesting standard bond of 150 for the no valid driver's license, and the state would be requesting standard bond of 500 for the resisting without violence.
Your Honor, defense would be seeking pretrial services, given that Miss Morton has a valid address and this is her first, she has no prior convictions.
So let me get this again, Mr. Kaufman. Count one, 150, count two, 150, and count three, 500.
That's correct, Your Honor, for a total of 800.
Pretrial services, yes?
Your Honor, I'm sorry, for the B-25-10437, that's 500, correct?
Yes, that is correct.
So count one is pretrial alternate 500, Your Honor?
Yes, just give me 1 second.
Yeah, I don't know that they're eligible for pretrial services.
They're what?
I don't think they're eligible for pretrial services.
Okay, and that's the question because our services representative isn't here. So at this time, no pretrial services in this regard, as I understand it. These are
Your Honor,
the
I apologize for the interruption, but given that we are not sure if she qualifies, can Your Honor give pretrial services? And if she doesn't qualify, then pretrial services can then not allow her to get out on pretrial services instead of just denying pretrial services?
Do we have the forms to be issued? Pretrial services, alternate bond granted.
That's alternate 500, alternate 150, and alternate 150?
Correct.
Only one count as a new city count? Separate.
Huh. So as to the resisting count one, we're not going to put it on this document, is what you're saying, right?
So count.
So on these, I put the,
Yes, Judge. And this one is 500, correct, Judge? This is the resisting.
no,
You need,
but wait a second.
the resisting is what you wanted to issue the 500 on. And
Correct.
I think it's 150.
Correct. Sorry for the confusion.
That's what I'm looking at.
And right here, I just. That's what they're doing. We've redone the form since I was last here.
Yeah.
Okay. There we go. Thank you.
No, that's-
Next case. Devona Lakeisha Brown. In this case,
Your Honor, on her DV case, you gave her a bond, a total bond of 1,500.
okay, here she was operating or driving with a suspended, canceled, or revoked license. Driving while license suspended or revoked. What's the offer by the state?
Yes, putting it up to $150.
Set the bond at $150. Court finds probable cause based on the ticket itself. Good luck to you. Thank you. Next case. Case of Michael Fernandez. Mr. Fernandez, please.
Your Honor, I do believe we have a write-in, Miss Guitaria Calcano.
Thank you. Why, of course. My fault.
It's not a write-in, it's just a court.
Did he got Tony?
Mm-hmm.
According to corrections, you said one thing and you wrote something else and then clarified with the clerk afterwards, but it just needs to be said on the record that you issued a $500 bond on that case.
Thank you. In the case AJWDCQE, you all weren't here yesterday, but there were several of these cases and they all had similar sounding case numbers or case letters in this case. So yes, in AJWDCQE with defendant William Frederick Lominac, whoops, I apologize. Janet, the defendant stands corrected, Janeth Norman Gattani. I issued a $500 bond yesterday. And
Thank you, Your Honor.
Somebody. You, next case, Michael or Michelle. In this case, Fernandez, is that who's standing?
Your Honor, we have two individuals that have not been called. They're both female individuals that we have here, Ms. Janet Gattoni and Ms. Guitaria Calcano.
We just addressed Ms. Gattoni. She's off calendar.
As an add-on.
We're missing Calcano.
Calpano. Anyone, do you have that over there by chance? We don't seem to have that, Madam Public Defender.
Yes, we called and had this case added on.
We're gonna look for it real quick. The lady standing next to you, Madam Public Defender, is who? What's her name?
She's Miss Calcano.
Ask her to step back. We just found the file. Thank you. Step back to the podium, Ms. Calcano. There was a bench warrant issued by Judge Linda Melendez on January 14, 2025 for failure to appear. Petty theft.
Your Honor, this is an added charge. Ms. Calcano was sentenced on F-25-851, in which her sentence expires on May 17th. And this bench warrant popped up.
So the state was part of the bench warrant that is issued in the amount that I put in front of
I'm sorry, can you speak into the mic? We can't hear you.
The state would request for the bench warrant that it be issued in the amount requested by the judge that issued the bench warrant, and the bench warrant be set aside.
Madam Public Defender.
Your Honor, we would be asked that the bench warrant be vacated. It should have been vacated when she was arrested for the felony case, and from now, January to May, she's been in 5 months for this. She can't afford a bond, so we would just ask for her to be R1.
State.
Your state just requests that it be issued in the amount requested in the bench warrant.
Your Honor, at the time of this bench warrant, Ms. Calcano was in custody.
So, Your Honor, okay, hold on. And Your Honor, given that she was in custody when this bench warrant was issued, it was not a willful failure to appear. Therefore, the bench warrant should never have been issued.
Unbeknownst to the judge who issued it. Thank you. At this time, she's going to be released on her own recognizance. Madam Clerk, do I need a separate form for that, or can I put that right in? Right down here at the bottom? Thank you. Good luck to you, ma'am. Thank you, corrections. The next case is the case of, back to, I think it's Michael Fernandez.
Your Honor, NBC
Thank you.
reset for tomorrow.
Done. Thank you. NBC reset tomorrow, 5/19. Next case, Joseph Lawrence White.
Your Honor, these are added charges for Mr. White. He's NBC also reset for tomorrow.
Thank you. Done. Whoops, I need to initial. I may not have initialed that last NBC if I didn't. How about the case of Michael Jufre, Jufre?
He also has a hold for immigration.
I thought we had him yesterday, did we not? I have on the back reset Sunday. Oh, that's today. There he is.
Yes, he refused on yesterday, Your Honor.
Okay. Mr. Jufre, you've been charged with a misdemeanor of the second degree petty theft.
Your Honor, I apologize for the interruption. Mr. Jufre does require the services of a Spanish interpreter.
I'm connected, Your Honor.
Thank you. At this time, you've been charged with a misdemeanor of the second degree petty theft, violating Florida Statute 812.014.
Muy buenos días, señor Jufre. A usted se le imputa un delito menor de segundo grado, que es hurto de menor cuantía, quebrantando así el Estatuto de la Florida 82.01.4.
That was count one. Count two is misdemeanor of the first degree, resisting an officer without violence to his person, violation of 843.02.
Y el segundo cargo que se le imputa es un delito menor de primer grado, que es poner resistencia al arresto sin violencia corporal en contra del agente policial, quebrantando así el Estatuto 843.02.
Court finds probable cause in this case for both counts.
Este tribunal encuentra causa probable para ambos cargos.
State.
Your Honor, the state would be seeking a bond of $2,000. We would be seeking $1,500 on the petty theft charge, and then the standard bond of $500 on the resisting without violence. The defendant has 3 pages of priors. Those include many theft charges as well as many violent charges, and he has spent significant time in prison.
Your Honor, defense would object to an elevated bond. He is charged with a misdemeanor in the second degree for petty theft, so $1,500 bond is not suitable for that. We would instead ask the court to give him a dollar bond, given that he does have an ICE hold and is likely to be taken into immigration custody.
Lo que está solicitando la fiscalía es una fianza mayor, superior, $2,000 en total, $1,500 por el cargo de hurto de menor cuantía y $500 por no poner resistencia al arresto sin violencia. Usted tiene 3 páginas de antecedentes penales que incluyen robos y delitos violentos. Así que la defensa se opone a esta fianza, es un hurto menor, así que $1 de fianza sería bien para usted, ya que tiene una retención migratoria y es muy probable que termine bajo la custodia de inmigración.
The request from the public defender is denied. The bond set at $1,500. Count one, count two, $500, and he is on an immigration hold. Good luck to you, sir. Thank you. Next case, Mario Luis Savon.
Este tribunal se opone a la solicitud de la defensa, así que fianza cargo 1, $1,500, fianza cargo 2, $500, más la retención migratoria. Buen día.
Yesterday, he was NBC for medical reasons.
Your Honor, reset for tomorrow medical.
Done. Thank you. In this case, the next case would be Michael Stephen Almodovar.
Your Honor, can we
Refuse.
pause, please?
Didn't hear that, please. Say again.
I'm sorry, Your Honor, he refused court.
Reset tomorrow.
Yes, Your Honor.
And Your Honor, Mr. Squartino is currently in the bathroom, so if we can briefly pass him.
We'll pass him. This is Scortino, so let's leave that there. I had two for Mr. Almodovar. I had case ending in 10422 and case ending in 10421.
That's correct.
So refused, reset 519. There we go. Next case, Stephen Randall Walden. Mr. Walden, good morning. You've been charged with a violation of trespass to property after warning, and this arises to a misdemeanor of the first degree, violation of Florida Statute 810.09 subsection 1. Taking a look at the arrest form. Prior stay away orders issued. In this case, that was the basis of the violation, probable cause found.
Your Honor, the state would be seeking a bond of $1,000, given the defendant has had previous trespassing arrests, and as you stated, the violation of the stay away order was the basis of this arrest.
Defense would object and would be asking for a standard bond.
Standard bond would be what, Madam Public Defender, in this case?
It would be $500.
$500.
Granted, $500. Probable cause found. And good luck to you, sir. Thank you. Let me ask the clerk real quick. Can you answer it at the bottom like that? Is that okay? So I don't make a mess of everything else. Thank you. Next case, Peter Louis.
Oh, Your Honor, Mr. Squartino is back from the bathroom.
All right. Take his case, and then this is Mr. Scortino.
Yes, Your Honor.
He's been charged with trespass after warning in violation of Florida Statute 810.09. This is a misdemeanor of the first degree. This occurred allegedly at the Miami International Airport. He's under current trespass. Court finds probable cause. State, Mr. Kaufman.
The state would be requesting a bond of $1,000, given the defendant's lengthy priors.
Defense would object and would be asking for an ROR and a homeless calendar day, given that Mr. Squartino's, the majority of his priors are what can be categorized as homeless priors. They're just petty thefts and trespass after warnings, the majority of his convictions.
Denied. $1,000 bond. Good luck to you, sir. You have, excuse me. You must not at any time return to the location where you were arrested at Miami International Airport, 4200 Northwest 21st Street, Miami, Florida, 33122, and stay at least 500 feet away from there until further order of this court. Do you understand? Does he understand, Madam Interpreter?
Sure. I have.
Madam Public Defender? In this case, Madam Public Defender, I see you haven't turned the volume on. If he's discussing his case, I would admonish him, please, not to discuss the facts of the case at this time until he has an opportunity to talk to his attorney. Ms. Public Defender, can you please interpret quickly? Not interpret, but give us status. Thank you.
Infringing on my constitutional rights.
Right. Thank you. Corrections, he can be removed at this time. Under the circumstances, I think he's dominating the calendar, and I've reviewed carefully his arrest form. I don't believe that either the state of Florida, the Miami-Dade Police Department, or this court have violated his constitutional rights at this juncture to the degree that I believe he's been afforded due process throughout. Next case, Peter Pakwan Luing. Mr. Luing, you've been charged with 2 separate incidences. I'll take the first case, which is M250-10429, misdemeanor of the second degree, boating under the influence in violation of Florida Statute 327.35 subsection 1. Taking a look at the arrest form. Court finds probable cause based on the field sobriety narrative, which constitutes 3 pages, as well the identification initially of the individual being under the influence at the time. Under the circumstances, what is the state's offer with respect to Mr. Luig's first case?
On the case ending in 429, the state seeks the standard bond $500.
Defense would request pretrial services, given that Mr. Luong has no convictions and he has a proper address where he can stay at.
Again, any objection by the state?
State simply objects, although it is correct that the defendant does not have local priors.
This is an alternate bond set at $500. Pretrial services granted. Good luck to you, sir.
Your Honor, I'm sorry, what's the bond? You have 2 different cases?
We have 2 different cases. So in case number 429, 500 alternate bond with pretrial services afforded, granted by the court. With respect to case number 428, that would be M25010-428. He's charged with unlawful use of city-owned property abutting water. It's a municipal ordinance in violation of Florida City Miami Municipal Ordinance 50157. And in this case, I find probable cause as well.
And in the case ending in 428, state would be seeking a bond of $150.
$150 pretrial services. Any objection by the public defender?
No, Your Honor.
Good luck to you, sir. Thank you. Madam Clerk, I'll need those 2 forms. They're right here. Next case will be the case of Craig Thurston. Mr. Thurston, you've been charged with a misdemeanor of the first degree, resisting an officer without violence in violation of Florida Statute 843.02. Checking the arrest form. Probable cause found. State?
Your Honor, the state would be requesting standard bond of $500.
Your Honor, defense would ask for pretrial services, given that Mr. Thurston does have a valid address. He stays with his child's mother.
Your Honor, the state would object given the defendant's lengthy priors.
Under the circumstances, standard bond, $500. No pretrial services.
Would Your Honor be inclined to give house arrest roaming?
Was pretrial was not here to fill out house arrest form.
Right, those forms are not available at this juncture. Maybe that's something that needs to be potentially corrected in the future, but we can't actually do that at this juncture. He may ask the division judge for such relief if he wishes. In this case, probable cause $500 bond. Good luck to you, sir. Thank you. Next case, Charles Edward Williams. Mr. Williams. Is this Mr. Williams?
Mr. Williams is coming, Your Honor.
Thank you. Mr. Williams. He failed to appear in a bench warrant was issued on a petty theft charge. He's violated, allegedly, a misdemeanor of first degree petty theft between $100 and $750 in violation of Florida statute 812.014. And then again, count 2 was the bench warrant. State?
Your Honor, the state would be seeking a bond of $2,000 in the petty theft charge ending in 296. And that is due to the defendant's significant priors, Your Honor.
I find probable cause based on the arrest warrant. Arrest affidavit, excuse me. Anything from the public defender?
Your Honor, we would ask for a tap on this case. Mr. Williams currently does not have an address to stay at, and given that he only has he only has 5 convictions. It's not a lengthy record. We believe that tap is warranted in this case.
The state objects, Your Honor, and the significance was not due to the number.
In this case, TAP is basically set up for folks that are homeless. If I were to enter that on the document, Madam Clerk, should I use this form here or the front?
Right, the judge.
It's a $1,000 bond, but alternate to the degree that TAP would be able to assist him. Good luck to you on that case. Now, let me give you that case number, by the way, Madam Public Defender. That's B25001296. He has a second case. This case is B25010441. Petty theft, again with the same charge in violation of Florida statute 812.014. And again, another bench warrant.
No, it doesn't.
That's the same case?
That's different. That's a brand new case.
Your Honor, the bench warrant, that was on the case of 296 and 441. There's no open bench warrant at the moment.
Okay. So we have take a look very quickly. This happened allegedly at Home Depot at 12055 Biscayne Boulevard. Probable cause found. State.
The state would be seeking a bond of $1,000 on the case ending in 441, and that is due to the defendant's priors and his potential harm to the community.
Defense would ask the court to match what the court gave on the case ending in 296.
Alternate bond set at 1,000. TAP program approved. Good luck to you, Mr. Williams. Next case, the case of Jose Diaz Gonzalez.
Your Honor, I'm sorry for Mr. Williams. That was tap alternate 1,000 on both cases.
Yes, thank you.
Thank you.
In this case, Mr. Gonzalez, you've been charged with a misdemeanor of the first degree, trespass of property after warning in violation of Florida Statute 810.09, subparagraph 1. Court has reviewed the arrest form and finds probable cause. State.
State is seeking standard bond of $500.
Defense would ask for pretrial services, given that Mr. Diaz-Gonzalez does have an address to reside at and he has no prior convictions.
Objection.
No objection, Your Honor.
Alternate bond, 500. Pretrial services granted. Good luck to you, sir. Next case be the case of George Raul Garcia Perez. Thank you.
Your Honor, Mr. Garcia Perez bonded out.
Yes, thank you. If any of these, Mr. Kaufman, warrants a stay away order in any reasonable means. One of our fellows was the one educating all of us on constitutional violations. Stay away order might have been warranted in that case. I don't know if that's a standard for you all, but I'll leave it to your discretion as
Your
well.
Honor, Mr. Garcia Perez bonded out. Also, Mr. Rivas Rodriguez bonded out.
Thank you. That's also for Mr. Leoza. If at any time stay away order, I know you're not going to suggest it per se, but if they do, you have full, robust opportunity to respond thereto accordingly, all right?
Yes, Your Honor. Why would I do that?
Next case would be the case of Carter, Christopher Carter. Mr. Carter, you've been charged with count 1, petty theft in violation of Florida Statute 812.014, and that is a misdemeanor of the first degree, and count 2, misdemeanor of the first degree, resisting an officer without violence in violation of Florida Statute 843.02. Date?
The state would be requesting standard bond, $500.
As to both counts?
Well, it would be $500 for the resisting without violence charge and $500 for the petty theft charge for a total of $1,000, Your Honor.
Your Honor, the defense would be asking for an ROR and a date certain at the homeless calendar, given that Mr. Carter does not have any prior convictions, and these are 2 misdemeanor charges.
Your Honor, the state would be open to tap with a bond of $500 on each charge, but not ROR.
TAP program approved as to both charges. Count 1, alternate bond, 500. Count 2, alternate bond, 500. And in this case, if you're eligible and were to make bond, Mr. Carter, you will, until further order of this court, stay away from the Target store located at 21265 Biscayne Boulevard, Aventura, Florida, 33180. Do you understand, sir? Yes, sir?
Yes, sir.
Thank you. Next case, Samuel Nava. He was a bond out.
Your Honor, I was just asked if we could call Mr. Londano out of turn.
We'll take a look for the file. Give me just a second. Yes, I have the case here. Jaime Londano is presented before the court in the first case that we have is case M250-10247. And he's charged with criminal mischief, more than 200, less than 1,000, which is a misdemeanor of the first degree. Misdemeanor of the second degree, count 2, assault, violation of 784.011, and count 3, reckless driving or damage to property or person in violation of Florida Statute 316-192, subparagraph 3. Taking a look at the arrest form. Give me 1 second. Court finds probable cause for all 3 counts. State.
Your Honor, first and foremost, the state requests a hold on this case due to the open felony. Additionally, the state would be requesting standard bond of $500 in the reckless driving damage charge, bond of $500 in the criminal mischief charge, and a bond of $500 in the assault charge, for a total of $1,500.
Your Honor, defense would be requesting, well, first of all, we would make a probable cause argument to the assault charge on this case, given that no threats were made to the individuals. Everything that's alleged is that Mr. Londono allegedly hit the hood of the vehicle and then slammed his head onto the windshield to break it, which is the basis for the crim miss. But we have no threats made to the individuals. Additionally, Mr. Londono has no prior conviction, so we would be asking the court to give him pretrial services, given that he has a permanent address where he can reside.
Your Honor, the violent nature of the actions that resulted in criminal mischief can also amount to assault prior to the damage then equating to criminal mischief. So that is not mutually exclusive for the actions of the incident to include both the assault and the mischief.
The request by the public defender is denied. He's getting count 1 $500 bond, count 2 $500, count 3 $500. The traffic is separate.
For the records.
Yeah, so it's on this other document. Okay. So criminal mischief is 500. And the assault is 500, correct? Count 1 and 2?
But are you 550 for the assault?
I apologize. Did I miss?
The state requested an elevated bond of $500 for the assault charge. That is correct.
It's 500. And then as to the reckless driving damage to the person or property, I'll set that on a separate form, but it's still remaining 500.
And Your Honor, I would like to know for the record, is the felony hold also in place in this case?
Yes.
Of course. The felony case number is F256168.
It's in Division 18.
Good luck to you, sir. Thank you. Do I need to notate that on the stuff?
Yes, Judge.
Where would you like me?
On board. Excuse me, Mr. Manager.
I don't have. I
What
put
is the traffic?
that took care of that, I think.
Write it in there. Should 500, and then if you could just write it down there. Yes, Judge. 25, 2160.
He's by 2168. Last but not least, Madam, well, we let him go away. They wanted stay away orders from the individuals involved. Could we call him back briefly if he's not gone too far?
They're bringing him back, Judge.
Thank you. Sorry. Mr. London, one last thing. You're to stay away at all times within no greater than 500 feet. You must not be within 500 feet of the victims in this case. Their initials are JR and RR. Good luck to you, sir. You understand?
Yes, sir, I understand. Thank you.
Next case, Damian Lanos Rizzo. Good afternoon, Mr. Rizzo, almost afternoon. This case, he was picked up on a bench warrant issued by Judge Corselli. He was originally charged with trespass of an unoccupied structure or conveyance in violation of Florida Statute 810.080. That. I'm taking a look at the arrest form. Probable cause found.
Your Honor, the state would be seeking a bond of $300 in this case. The defendant has fairly lengthy priors, and he bench warranted.
At this time, bond set at $300.
Your Honor, we were asking for an ROR and set in the homeless calendar, given this is a trespass misdemeanor in the second degree, and Mr. Leno's priors, they're all misdemeanor priors. His
Your Honor,
convictions, that is,
the
which is what is to be taken into consideration when given bond.
Alternate bond 300. I think Mr. Kaufman just indicated the state would accept the TAP program, which I'm approving for him. Good luck to you, sir. Next case. Case of Grant Moldine. Maudlin, excuse me. Mr. Maudlin, you've been charged with trespass to property after warning in violation of Florida Statute 810.09, subparagraph 1. This is a first-degree misdemeanor. Previous warnings to not visit or be in and around or inside the Walmart at 8651 Northwest 13th Terrace, Doral, Florida. I find probable cause. State.
The state is seeking a bond of $1,000. The defendant currently has an open trespass charge as well as prior charge.
Probable cause, yes. Bond set at $1,000.
Your Honor, we would be asking for TAP, given that Mr. Maudlin has no prior convictions and he is currently homeless.
Kaufman.
No objection, Your Honor.
Converted to an alternate bond
Your Honor, that was tap alternate 1,000.
Yes. Good luck to you, sir. Oh, Mr. Modlin, before you leave, you'll stay away at all times from the Walmart located at 8651 Northwest 13th Terrace, Doral, Florida 33126, until further order of this court. Do you understand?
Yes.
Thank you. Next case, Henry Ruland. He was subject of a bench warrant issued previous, very keeps failing to appear. That's why he keeps getting his bench warrant. So for case B 24-655, charged with petty theft in violation of Florida Statute 812.014 at Walmart, 3200 Northwest 79th, alleged. Probable cause found. What would the state like to do?
The state would like to impose a bond of $10,000, give that the defendant bench warranted. And I think that is the current bond set in place. And then in the case ending in 463, if probable cause is found, the state would be requesting a bond of $300 to make the total $13,000.
Defense would object, given that Mr. Roland cannot afford that much money in bond, and $10,000 for a misdemeanor is, excuse my language, ridiculous.
The current $10,000 bond, if I'm not mistaken, is due to the continuous bench warrants.
No doubt, Mr. Kaufman, no doubt. Miss Loiza, in this case, the bond will be set at $5,000, not $10,000, because Mr. Kaufman is correct. He refuses to come to court. Second, and more importantly, you mentioned the case, Mr. Kaufman. I don't know if you meant to say case number 10463. That's the new case, correct, Madam Clerk?
Yes.
If that's what you're referring to, that's petty theft as well. And at this point, it looks like a different location completely, but it is a Walmart. So as to case number B24-655, the bond is set at $5,000. And we're setting that today. So let me write the date down. As to the other case, let me take a moment to look at the arrest form. Concealing merchandise in his pants, walks intentionally past all points of sale. At this time, probable cause found.
And in that case, the state's requesting a bond of $300.
$300 bond is set at this time. Good luck to you, sir. Oh, by the way, before you run away, Mr. Rowland, you may not return at any time whatsoever to 3200 Northwest 79th Street.
One moment, Your Honor, he's coming back.
Sorry. Mr. Rowland, you may not return at any time to 3200 Northwest 79th Street, Miami, Florida, which is the Walmart that you were arrested in. Do we understand? I think he said yes. Good luck, sir.
Yes.
Next case, Matthew Robert Miller. I have just the one. I have case number 25-10466.
She has.
No. have this one. Oh, it was. Gosh, you are right. Thank you. Yes, I have the other one, 10467. The first charge, 10466, count 1, misdemeanor of the first degree petty theft in violation of Florida Statute 812.014 subsection 2. Let's take a look at that. Probable cause found.
The state is requesting standard bond $500.
Defense would request that Mr. Miller be released on his own recognizance and given a date certain in the homeless calendar, given that he currently does not have housing and he has no prior convictions.
The state objects to the ROR. However, given the other open petty theft case, the state would be potentially inclined to tap if the bond on both charges would be $500. And when I say both, we have the current case ending in 6-6 as well as his case ending in 6-7.
And I understand the state's objection, but it is in the court's discretion, given that we do have a specific courtroom for homeless individuals that cannot afford bond, and it would give them a better alternative to sitting in jail and waiting for TAP to find them housing.
He's got 2 charges, and I haven't gotten to the second just yet, but for this one, it's an alternate bond, $500, TAP program approved, probable cause found. If he is to also, Mr. Miller, you may not at any time be back to the target location at 249 Northwest 6th Street, Miami, Florida. You must stay away from that store at least 500 feet until further order of this court. Do you understand?
Yes, sir.
The second charge is petty theft, misdemeanor of second degree, Florida statute violation alleged 812.014 subparagraph 2. In this case, probable cause found.
And Your Honor, the state would be seeking the same $500 bond in this case.
In this case, the court finds reasonable grounds for entry of the bond in this case, but it will be, again, alternate bond, $500, TAP program approved.
Your Honor, both cases TAP alternate 500.
Correct. Thank you. Good luck to you, sir. Next case, James Walter Weyes.
Hi, this is Joanne Hennessy for the City of Miami Beach, Your Honor.
Thank you. Mr. Weyes, Judge King, welcome. At this time, you've been charged with a municipal ordinance violation of City of Miami Beach, camping prohibited. In this case, the area of Lincoln Road and the boardwalk after receiving a report from park rangers regarding a male who was sleeping in the area. They'd been receiving ongoing issues throughout the day. This time, the court finds probable cause. Anything requested by the City of Miami Beach, Counselor?
Your Honor, we would just ask for the standard.
Standard bond,
Defense would ask for TAP.
250, would that be acceptable? Or standard bond for, yes, I know, she's right there. We're having trouble
Standard
hearing.
bond is 150, Your Honor.
150, thank you. Standard bond, TAP, any objection to the TAP program
Sorry.
by the City of Miami Beach? Thank you. TAP approved, alternate bond 150. We also would admonish, in this case, don't let him run away. Mr. Wayas, you're not to be on Lincoln Road, boardwalk in Miami Beach, asleep on a park bench. Do you understand? And
Yes.
that's why you're here and alleged. TAP program approved. See if we can't get you some help. Good luck, sir.
Your Honor, I'm sorry, what was the alternate bond?
$150.
Thank you.
Next case, Adonis Ramirez.
He's a bond out, Your Honor.
This next case up.
Yes.
Thank you.
We should be on three hits.
So the case of Juan Reyes.
That's where we are now.
Okay, this one is a bond out. I only put bond out on one of the two.
That's fine, Judge.
I mean, in other words, I thought you said we had two cases that were bond out.
I pulled the other one out.
Thank you. Yes, Juan Alberto Reyes Ferrales. He's back this time.
Your Honor, we have Mr. Leyva here. We asked that he be taken out of turn. This is the individual that has.
I remember.
Yes. He should be, I believe, the last one on your calendar.
Your Honor, Mr. Labor Martel also has an open felony. He'll be back on your bond hearing calendar. He's on probation on F18-24332 and also F21-2062.
Thank you. All right. As the case AIY06SE, he's been charged with.
Judge, I apologize. There's no tickets for these cases, but if you look on the 8 form, I'll tell you.
This one had one ticket, but I'll look at the 8 form as well. Court finds. So these tickets were all issued arising from the one incident, correct?
Correct.
Okay, the court has the 8 form count 1, reckless driving, damage to property or person in violation of 316-192 subsection 3, count 2, no valid license, Florida statute 322.03, leaving the scene of an accident with property damage, violation of Florida statute 316.06, failed to surrender his license after it was suspended in violation of Florida statute 324.201. Count 5, driving while license suspended knowingly, violation of 322.34. And count 6, driving while license suspended, financially suspended. It says SBSE violation, Florida statute 322.34. I did have a chance to read the 8 form. The court finds probable cause as to the arrest and to the 6 charges.
Your Honor, on the first reckless driving charge, the state is seeking the standard bond of $500. On the driving while license suspended, the enhanced one, which is the statute subsection 10B2, the state is seeking standard bond of $500. For the driving.
I'm sorry, can we call the case numbers out, please?
Yeah, we're gonna have to do that for everybody. So on AL 9XJOE bond $500 is what the state's requesting.
Correct.
On AL9XJQE,
The state is seeking a bond of $500, given that it was leaving the scene of an accident with property damage.
in
And
case number AL9YAFE,
the state is seeking the standard bond of $150.
with respect to case number ALDBXE,
The state is seeking the standard bond of $500.
ALDDBWE,
State is seeking standard bond of $150.
and lastly, AL9XJPE,
State is seeking standard bond of $150.
court finds probable cause and enters the bonds accordingly. At this time, this one ticket was standing alone. Yes, that one is. Yes, I'm sorry. Thank you. More than one. This time, I'm entering the bonds accordingly. Good luck to you, sir. He's being held until we see him at the felony calendar in a few minutes, right?
Thank you, Your Honor.
Your Honor, this is Joanne Hennessy for the city of Miami Beach. I believe the rest of the calendar is the traffic calendar. And if so, could I be excused?
You may. Thank you for assisting us. Good to see you again.
Thank you. You too as well. Thank
Okay. Right. I started to sign at the wrong place. So this one,
That one's next, because they had us pull something.
yes, this one would be next. It would be Juan Alberto Reyes Ferralis.
And Your Honor, Mr. Reyes does require the services of the Spanish interpreter.
Thank you. Madam Interpreter.
Yes, Your
Correct.
Honor.
Thank you. We have ticket AL9DXCE. He's been charged with driving under the influence in violation of Florida Statute 316.193. He also has a secondary ticket, AL9DVZE, charged with no valid driver's license in violation of Florida Statute 322.03.
Usted tiene un ticket y es por manejar bajo los efectos en quebrantamiento del estatuto 316.193 y un segundo ticket que lo acompaña que es por manejar sin una licencia de conducir vigente en quebrantamiento del estatuto 322.03.
Court's had a chance to review the arrest form and the field sobriety test results that were conducted and finds probable cause.
Este tribunal ha revisado el atestado de día de arresto y también el resultado equívoco o el resultado en el que no pasa la prueba de sobriedad y se encuentra causa probable.
State.
With respect to the citation number ending in ZE, the state is requesting a bond of $300, and that's for the no valid driver's license charge. And in the case ending in CE, which is the DUI, the state is seeking standard bond of $1,000.
La fiscalía pide por el delito de manejar sin una licencia de conducir vigente $300 de fianza y por el delito de manejar bajo los efectos $1,000 de fianza.
Defense would be seeking pretrial services on this case, given that Mr. Reyes Ferrales does have a permanent residence where he can stay at. Additionally, he did blow under the legal limit for alcohol.
La defensa pide el programa PTS, ya que el señor Reyes tiene una residencia permanente acá en el condado. Además de eso, el resultado de alcoholemia dio menos del establecido.
Your Honor, individuals can be driving under the influence other than alcohol, can be from other substances. And the state is still seeking the standard bond for the DUI charge.
In this case, $1,000, correct?
That is correct, Your Honor.
I'm going to make it an alternate bond of $1,000, pretrial services. And I didn't see any notation of any additional suspected substances at the time in the A form. That is the basis of my decision there. So I am granting Ms. Loisa's request. At this time, give me 1 second. Thank you. You're free to go, sir. Next case. Free to go.
I'm sorry, what was the bond on the no valid?
It was 1 second. The no valid was 150 alternate bond pretrial services.
Thank you.
Muy bien.
And Your Honor, Mr. Reyes does need the translation.
Yes, thank you. Señor Reyes, usted va a salir bajo la supervisión del programa Pretrial Services o de lo contrario, usted va a tener que pagar una fianza por manejar sin una licencia de conducir vigente de $300 y una fianza de $1,000 por manejar bajo los efectos.
Good luck to you, sir.
Buena suerte, señor.
Next case will be the case of George Velez. He's.
You don't have a judge.
Thank you.
Your Honor, also Mr. Meneses Velez, he has a fugitive warrant from Brevard County, total bond $10,000.
Thank you.
And Your Honor, Mr. Mendez Velez does require the services of Spanish interpreter.
Thank you.
El agente penitenciario le acaba de dejar saber a su señoría que usted también tiene una orden de captura y arresto del condado de Brevard y la fianza de esa orden es de $10,000.
All right. Under the case number AEFV 89E, he's been charged with driving while license knowingly in violation revoked and having no license with him at the time. Under the circumstances, the state's seeking what type of bond?
The state is seeking a bond of $500, given that that is the standard bond for DWS knowingly. Or at least that was based off of the warrant issued in that previous case.
This case also, the next case is case number Madam Interpreter. Let's let the interpreter do her thing there.
Muy bien, en el primer cargo a usted se le imputa manejar con una licencia de conducir revocada a sabiendas y en el momento en el que se le detuvo usted no tenía una licencia de conducir. La fiscalía solicita la fianza estándar para este tipo de delitos que es de $500.
All right. The next ticket was I don't?
Y'all only have one case for him.
That's right. She was just reminding me the second one's an infraction, no display of tag. All right. So at this time, the bond.
Your Honor, I apologize. Defense would be asking for pretrial services so that if Mr. Meneses Velez can pay the Brevard County warrant amount, he can be released on this case.
Your Honor, the state would be objecting simply because he has a $10,000 warrant from another jurisdiction.
And Your Honor, Mr. Menendez did turn himself in for this bench warrant. So I don't believe that he's attempting to flee.
Well argued by both sides. Request by the public defender denied. At this time, the next case, good luck to you, sir. Wesley?
The bond is a straight bond of 500, Your Honor.
That's right.
Thank you.
Floridor Wesley or Wesley Floridor? Anyone present for this case? Let's see. There he is. Thank you. From the arrest form is driving while license suspended knowingly in violation of Florida statute 322.34. State. Let's take a look. 1 second. Give me a second. Probable cause found. No, this is Wesley Floridor.
Your Honor, the state would be requesting a bond of $500. The defendant has significant priors, including threatening law enforcement officers that he was convicted, or that he at least took the withhold of adjudication, as well as many other arrests.
Bond set at $500. Good luck to you, sir.
Your Honor, if defense could argue, we would be arguing for pretrial services, given that Mr. Floridor does have a valid address where he can stay at. And if I heard the state correctly, Mr. Floridor took a withhold of adjudication, which is not a conviction, and he cannot take into consideration priors.
Your Honor, we can take into consideration prior arrests when judging whether or not an individual is a potential threat to the community. And given the violent nature of that arrest and the fact that the defendant did not beat the charge, for lack of better words, this should still be taken into the court's consideration.
I have considered an alternate bond set $500 pretrial services. If he's eligible, he may be eligible for release. If he's not, you'll have to post the $500 bond. Good luck to you, sir. Next case, Alexander Reeves Lavon. Mr. Lavon charged with no valid license or driver's license revoked in violation of 322.03 Florida statute. Taking a look at the form. His license was allegedly revoked on July 7th, 2008. In this case, probable cause found.
Your Honor, the state would be requesting a bond of $500 in this case. The defendant has lengthy priors that include violence. We have multiple robberies, fleeing and eluding, grand theft. I can keep going, but the list of priors is multiple pages.
And if the state can verify which of those are convictions, public defender does not have those priors.
There are too many convictions for me to verify each of them, but I can give you F006755, 6754B, 6751B, 6752. These are all F00s. And like I said, the list of priors is multiple pages long.
And Your Honor, Mr. Reeves does have a permanent address where he can live at. We would be requesting pretrial services, given that the prior convictions that the state just read out are from 2000, approximately 25 years ago.
Your Honor, the most recent conviction was in 2024, and that was for petty theft, and that is case B2424856.
And before that?
before his 2024 conviction. His last arrest was in 2020, and his last conviction was in 2017 for a trespass after warning, and that's B17-11007.
Alternate bond set at $500. Pretrial services approved. Next case. This would be the case of Martino de Jesus Monta.
Is Mr. Meza bond out? Thank you.
Mr. Mays is a bond out, Mr. Mota is a bond out. Also, Mr. Gonzalez Vasquez is a bond out.
All right, as to Martino de Jesus Monta, ticket A1A75EP.
Your Honor, if I'm not mistaken, I have that listed as a bond out for Mr. Mota. Okay.
That's what they just advised you, so. As to Maurice Williams, Jaquan, Maurice.
Your Honor, on his DB case, you gave him a bond of 2,000.
And he bonded out.
He's before you, Your Honor.
I stand corrected. Of course, how could I forget? There he is. My fault. You were charged in this matter with no valid driver's license. This is ticket AIM8FOE. There was a second ticket, AIM8FLE, which charges improper tint at the top of the windshield. AIM8FTE, failed to change address within 10 days, violation of, let's see. I'll look for that momentarily. And lastly, ACI706E, driver not carrying or exhibit a license upon demand.
Yeah. Judge, who are you on?
This would be Mr. Joaquin State.
Your Honor, the state is seeking a bond of $1,000 on the case ending in FOE. The defendant had a bench warrant in that case, so the state is requesting an elevated bond.
Judge, I apologize. These are all of his cases. All of those belong to him.
This is Roberto Leyva here.
Not him.
No, this is Monta. See who I'm looking at? I apologize. This is this fellow. And that's who's standing in front of me.
What happened to Monta?
We already dealt with him. He was a bond out, if I'm not mistaken. That's why I put it up there. Here we go. And maybe I didn't put it in the right place. So back to Mr. Kaufman with Mr. Joaquin Williams.
So for Mr. Williams, he had a bench warrant on the case ending in FOE, so the state is requesting an elevated bond of $1,000.
And Your Honor, just to verify, this is for Mr. Jaquan Maurice Williams?
Correct.
Got it. Defense would be asking for the standard bond of $500, given that was the bench warrant amount.
Denied, 1,000. Probable cause found on all of these tickets. Next ticket is the one that's 8FLE.
Your Honor, per my notes, we only have one citation, criminal citation for Mr. Williams.
True. The improper tint is an infraction. You're correct. Changed address infraction and not carried DL on demand.
Those are also infractions, Your Honor. Yes, sir.
So we're going to stand with just the one that I issued, the $1,000 bond in case AIM8FOE. Good luck to you, sir. Thank you. These are all my misdemeanors, right? I said that, felony. Anything else we can assist our misdemeanor calendar with?
Did they say labor was on?
Did they say,
Your Honor, we are, Mr. Roberto Leyva, reset for tomorrow, warning.
thank you.
Thank you.
Thank you, Cece.
Welcome.
I want to thank our clerks and corrections and our interpreters and the City of Miami Beach attorney and our state's attorneys, and of course, Miss Loiza over there handling all this by herself, along with at least Kaufman had backup today and vice versa. We'll,
Thank you, Judge. Pleasure being in front of you.
yes, all of you. We're going to have about a 15-minute recess at this time because we've been at this since just before 9 a.m. this morning. And so we'll see you back about 1:45, if that's okay for everyone. By the way, Madam Clerk, we have approximately how many, if you know? That's okay.
That is like.
It's okay. You'll just scare me. Don't worry.
All right.
Oh, boy. We had a bunch that were brought in from Metro West. I think that we had to set, remember, we had to set them yesterday. Thank you very much. We'll be right back in a few minutes. Thank you. I said 15, yes. Thank you.
Yes.
All right, how can I be helpful?
We're gonna follow it. Wait. All right.
How about where?
So I can have all the stuff.
Where? Like roughly 18.
I should I put these over and have these sorted elsewhere?
Yeah, go, go.
All right.
Just stagger them from the other one. So like if there's one hold on to the
Not roll.
Okay. Okay, they're going good, okay?
No, I understand what vertical horizontal, I don't understand what is what right now in here.
Okay,
Should
yeah, just
drop
put
it.
it the other way from that at the bottom.
Okay.
So you can separate them.
Yeah. Here's what we got, number one, that's our line. Down one, down one.
Exactly, you want.
Okay.
Bill,
Where you going?
It's or you can always cafe, so we can reach the closest one.
Yeah.
All right. Well, check right place.
Okay.
Decaf larger copies. All right.
Yeah.
Do you have a preference between the two?
No, well, I would have probably a snack. I just want to in the.
Not necessary.
Yeah.
Understood.
Oh, Ashley, and Ashley. Oh, there he is. 3 Ashleys.
Yeah, I always put that for
Always does in the other. I put the other one there, right?
Thank you. This one popped off. Well, and then I'm just.
Give him leave. That.
Yeah. Right on the.
Ashley, can I see you later?
Bye, Cece.
Ready? Yeah, there you go.
Never started from court, right? Yeah, there we go. Yeah, came all the way to the end, so I was trying to find them, I was like, come here, how should I get here?
Yeah, we got big on stuff.
If I was gonna say whatever, somebody has to leave before I'm out, and I was like, sorry.
Yes. If they're already filled out, I'll just take that. Okay, for me, start just. Yeah.
Good morning, State. Madam Clerk?
Council, we're having a 15-minute recess.
Okay. Thank you.
Like sometimes it is the one. So I'm. You can.
Is it, can you see me? All right, here we go. So here's where we're gonna start. Almost no stay reorders after this one, which is so funny.
Yeah, it's all about everybody team.
Yeah, so here's the, okay, let me try and make this upside down. Here's the back, here's the front that we're actually starting with. Okay, thank you. Yep.
Good morning, everybody. Would it be possible to send an arrest affidavit on Auguste Clemente?
Hi, council. It's I can, let me see if I can pull it up.
Thank you.
I know that I have the A form that was dropped for it.
Say again?
I know that I have the A form that was dropped for it.
Yeah, I think he came yesterday and I didn't get notice of it.
Will you be making an appearance on all of his cases in the probation violation? This is ASA.
Yeah.
I'm actually handling these matters in division.
Oh, yeah, absolutely. I will. I already filed my appearance.
Okay. Just to know, so then I can start going on that. Were you aware that he was held no bond on the probation matter?
Yes. Yeah, we had an appearance. We had a hearing on Friday.
Yes, just confirming.
And then I guess they dropped an A form for the new case.
Yes. Actually, what I will do is I'm sending you the email right now with the A form for the new case that's on for today.
Thank
I
you.
will also include in there my out of office, if you want to call and talk about the matters.
Appreciate it. Madam Clerk, would you be able to call this matter out of turn?
Council, it's actually going to be the second one on,
Oh, it is? Okay.
Yes. Based on where we're starting in the stack.
Thank you. I put my email in the chat.
I have it. It's michael@mirrorlaw.com, right?
You got it. Thank you so much.
Honestly, like, especially. Is that proper cap? I have no idea, honestly, I think it's blueberry. Well, it is. No, this was thinking there, it's definitely a blueberry. All right. There you go. I think we told it it's very. I apologize, it's 2 minutes. Pardon me. Just for next 5 minutes. If you don't want me to sound there. Yeah, camera. Oh, thank you. Thank you, board. Have a great week. Okay.
One is and this one, definitely not having that. That's an old case. I was looking at our resets and I'm like, oh, maybe. No, I don't think so. I'm the tree. Actually, you're good. Hopefully not overtime today.
I got $500 for you.
Number one. Number one, the 12.
Wait, what is the normal order?
Yes, the very first one.
Yeah. 12.
Mrs. Johnson.
Yep.
12.
More 12, 44, 46, and 48. It's 12 Smith.
12 Smith. And 40.
Thank you. Please be seated. All right. When you hear the name of the case called for the person you're here to help or assist, please let me know, okay? Okay. Okay, we're back and we're ready to, I believe, start on our following calendar. We're waiting on Mr. Kaufman, yes? Okay, thank you.
All rise and raise your right hand.
Todos pónganse de pie y levanten la mano derecha.
Do you swear affirm the testimony about to give be the truth, the whole truth, and nothing but the truth? Say I do.
Yes, ma'am. Yes.
Juran o afirman que el testimonio que van a dar es la verdad, toda la verdad y nada más que la verdad. De ser así, digan, lo juro.
Lo juro.
Thank you very much. At this time, I'm going to call one case that marked NBC. This is the case of King Jaha Gerald Clark.
He's present, Your Honor. Assistant Public Defender Claire Chatelier on his behalf.
Thank you. In this case, sir, you've been charged with a felony of the 3rd degree firearm at a school property and possession in your possession at that time in violation of Florida Statute 790-1152C. Count 2, misdemeanor of the 1st degree firearm in the possession of a minor, 790.22 subsection 3. And in this case, count 3, misdemeanor of the 2nd degree educational institution interference and disruption, case 877, or in this case statute, excuse me, 877.13 subsection 1. Take a look here.
I don't have any probable cause arguments to count 1, but to count 2, the statute with which this person has been charged requires that the firearm be present in a home. The specific statute that the officers listed that Your Honor mentioned includes that it's like an event that occurs in the home. And so I would argue on count 2 that there's no probable cause and that Mr. Clark be released outright on count 2.
State.
Yeah, per the statute, it's unlawful for a minor to possess a firearm at all. There are certain exceptions for an unloaded firearm in the home. The state would request that it just be generally under the statute 790.22 generally, rather than the specific subsection that was listed by the officers. There is probable cause as the juvenile did have a statute my apologies. The juvenile did have a firearm in their possession, and that is unlawful.
Thank you. In this case, having read the arrest form, count 1, probable cause found, count 2, probable cause found, without the subsection 3 and probable cause found as to count 3. The bond on count 1?
A bond of $2,500 for count 1, $1,000 for count 2, and $1,000 for count 3. They're standard bonds.
Your Honor, I'm reflecting in my notes that the standard bond for count 1 is 2,500, the standard bond for count 2 is 500, and the standard bond for count 3 is 150. Regardless of what the standard bonds are, I'm asking for reduced bond as Mr. Clerk is a minor and presumably does not have means of his own to post this bond. Further, no, I rest my argument there that he's a minor and we shouldn't be giving him these thousands of dollars in bond.
And you're on the state would just be requesting standard bond for each count. So $2,500 for count 1, $500 for count 2, and $150 for count 3.
The request and objection by public defender is accepted. At this time, those bonds have been set, and I think I have.
Yeah.
So Your Honor, you have to specifically say the amounts. Are you doing standard bond 2,500, 500, 150?
I thought we did. Count 1, 2,500. Count 2, 500. Count 3, 150. Yes, thank you. Next case would be the case of Augustin Clemente. Maybe see.
Judge.
Thank you.
Judge, this is an added charge.
And your private couple is on for this case, and they're just in order for this case.
He's also a valid felony offender, special concern.
Thank you. And we'll hear from Mr. Meyer. How are you, sir?
I'm doing fine, Judge. Thank you. Michael Meyer on behalf of Mr. Clemente. Judge, I have the benefit of reviewing the arrest affidavit in this case. As corrections said, this is an add-on, so I was not aware of this. I think it came up before the court yesterday. I do have a probable cause argument as to count 1, aggravated stalking. In the 4 corners of the arrest affidavit, it indicates that the alleged victim and witness saw my client parked in a parking lot. The victim then took a picture of the defendant, and then the defendant then allegedly leaves the parking lot and they travel on a road. It seems for about 10 blocks, at which point she called the police. When the court looks at the required for aggravated stalking, 784.048 subsection 4, it requires that the defendant, after an injunction has been issued, and I will stipulate that there was an injunction in this case, but there has to be a knowingly, willingly, maliciously, and repeatedly following, harassing, or cyber stalking another. So the allegations in the arrest affidavit are one incident where she alleges that my client followed her on a road. Other than that, there's nothing within the affidavit that would suggest that this was repeatedly, therefore not an aggravated stalking. I think that there is PC for the other 2 counts, though.
In this case, state?
A form that does state that the victim went to the police department in regards to a possible tracking device, given the fact that the defendant was following her around. At this point, after this, the victim then goes to a location. She sees the defendant in a parking lot, at which point she takes photos of him to show that he is there in the parking lot that she went to enter. Then additionally, when the victim goes to leave, the defendant exits the parking lot and begins following the victim. She has to call 911, and he stays following her while she's on the phone with 911 until police are dispatched, at which point he flees. The state would argue that there is probable cause, there is an injunction that has been put in place. The defendant has repeatedly harassed and followed the victim. Additionally, there are additional cases. The defendant has another open case for aggravated stalking and injunction violation, as well as an open probation violation with the same victim, and the state would be requesting probable cause be found.
Judge, if I can just briefly respond to that. With regards to the tracking devices, there is nothing in there that would suggest my client has anything to do with that. She just said she went to the police department about tracking devices. There is nothing in this arrest affidavit that indicates any other incidents other than the one that is in the arrest affidavit. So I just don't see how it fits within the statute of aggravated stalking.
Thank you. Let me ask the state as to count one, they would seek what type of bond?
Your Honor, for count one, the state would be requesting a bond of $5,000 and a level 1 GPS. It should be noted the defendant's currently being held no bond for the probation violations for picking up the new cases.
In this case, count two.
And the state would be requesting a bond of $1,000 for count two and for count three.
Judge, with regards to the defense's position, I, of course, would suggest that there's no probable cause for count one. I would ask for $2,500 count two and $1,500 count three.
And the state said count two was how much?
$1,000, Your Honor.
1,000. So I think we're not going to increase it. We'll keep it to 1,000 as to count two and 1,000 as to count three. I concur with counsel for the defense. No probable cause as to count one.
Your Honor, then the state would request, rather than aggravated stalking, that the court find probable cause for an additional count of injunction violation.
We have that already. Violation of the injunction, count three.
Yes, Your Honor, there could be multiple violations of an injunction. So the defendant following her to the parking lot is one violation of the injunction. The defendant following her out of it without being within 500 feet again is a second violation of the injunction. And they would request an increased bond then if there's no PC on the other ones for it to be a level 1 GPS in addition to the monetary component.
I think if I read this correctly, I don't see where he followed her to the police station. She went to the police station.
Correct, Your Honor, but when he goes to the parking lot. So when she goes, she goes to a location at a parking lot. He then goes into the parking lot. She then gets out of her car to confirm that that's him and that that's him there. He then follows her out of the parking lot as she's trying to go to her residence, at which point she calls 911, and then he flees from the police while pursuing her.
I disagree.
Understood,
At
Your
this
Honor.
time, no probable cause, count one. Count two and three, 1,000 bond, 1,000 bond. At this time, we have a stay away order. And in this case, Mr. Augustin, your attorney is here. Mr. Meyer is present. We may be able to obtain release. You may be able to make bail and bond out, but you will not engage in any criminal activity. You will not use, possess any illegal drugs. You will not purchase, possess, carry any firearms, guns, weapons, or ammunition. You must immediately surrender the firearms and ammunition and any concealed weapons permits to the nearest police station and file with the court a receipt. Your attorney can explain more to you about this order that I'm signing. It's called Order of Pretrial Release Conditions. The defendant is also prohibited from having any direct or indirect contact with the alleged victim, and in this case, victims, because counsel, I understand all of the children and the adult female have injunctions in their favor over and against Mr. Clemente, so he needs to be advised. You shall not contact any of them by writing or in person or telephone or through social media or through third parties. Defendant must stay at least 500 feet away from all victims in this case, victim home, victim's place of employment, or the victim's school. They do not cohabitate, so I don't think that's applicable at this time.
Judge, are you placing a hold on his probation warrant? He has a probation warrant, also no bond, on F24015-989.
So, Mr. Meyer, anything further?
Nothing further, Judge.
Thank you. Thank you for assisting us here today. Do you understand what I read to you, Mr. Clemente?
Yes, Your Honor.
Okay. All right.
Judge, was that a yes or no?
He said yes.
Thank you.
Judge, I think they're asking if there's a hold for the felony case based on this matter. Is the court issuing a hold?
Yes.
Okay.
Your Honor, the state has to have the defendant verbally state if he understands that there is a stay away order in place and the injunction in place, which prohibits any contact or being within 500 feet of the victim and her children.
He said yes, that he understood the conditions of the release that I just read him. Correct, Mr. Clemente?
Yes, Your Honor.
Thank you.
Thank you.
Lastly, where would you like me to mark the hold?
I'm talking where you go to the
Right there.
It's a prohibition.
Judge, thank you very much.
Thank you. Good luck. You're free to, next case would be the case of Anthony Andrade.
Judge, he refused, reset for tomorrow.
Thank you. 1 second, let me finish signing all the paperwork.
He has multiple cases, so he has a case.
Already in custody.
Okay. Don't be shy. You all speak up when I'm heading down the wrong trail. That's okay. His attorney is checked off of the Zoom, so I can't. So there is no probation hold. Okay. Maybe we could contact Mr. Meyer in some meaningful manner. And
Your Honor, I'm the actual ASA handling this defendant's cases, so I'll get in contact with counsel. He's gonna be on present on Monday anyways.
Or we don't specifically hold him on this case because he's already.
very good. Thank you for assisting us. Next case, Oscar Castro Kanaka.
Mr. Castro Kananaka has a hold for immigration.
Thank you.
Corrections, did he refuse?
He's here. He took him back. He refused, Judge.
Thank you. Reset tomorrow?
Yes, Your Honor.
And Madam Public Defender, your name, please?
Assistant Public Defender Claire Chatelier.
Oh boy, that's could you spell the last name just so I have it down? I apologize.
Yeah, it's a hard one. It's ChatEllier.
Wonderful, thank you.
Thank you.
The next case will be the case of Richard Bosch.
Mr. Bosch refused, reset for tomorrow.
Yeah.
Next case, Manuel Garcia.
Garcia refused, Judge, reset for tomorrow.
Next case, Travis Williams.
Mr. Williams refused, reset for tomorrow.
Next case, Mark Anthony Colon.
Mr. Colon refused, reset for tomorrow.
Jerry Alfred.
Defendant refused, reset for tomorrow.
Javon Alexander Washington.
Mr. Washington refused, reset for tomorrow.
Julio Angel Rodriguez.
Mr. Rodriguez refused, reset for tomorrow.
Case of Isaac Lumpkin.
Mr. Lumpkin refused, reset for.
Say again.
Mr. Lumpkin refused, reset for tomorrow.
Yes. Thank you. He has multiple cases, is what you were saying, yes?
I know there was one that got passed with that table, so just to make sure we have them.
Yes.
Oh, okay.
About the case of Christian Nieves.
Mr. Nevius refused, reset for tomorrow.
Mhm. Greg Leonard Mack.
Mr. Mack refused, reset for tomorrow.
Arista McLeod.
Mr. McLeod refused, reset for tomorrow.
Adam Gonzalez.
Mr. Gonzalez refused, reset for tomorrow.
Yanni D'Angelo McIntosh Jones.
Refused, reset for tomorrow.
Thank you. Next case will be the case of Siobhan Tria Monique Johnson.
It's a bund out, Judge.
Thank you. Next case, Denisha Nicole Hamilton. Good afternoon, Ms. Hamilton. You've been charged with a felony in the first-degree robbery, firearm or deadly weapon in violation of Florida Statute 812.13, subsection 2, subsection A. Count 2, felony of the third-degree assault aggravated with a deadly weapon in violation of Florida Statute 784.021, subsection 1, subsection A. In review of the arrest form, court finds probable cause, in this case specifically, state.
Your Honor, I think that did file a motion for trial detention in this case. As such, the state would request that this be reset for tomorrow for a hearing date.
Is the state's microphone on? Sorry, we can't hear them.
The state did file a motion for pretrial detention in this case, Your Honor. So upon the finding of probable cause, state requests that it get reset in division tomorrow for a hearing date for the motion for pretrial detention. And during that time, the defendant be held no bond.
Any objection?
No, I would just ask that it be set in division for tomorrow.
Granted.
Requesting for count 2.
5,000.
So in count 1,
No bond.
probable cause, no bond.
Yes. Count 2, $5,000 fine.
In this case, Ms. Hamilton, you may be released, but at any time you do obtain your release, you may not engage in any criminal activity whatsoever. You may not use or possess any illegal drugs. You may not purchase, possess, carry any firearms, guns, weapons, or ammunition. You must immediately surrender any and all firearms, ammunition, and concealed weapons permits to the nearest police department and file a receipt with the court. Defendant is prohibited from also having any direct or indirect contact with the following persons. That would be the victim, Kelsey Ware, including contact by writing, telephone, through social media, or other third-party means. Defendant must stay at least 500 feet away from the victim at all times, as well as the home, place of employment, school. In this case, they don't cohabitate. Is that correct, Madam Public Defender?
Yes, I don't believe they live together, Judge.
Thank you. Do you understand the pre-trial release conditions, ma'am?
I guess, yes, sir.
At this time, the court is also signing it and granting the state's request for a pretrial detention hearing, which will occur tomorrow in the division assigned to the circuit court judge. Good luck to you, ma'am. Next case of Maria Lavino.
Your Honor, in this case, I'm waiving the reading of the charges. I also don't have any probable cause arguments.
State.
She also needs the services of the interpreter, sorry.
Your Honor, the state would be.
1 second, Mr. Kaufman, Madam Interpreter.
Thank you.
Sorry about that, Your Honor. I'm here.
Thank you. This is Maria Lavino. We just were advised by the public defender that they're waiving any reading of the charges. And they are also not challenging probable cause in this case. At this time, Mr. Kaufman was about to advise the court of the amounts of the bond.
Yes, Your Honor. On the first charge, the state's requesting a bond of $5,000, and on the second charge, the state's requesting a bond of $5,000.
Muy bien, señora Lavino. La solicitud de su abogada, la Defensoría Pública, ha pedido que por favor no se lean los cargos en su contra y tampoco va a argumentar nada con respecto a causa probable. La Fiscalía solicita para el cargo número 1 una fianza de $5,000 y para el cargo número 2 una fianza de $5,000.
Your Honor, I would request pretrial services if she qualifies with an alternate of the standard bond of $5,000 as she has no prior arrests.
Lo que solicita la defensa es que usted sea liberada bajo la supervisión del programa Pretrial Services, ya que usted no tiene antecedentes o de lo contrario pagaría una fianza de $5,000.
Okay, I didn't understand. I apologize. Give me 1 second, Madam Interpreter. Oh, thank you. She doesn't qualify for pretrial services based on the nature of the charge against her, is what I'm being told from our pretrial representative. So under the circumstances, ma'am, if you do obtain release based on the bonds that I've set, that you will not engage in any criminal activity, you'll not possess any illegal drugs, you'll not be involved with the purchase, possession, carrying, or use of firearms, guns, weapons, or ammunition. and you must immediately surrender any firearms, ammunition, or concealed weapons permits to the nearest police department and obtain a receipt from the police department to file with the clerk of court. In this case, the defendant is also prohibited from having any direct or indirect contact with the minor, in this case, the MP victim, including contact by person, writing, telephone, or social media, or through third parties. Defendant must stay at least 500 feet away from the victim, victim's home, victim's place of employment, or school. Do they cohabitate to your knowledge, Madam Public Defender?
They do, Your Honor.
They do. In this case, Ms. Lovino may return once to the residence to retrieve the items in question of personal limited nature, such as clothing, personal health items, medication. She must go in the accompaniment of a police officer. To the degree she were to return to the property without a police officer, she subjects herself to arrest. There will be no contact whatsoever with the victim of this incident until further order of this court. Do you understand, ma'am?
We need the interpreter again.
Muy bien, señora, debido a la naturaleza de los cargos, usted no califica para el programa Pretrial Services. Si usted llegase a ser liberada, tiene que pagar la fianza que he mencionado previamente. Además de eso, usted no puede participar de ninguna actividad delictiva. Usted no puede consumir o tener sustancias ilícitas. Usted no puede comprar, portar o usar armas, armas de fuego o munición. De tener alguna de estas, tiene que entregarla a la comisaría más cercana y dar el recibo de dicha entrega a la Secretaría del Juzgado. También usted tiene prohibido tener contacto directo e indirecto con el menor, la menor víctima en esta causa. No puede ser el contacto en persona, por escrito, vía telefónica, a través de las redes sociales o a través de terceras personas. Además de eso, en todo momento, usted tiene que mantenerse a no menos de 500 pies de distancia de la víctima, el lugar donde ésta viva, trabaje o estudie. Ahora, como usted comparte la vivienda con la víctima, usted puede retornar una sola vez a la residencia escoltada por un policía para recoger sus artículos personales, los cuales están limitados a ropa, medicamentos y documentos personales. De no ir acompañada por un agente de la ley, usted estaría sujeta al arresto. ¿Ha entendido la orden que le dije?
Sí.
Yes.
Thank you. Good luck to you.
Gracias y buena suerte.
Judge, what are the bonds?
Sorry, I apologize. 5,000 on count 1, 5,000 on count 2. Next case is Jumanji Mency.
Judge, Mrs. Manny refused.
It'll be set tomorrow. Reset. As to both cases, that would be as to case number F25010088 and F25010102. There we go. Thank you. Next case is Jacqueline Solis.
She's present, Judge.
Ms. Solis, you've been charged with grand theft of a vehicle in violation of Florida Statute 812.014. This is a first-degree felony. Second, you've been charged with failed to redeliver a hired vehicle. This is a third-degree felony in violation of 817.52 Florida statute. And lastly, using false identification and possession of false identification, third-degree felony in violation of Florida statute 817.568.
Judge, Mrs. Solis also is a fugitive from Monroe County. He has 2 fugitive warrants from Monroe County. One of them is $40,000 and the other is $25,000.
Your Honor, I do have a probable cause argument as to count 1.
Momentarily, thank you. Probable cause found as to count 2 and 3. I'll hear argument on count 1.
Yes, Your Honor. So this should be a second-degree grand theft rather than a first-degree grand theft. A first-degree grand theft, as it's charged, would either have to be for property valued over $100,000 or a semi-trailer that's deployed by law enforcement. According to the four corners of the arrest form, the value of the alleged U-Haul truck is $38,000. That would mean that this would be a second-degree felony, an F2 grand theft, for which the appropriate bond amount would be $7,500. So I would be arguing that there's probable cause for a second-degree grand theft rather than a first-degree grand theft, as is indicated on the arrest form.
No objection, Your Honor.
7,500 bond, count 1. PC found as argued in this case, and the court concurs with the public defender and with the agreement of the state. Count 2, the bond.
Your Honor, for count 2, the state requests a bond of $2,500.
Count 3.
State also requests a bond of $2,500.
State's recommendations are approved. So to recap, count 1, $7,500. Count 2, $2,500. Count 3, $2,500. In this case, ma'am, if you're able to obtain bonds, you will stay away from the U-Haul location at 9118 Southwest 40th Street, Miami, Florida 33165 at all times. Be no closer to that facility than 500 feet. Do we understand?
Yes.
Good luck to you, ma'am. Thank you. Next case. Eve Serenity Ortiz. Miss Ortiz, in this case, you've been charged with a third-degree felony, burglary of an unoccupied conveyance in violation of Florida Statute 810.024B, and F, felony third-degree burglary of tools in her possession, or in this case, let me restate that, burglary tools that were in her possession, violation of Florida Statute 810.06. Taking a quick look at the arrest form.
Yes, Your Honor. And when you're done, I have a probable cause argument to count 2.
Thank you. We'll hear from the public defender.
Sure, Your Honor. So I believe that the that Officer Laurent, in writing this, was intending that the mentioned, I think, gloves and maybe mask were intended to be the burglary tools in this case. However, that is incorrect. The definition of burglary tools is any tool, machine, or implement used with the intent to allow a burglary, and the Florida Supreme Court has actually clarified that household objects such as gloves and masks do not count for the purpose of being considered a burglary tool under the statute 810.06. And I have case law that I can give, Your Honor, if you need it, but these are not burglary tools for the purpose of this statute. So I would be arguing release outright on count 2. There's no probable cause. I don't have any probable cause arguments as to count 1, however.
Thank you. Probable cause as to count 1 found as I've read the A form. Count 2, state.
Your Honor, this incident occurred at 2:27 in the morning, and although every item listed, a ski mask, a hoodie, white colored gloves, although those items may be had individually that do not indicate burglary tools, at night at an area that was burglarized, but specifically having those items in conjunction with the report of burglary, all rise to them being used as tools for burglary.
Your Honor, if I may, that's just not, that doesn't square with the case law. In Green v. State, the Supreme Court specifically held that gloves and other items of personal apparel do not facilitate the breaking and entering of a dwelling, and thus, therefore, do not fall under the statutory definition of burglary tools.
I concur. No PC released outright on count 2 only. As to count 1, state, bond.
On count 1.
On count 1, state is requesting a bond of $2,500.
Your Honor, would you be open to granting pretrial services with an alternate of $2,500? Ms. Ortiz has advised me that she's lived here her entire life, which leads me to believe she would actually. I retract my argument. I'll stipulate to $2,500, Your Honor.
Time bond is $2,500, and that would be as to count 1. Release outright as to count 2, no probable cause. Stay away. In this case, if you're able to make and obtain release, Ms. Ortiz, you will stay away from the location where you were arrested, which is 10501 Northeast 11th Avenue, North Miami Beach, Florida, 33162. Any questions?
No.
Do you understand? Is that a yes, ma'am?
No, she said she didn't have any questions.
Thank you. Does she understand the?
Yes.
Thank you. Next case, Bianca Cotila.
Your Honor, this is a co-defendant from the last defendant.
Thank you. I find probable cause as to, in this case, count 1. Let me take a look. I think we have the same situation, do we not?
That is correct, Your Honor.
Probable cause is not found as to count 1.
And Your Honor, just for purposes of the record, state renews its previous objection.
Overruled. Count 2. Probable cause found. State is seeking what type of bond?
Facing a bond of $2,500, Your Honor.
And I suspect in this case, the public defender had the same arguments to be made.
Yes, Your Honor, and $2,500 is fine.
So as to count 1, burglary tools, release outright. Lastly, Ms. Patina, if you are able to secure your release, at no time are you to be found at the place you were arrested and or be near the victim of this incident, Sharpston Jean. You must stay at least 500 feet away from the victim's home, place of employment, or school at all times, and you may never return to that location of 1031 Northeast 166th Street, North Miami Beach 33162, until further order of this court. Do we understand?
Yes, Your Honor, I understand.
Thank you.
You're welcome.
Next case, Esther Torres.
And in charge, Judge.
Thank you. This case is charged with a felony of the 3rd degree, grand theft, violation of Florida Statute 812.014, subsection 2, subsection C.
I don't have any probable cause arguments.
Rest, please. All right. Court finds probable cause in this case.
The state is seeking a bond of $2,500, Your Honor.
Count one, bond $2,500. Probable cause found, yes. In this case, Ms. Torres, if you are able to secure your release, you will stay away from Stephen Leshi, who was the victim in this incident, alleged, at least 500 feet from the victim himself. You'll not directly or indirectly seek to contact him by telephone or pager or fax, and you'll stay away from the victim's home, place of employment, and school at all times. Do you understand?
Yes, Your Honor.
Good luck to you, ma'am. Next case. Case of Angelina Mills. Miss Mills, you've been charged with a third-degree felony, grand theft, violation of Florida Statute 812.014, and second count of third-degree felony credit card fraudulent use of $100 or more in violation of 817.61. Take a moment. Probable cause found as to both counts. In this case, bond for count one.
State is seeking a bond of $2,500, Your Honor. And the state is seeking a bond of $2,500 in each count.
This time, bond set at $2,500 in both counts. Lastly, Matt, in this case, Miss Mills, if by chance you were to secure your release from the jail at no time going forward, may you be at the Port of Miami at 1435 North Cruz Boulevard, Miami, Florida 33132. You're not to return to that location until further order of this court. Do you understand?
Yes, Your Honor.
Judge, that's 2,500 all counts, correct?
Each count.
2,500 each count.
Thank you, Judge.
Oh, I apologize, Madam Public Defender. I understand. Because in count number 2, there were 3 uses of the card, there were 3 charges. So in the clerk being helpful here has reminded me of that fact. So as to the other counts, probable cause, yes, as well, based on the A form and 2,500 per count as to the count 3 and 4. Good luck to you, ma'am. Oh, they always let me put this too. S-A-O. I forgot to do that. Thank you. The next case is Jesus Ramos. It says on my posted here, hospital.
He's on his way. He's present, Your Honor. He needs the services of the Spanish interpreter. I don't have any probable cause arguments.
Thank you. Madam Interpreter has arrived. At this time, sir, you've been charged with a third-degree felony, possession of crack cocaine in violation of Florida Statute 893.13.
Buenos días, señora. Usted se le imputa un delito mayor de tercer grado, que es tenencia de cocaína en piedra, quebrantando el Estatuto de la Florida 893.13.
In this case, that is count 1. Count 2 is a first-degree misdemeanor, being in possession of drug paraphernalia with the intent to use. In this case, Florida Statute 893.147.
Y el segundo cargo que se le imputa es un delito mayor de primer grado, que es tenencia de adminículos para el consumo de drogas en quebrantamiento del Estatuto de la Florida 893.147.
Probable cause is found from reading the arrest form.
Luego de leer el atestado de arresto, se encuentra causa probable.
Bond, count one
Your Honor, the state is requesting a bond of $5,000 for count one.
and two.
1,500.
Your Honor, that would be over defense's objection. The nature of the standard bond contemplates the nature of these charges. The standard bond is $2,500 and $500. These are nonviolent charges related to addiction. And we should be giving him the standard bond in these cases.
Sure. As public defender's request is granted, 2,500 for count one, 500 for count two. Good luck to you, sir. Next case, Yeremias Garcia.
Se ha aceptado la solicitud de su abogada, la fianza para el cargo 1, 2.500 y para el cargo 2, $500. Buena suerte, señor.
I apologize, Madam Court Reporter. In the old days, because this is my 27th year on the bench, we would have a court reporter standing right in the well of the courtroom. We had 3 court reporters in the South Day Justice Center when I first arrived down there. Now we have the Zoom in the court reporter system and it works well. But like having been on the bench as long as I am, I forget that you're there sometimes, even though you're right there on the screen. I apologize.
Don't worry, sir. That's fine.
Thank you. Yeremias Garcia, he's been charged with a third-degree felony resisting an officer with violence to the person of the officer in violation of Florida Statute 843.01. This was a traffic stop in Virginia Gardens alleged.
For the traffic judge, the driving under the influence will be seen on tomorrow's calendar.
Thank you.
I don't have any probable cause arguments, Judge.
Thank you. Probable cause found after review of the arrest form. Bond.
Your Honor, state's requesting a standard bond of $2,500.
Bond will be set at $2,500. Good luck to you, sir. Next case, Reginald Smith.
Bond out.
Thank you. Next case, the case of Pavel Gomez Dubin.
Gomez is on his way, Your Honor.
Your Honor, the state is submitting a motion for pretrial detention.
Thank you.
He needs the services of the Spanish interpreter.
Madam Interpreter is here. In this case, Mr. Pavel Duman, you've been charged with 5 counts. I'm going to read them to you. The first is a felony of the first degree organized fraud, $50,000 or more in violation of Florida Statute 817.034.
Muy bien, señor Pavel, a usted le imputan 5 cargos. Voy a leer el primero, es un delito mayor de primer grado, que es organizar un fraude mayor a un total de $50,000, quebrantando el Estatuto de la Florida 817.034.
The second count is first degree felony grand theft in violation of Florida Statute 812.014.
Segundo cargo es un delito mayor de primer grado, hurto de menor cuantía en quebrantamiento del Estatuto de la Florida 812.014.
Third count is felony in the second degree grand theft in violation of Florida Statute 812.014.
El tercer cargo es un delito mayor de primer grado, hurto de menor cuantía en quebrantamiento del Estatuto de la Florida 812.014.
The fourth charge is a third-degree felony vehicle obtained by trick in violation of Florida Statute 817.52.
Your Honor,
817.52.
Thank you, sir. El cuarto delito que se le imputa es un delito mayor de tercer grado y es obtener un vehículo motorizado a través de engaños, esto en quebrantamiento del Estatuto de la Florida 817.52.
The fifth charge in this case is a misdemeanor of the first degree property obtained by false statements in credit. Florida Statute 817.03.
El quinto cargo que se le imputa es un delito menor de primer grado, que es obtener propiedad o artículos dando una declaración falsa. Esto en quebrantamiento de la ley de la Florida 817.03.
Having read the arrest form, which is 4 pages in length, court finds probable cause for all 5 of the charges against you. The state, please.
Your Honor, the first charge, this. Thank you.
You're gonna pause for the interpreter.
Yes.
Ok, he leído la totalidad del atestado de arresto que consta de 4 páginas y encuentro causa probable para los 5 delitos que se le imputan. Fiscalía, ¿cuál es la solicitud?
Your Honor, the state is seeking no bond on the first charge, a bond.
Your Honor, the state filed a pretrial detention motion in regards to count 1. So it'd be no bond for count 1 and reset for tomorrow for a hearing for the pretrial detention motion. Pausing for interpretation.
Su señoría, la Fiscalía solicita en el cargo número 1 que no se le dé fianza y más bien vamos a entablar una solicitud de detención preventiva para que se lleve a la audiencia el día de mañana.
Then on count 2 and count 3, the state is seeking a bond of $2,500 on each charge. On
Ahora,
count,
con respecto al cargo 2 y 3, la Fiscalía solicita $2.500 por cada uno de los cargos.
on count 4 and 5, the state is also seeking a bond of $2,500 on each charge.
Y con respecto al cargo 4 y 5, la Fiscalía también solicita $2.500 de fianza por cada uno de ellos.
And for charge 6 and 7, the state is seeking a standard bond of $500 on each charge.
Y con respecto al cargo 6 y 7, la Fiscalía solicita fianza estándar $500 por cada uno.
And I want to advise everyone that I didn't see there are 2 charges as to count number 5, which was credit obtained by false statement. So that would mean that the state seeking, did you say 500 on 6?
For count 6 and 7, it'd be $500 each, Your Honor.
Court finds probable cause as to all of the respective charges, as I stated earlier, including the 2 that are combined in those last 2 credit fraud. In this case, I've set the bonds, no bond, and I am going to sign the order.
Your Honor, if I may be heard regarding the pretrial detention motion. So statute 907.041, that's the pretrial detention statute. That detention statute specifically lists only 26 different types of crimes for which the state of Florida can file a pretrial detention motion. Those specifically enumerated crimes are described as dangerous crimes. And I can read all 26 of them if you'd like into the record. I don't think that should be necessary, but I can affirm to you that any grand theft or organized fraud is not one of the 26 listed enumerated offenses for which the state has any grounds to file this motion. Your Honor does legally have to give Mr. Gomez de Ben a bond in this case, and the standard bond for the charge that he's alleged, which the standard bond contemplates the nature of the charge, is $10,000 here. So I have no objection to the other bond amounts that the state has asked for in counts 2 through 7. So I think that we can agree and stipulate on counts 2 through 7. However, for count 1, if Your Honor grants the state's motion or even resets it a day to tomorrow, that would be illegally holding him in jail without a bond. That is not permitted under the pretrial detention statute. He has to be given a bond, and I would ask for the standard bond in this case of $10,000.
In reviewing the administrative order, the state does agree. The state will be withdrawing the pretrial detention motion and requesting a standard bond of $10,000 for count 1.
Your Honor, may I?
Thank you. Yes, Madam Interpreter.
Muy bien, su señoría ha encontrado causa probable para los 7 cargos. Los últimos 2 cargos están en combinación con el 5º cargo, que es obtener crédito dando una declaración falsa. A pesar de la solicitud de la Fiscalía de mantenerlo usted sin fianza, gracias a la defensa de su abogada, la Fiscalía ha retirado la moción o el recurso para de detención preventiva y le van a otorgar a usted la fianza estándar, que es $10,000, y luego están de acuerdo ambas partes en que la fianza se establezca según lo que propuso la Fiscalía con respecto a los cargos 2 al 7º cargo.
Thank you. To the degree in this case, Mr. Gomez Deben, that you are able to obtain release, you must stay away at all times from Lorenzo Buick GMC at 8447 Northwest 12th Street, Doral, Florida. Until further order of this court, you have no direct contact with them, and you shall stay at least 500 feet away from that dealership. As well, Mercedes-Benz of Miami at 1201 Northwest 16th Street, Miami Gardens, Florida. In this case, you'll have no contact and you'll not be found at that property. If you are, pursuant to this stay away order, you may subject yourself to arrest. Do you understand?
Muy bien, señor Gómez. Entonces usted ha sido capaz de obtener la liberación, pero quiere decir que usted no se puede acercar a la concesionaria de Lorenzo Buick, ubicada en la 8447 Northwest y la 12 calle en el Doral, Florida. Usted no puede tener contacto directo o indirecto o encontrarse en esa concesionaria y tiene que mantenerse a no menos de 500 pies de distancia, así como también la concesionaria Mercedes-Benz que se encuentra en Miami Gardens. Usted no puede estar cerca de ese lugar. Si se le vuelve a encontrar en cualquiera de estos 2 lugares, según lo que establece la orden de alejamiento, usted va a ser arrestado. ¿Me ha entendido?
Correcto, correcto.
Right.
Thank you.
Gracias.
Good luck, sir. Next case, James Elias. In this case, Mr. Elias, you've been charged with felony of the 3rd degree grand theft of a bicycle in violation of Florida Statute 812.014. Also, a misdemeanor of the 1st degree shopping cart possession, 506.509. This occurred in Miami Beach, Florida at 19th Street, alleged. I find probable cause. In this case, state.
Your Honor, on the first charge of grand theft, the state is seeking the standard bond of $2,500. And on the shopping cart possession charge, the state is seeking the standard bond of $500.
Your Honor, I'm asking for an ROR on the shopping cart charge. This is the misdemeanor milk crate where sometimes homeless individuals get charged with sitting on milk crates. I would ask for an ROR on the count 2.
Your Honor, that charge is in relation to, although it is specifically shopping cart and for milk crate, it has more connection to narcotics use and sale. And moreover, the defendant has lengthy priors and the state could have argued for an elevated bond on the grand theft charge.
Yet didn't. At this time, your request on the 500 is denied, but I will lower it to 100 in light of the facts surrounding the actual arrest form contained therein. Good luck to you, sir. Thank you. We also have a stay away order. You shall not return to the 1000 block of 19th Street, Miami Beach, 33140 until further order of this court. Do you understand? He just walked away. We're going to have to get him back. There's a stay away order.
Okay, he's coming back.
Judge, what was the bond for count 1?
Count 1, 2,500. Count 2, 100.
Okay, he's back.
Milk crate allegation. You mustn't return at any time, Mr. Elias, to the 1000 block of 19th Street, Miami Beach, Florida, 33140 until further order of this court. Do you understand?
Yes, sir.
Thank you. You're free to move back into the other room. Thank you. Next case, Alfredo Reyes. Mr. Reyes has been charged with a third-degree felony, battery on a person 65 or older, in violation of Florida Statute 784.082.
Brinson, they use Brinson, T. Brinson.
This is related to a domestic battery at 19th Place, Homestead, Florida.
He didn't do it.
And Your Honor, I do have probable cause arguments.
Momentarily, thank you.
Sure.
I have found probable cause, but I'll hear from the public defender.
Your Honor, there's no, unless I'm missing something, there's no age alleged in the four corners of the arrest form. So I'd be arguing that there's probable cause for misdemeanor battery, but not for felony battery. And so I'd be asking for a bond of $1,500, which is the bond for misdemeanor battery. I'd also note that Mr. Reyes has no prior convictions and has only one prior arrest since 2006.
Date?
Your Honor, the state's going to stipulate to a misdemeanor battery for a bond of $1,000.
Court finds probable cause for misdemeanor battery only. And the amount of the bond is $1,500, did you say, Madam State?
$1,000, Your Honor.
1,000, I stand corrected, thank you. At this time, we have also a stay away order. In this case, Mr. Reyes, you shall not return or engage, excuse me, you shall not engage in any criminal activity from this point forward. You are, if you are able to obtain release, these are the conditions of that release. You'll not use or possess any illegal drugs. You shall not use, purchase, possess, or carry any firearms, guns, weapons, or ammunition. You must immediately surrender any firearm, ammunition, and concealed weapons permits to the nearest police department and file a receipt from that tender of those weapons to the court. The defendant is prohibited from having any direct or indirect contact with, in this case, Alfredo Reyes Sr., including contact in writing, telephone, social media, or by third persons. Defendant must stay at least 500 feet away from the victim's home, the victim's place of employment, and school at all times. Do you understand that? Do you cohabitate with him? Do you live with him?
Yeah. This is just a father.
Did he say yes?
Yes, they do cohabitate, but he's advised me that he's the owner of the home.
He will not be returning to the home until further order of this court, except by the following methods. He has an opportunity within one time and one time only to return within 48 hours of the entry of this order, accompanied by a police officer. This is to retrieve personal clothing, personal health items, medication, or business-related work papers. Going to the home or remaining at the home without the police will subject the defendant to arrest. Police officers shall request all keys and garage door openers to the home from the defendant and turn them over to the victim in this case. Do you understand?
Say that one more time.
He asked for a repetition, Your Honor.
You'd like me to read it to him again?
Just the last couple sentences.
Yes. He may not go to the home without the accompaniment of a police officer. If he does so, he'll be arrested. He has to turn in all keys to the house and garage door openers, if any, to the victim in this case, because both of them reside at the same premises, even though in this case, Reyes Jr. is alleging he's the owner of the property. Does he understand?
Yes. He said yes now, Your Honor.
Good luck to you, sir. Next case, Gaspar Lopez Perez.
He is present, Your Honor. He requires the services of the Spanish interpreter, and I do have probable cause arguments eventually when we get there.
Thank you. Mr. Lopez Perez, you've been charged with a felony of the 3rd degree providing false information to a law enforcement officer in violation of Florida Statute 775-261, subsection 10, subsection D.
Señor López Pérez, a usted se le imputa un cargo, un delito mayor de 3er grado por haber dado información falsa a un agente de la ley. Esto en quebrantamiento de la ley de la Florida 775267, subsección 10, subsección D.
Count 2 is a misdemeanor of the 1st degree resisting an officer without violence in violation of Florida Statute 843.02.
Y también se le imputa poner resistencia al arresto sin violencia en quebrantamiento de la ley de la Florida 843.02.
Count number 3 is consuming alcohol near a premises which sells alcohol in violation of municipal ordinance 21-31, subparagraph 2, subparagraph B, subparagraph 1.
Además, también se le imputa beber alcohol cerca a un recinto o un comercio donde se vende alcohol. Esto en quebrantamiento de una ordenanza municipal 21-31, subpárrafo 2, subpárrafo B, subpárrafo 1.
At this time, Madam Public Defender, I'll hear from you.
Yes, Your Honor. So regarding count 1, espere. Regarding count 1, if you look at the statute 775.261, I believe that this requires the defendant to be classified as a career offender. There's nothing in the 4 corners of the arrest form that alleges that he's any kind of career offender, and in looking at his priors, it looks like this is his first arrest. So I'm not sure why he was listed as having been a career offender. I think possibly what the officer meant to put, and what I would agree with, is that there's misdemeanor probable cause, or there's probable cause for the 1st degree misdemeanor of providing a false name after arrest. And I would stipulate to a finding of probable cause of misdemeanor 1st degree providing a false name after arrest. But from what I can see, and certainly in the evidence that's included in this arrest form, Mr. Lopez Perez is not a career offender, and there's no probable cause for any felony at all.
Thank you.
The Honor State stipulates that.
Cause is found for the misdemeanor only, and that is a misdemeanor in what degree?
It's a 1st degree misdemeanor, Your Honor. I would be asking that we do, and I don't have probable cause arguments to count 2 and 3, so I would just ask that we do 500 for count 2, 150 for count 3, and then do 500 for count 1, seeing as they're both 1st degree misdemeanors.
The state's request.
At this time, count 1, 500, count 2, 500, count 3, 150. Probable cause found as to all based on the arguments made by counsel.
Gracias. Go ahead, Your Honor.
I'm so sorry, Madam Interpreter.
Muy bien, entonces su señoría encuentra motivo fundado a los delitos que se le imputan y gracias a los argumentos presentados por su abogada, la fianza es la siguiente: $500 cargo 1, $500 cargo 2 y $150 el cargo 3.
Very good. At this time, good luck to you, sir.
Buena suerte, señor.
Next case, Johan Diaz. Mr. Diaz, you've been charged with a felony of the 3rd degree criminal mischief and $1,000 or more in violation of Florida Statute 806-13 sub 1. In this case, this happened at Southwest 8th Street and 10220 Avenue, as alleged. The victim's vehicle had a brick thrown through the window. Court finds probable cause. State.
State is seeking a bond of $2,500, Your Honor.
Your Honor, I would be requesting pretrial services alternate standard if he qualifies. I believe he's lived here for long enough to qualify, and in my packet I received, I don't see any priors.
Mr. Kaufman.
Your Honor, I see a 2021 aggravated battery arrest.
In the NCIC, Your Honor.
As well as a battery on law enforcement. This is again from the defendant's NCICs, and another aggravated battery. No, that was from the same previous charge. So, Your Honor, I see both a battery on law enforcement as well as an aggravated battery from his NCICs.
Alternate bond denied. $2,500 is the set bond. Mr. Diaz, if you are able to secure your release, you shall not be within 500 feet of Alexandra Figueroa. Have any direct contact with her indirectly or in person or in writing or by telephone, pager, fax, or other third parties. You must at all times stay away from her by 500 feet from the victim's home, place of employment, or school at all times. Do you understand?
Yes.
Thank you. Back to you, sir. Next case. Case of Luis Angel Medina.
One moment, Your Honor, we're finding out about Medina.
Thank you.
Medina refused, Judge.
Thank you. Thank you. At this time, Elvilio Bermudez.
He also refused, Your Honor.
Thank you. Next case, Juan Quintero.
He's present.
Mr. Quintero, you have been charged with, in this case, 4 counts of violation of criminal statutes, felony in the 3rd degree, robbery by sudden snatching in violation of 812.131, misdemeanor in 1st degree battery, Florida statute 784.03, misdemeanor in the 2nd degree, phone call, obscene and harassing in violation of Florida statute 365.16 subparagraph 1, and a misdemeanor of the 1st degree stalking, violation of Florida statute 784.048. In this case, this incident occurred alleged at 11401 Northwest 12th Avenue, Sweetwater. Apparently, this was a dispute between people who had been dating previously. After reviewing the arrest form, the court finds probable cause for all 4 charges. State.
Your Honor, on the first charge, the state is seeking a bond of $5,000. On the battery, state is seeking $1,000 and then $150 on the phone call. And the elevated bond is due to the significance of the defendant's priors, as well as the potentially violent nature.
As to stalking, count 4.
For the stalking charge, the state is seeking $1,000 bond, Your Honor.
Your Honor, I would ask, because maybe the state has information that I don't, that the state please proffer what priors they're referring to when they say the seriousness of the defendant's priors.
Yes, so the defendant has had previous battery charges. There was a felony, this is a local case as well, felony case that ends in 454 with 2 battery charges. And then and those were domestic violence, by the way. And for his national priors, he has previous battery charges, 2 of them. He has a previous kidnapping charge, at least 1, if not 2. And that was from 2009. And defendant's page's worth of previous priors. Each page includes battery.
Okay, yeah, all I could see were the no action batteries from over 10 years ago. So that's why I asked. We will stipulate to standard bond on these charges, Your Honor. So I believe count 1 is 5,000.
Correct. I've entered 5,000, count 2, 1,000, count 3, 150, count 4, 1,000. At this time, sir, if you're able to secure your release, you will not engage in any criminal activity. You will not use or possess any illegal drugs. You shall not purchase, possess, or carry any firearms, guns, weapons, or ammunition, and you must immediately surrender any such weapons and concealed weapons permits to the nearest police department and obtain a receipt for doing so to bring to court. The defendant is prohibited from having any direct or indirect contact with the following persons: Antonella Canepa, including by and through writing, telephone, social media, or through third parties. You must stay at all times away from her by 500 feet, and you must stay away from the victim's home, place of employment, and school by 500 feet at all times. In this case, do we know if he cohabitates with her?
No, they don't cohabitate.
Shall not be returning to the property at any time that she resides in. Do you understand the conditions of the release, Mr. Quintero?
Yes, sir.
You. Next case, Patrick Gaines. Mr. Gaines, you've been charged with a 3rd-degree felony of burglary of an unoccupied structure in violation of Florida Statute 810.02, subparagraph 4, and a misdemeanor of the 2nd-degree petty theft in violation of Florida Statute 812.014. In this case, looking at the arrest form, the court finds probable cause. State?
Your Honor, state is requesting a bond of $2,500 for count 1 and $150 for count 2.
No objection.
Court has entered accordingly the bonds, 25 for count 1, 450 for count 2. Good luck.
I thought I heard 150.
150, Your Honor.
I stand corrected here. You need to be also an accounting degree major to handle bond duty on the weekend. Thank you. Next case, you're free to go, sir, to the next room. Thank you. Russell Johnson. Mr. Johnson, you've been charged with felony count degree 2, retail theft, prior convictions in violation of Florida Statute 812.015. Also a 3rd-degree felony credit card dealing in others, 817.0.60 subsection 5. 1 second, let me take a look at the arrest form. In this case, court finds probable cause. State?
Your Honor, in this case, the state is seeking the standard bond of $2,500 in each charge.
Thank you.
Your Honor, if I may be heard as to retail theft, I think that there's probable cause for felony petty theft by 2 or more prior convictions, but I don't believe that there's PC for retail theft. The statute for retail theft requires some kind of anti-shoplifting mechanism or an anti-shoplifting inventory like control tampering or multiple thefts from the same location, neither of which are depicted in the arrest form. I'd be asking for F3 petty theft by 2 or more prior convictions, which has a standard bond of $1,500. And I don't have any objections as to probable cause, however, on count 2, and I would stipulate to the state mentioned the standard bond on that as $2,500, but I think it should be different on count 1.
Response.
No objection, Your Honor.
In this case, as stated by the counsel, count 1 will be deemed to be probable cause found for
Petty theft by prior conviction, Your Honor.
petty theft by prior conviction, which is a felony of the 3rd degree?
Yes, Your Honor.
Thank you. And the court has entered the count 1 $2,500 bond, count 2 $2,500 bond.
Your Honor, I believe that standard bond for the petty theft by prior conviction is actually $1,500 based on my review of the bond schedule.
Thank you. I will adjust it accordingly. 1,500 for count 1, 2,500 for count 2. If I have that understanding correct. Yes? At this time, Mr. Johnson, you shall at all times remain away from the CVS where you were arrested at 9578 Harding Avenue, Surfside, Florida, 33154 until further order of the court. Do you understand, sir?
Yes, sir.
Mr. Johnson. Good luck. Ruben Guevara. Mr.
Your Honor, he's present. He speaks English. I don't have probable cause arguments.
Thank you. Battery on a police officer, corrections officer in violation, Florida Statute 784.07 sub 2. And a misdemeanor of the 1st degree, resisting an officer without violence to his person in violation of Florida Statute 843.02 based on the stipulation, probable cause found as to count 1 and count 2. State?
Your Honor, the first charge, the state is seeking a bond of $5,000, and in the second charge, the state is seeking a bond of $2,500.
Bond set accordingly. Good luck to you, sir. Thank you. Next case.
The state's microphone wasn't on.
Say again.
The microphone for the state wasn't on. We didn't hear what they said.
I apologize.
The state is seeking a bond of $5,000 in the first charge and a bond of $2,500 in the second charge.
Your Honor, I believe the standard bond for the second charge is $500. So I'd be asking for standard bond. Doesn't look like he has priors.
The second charge, that is correct, and the state stipulates to the $500 bond in charge 2.
Thank you. So now we have count 1, 5,000, count 2, 500. Thank you. Pedro Guzman Bautista.
He's present, Your Honor. He needs the services of the Spanish interpreter. I don't have any arguments as to probable cause.
Madam Interpreter. Mr. Batista, you've been charged with a felony in the 1st degree battery and aggravated bodily harm and using a weapon, in this case, a firearm, in violation of 784.045. The court, having reviewed the arrest form, this actually argues that these weapons were scissors. It says weapon, so ergo I'm presuming that's what they meant. Probable cause, yes.
And Your Honor, the state did file a motion for pretrial detention. At this time, the state requests that the defendant be held no bond and reset for hearing tomorrow in division.
I don't have an objection, but just as a reminder, he does need an interpreter.
Muy bien, señor Batista, usted se le imputa un delito mayor de primer grado, que es agresión física agravada o calificada con daño corporal, habiendo usado un arma en quebrantamiento del Estatuto de la Florida. Luego de haber leído el atestado de arresto, se dice que el arma eran unas tijeras, así que encuentro causa probable. La Fiscalía acaba de entablar un recurso donde solicita la detención preventiva y que se quede sin fianza hasta el día de mañana.
Thank you. The court signed the order granting pretrial detention hearing.
Sí, tú lees con un otro
No
juez mañana.
No bond at this time.
No tengo fianza en este momento. You can head out that way.
Batista. Uh-oh. Well, he's no bond, so I guess that can be issued by the whoever's going to hear that hearing. How about Cosme Leyva?
He's on his way in.
Didn't hear that. Mr. Leyva,
Mr.
you've been charged with felony of the third degree, controlled substance possession in violation of 893.13, drug paraphernalia possession with the intent to use 893.147, and a probation violation of Florida Statute 948.061.
I don't have any probable cause arguments, Your Honor.
Court finds probable cause as to count 1, 2, and 3.
As to count one, the state seeks the standard bond of $2,500. To count two, the state seeks standard bond of $500. And for count three, the state seeks a standard bond of $500, Your Honor.
I don't have 3 counts, Judge. I only have 2.
The third count was a probation violation.
Right. They just list that there to notate that they think the person might be on probation. It's not a separate crime for which bond is set.
So therefore, count 1, probable cause, yes, $2,500 bond set. Count 2, probable cause, yes, $500 bond set. Good luck to you, sir.
Judge, you're going to place the hold on the probation cases, correct?
Yes.
And a hold for the probation. Yes, thank you.
I'm sorry, correction, what's the case number for the probation?
The first one is F180243332. And you also have F2102062.
Thank you.
Next case, Thomas La Rosa Hernandez.
Mr. La Rosa Hernandez is a hold for immigration.
Your Honor, he's present. He needs the services of the Spanish interpreter. I don't have any arguments as to probable cause.
El señor de la Rosa tiene una retención migratoria. No hay argumento con respecto a causa probable.
Thank you. At this time, Mr. La Rosa Hernandez, you've been charged with a felony of the third degree, baiting, animal fighting, and attending in violation of Florida Statute 828122, subsection 3.
Señor de la Rosa, usted se le imputa un delito mayor de tercer grado, que es haber organizado y asistido a una pelea animal, lo cual está en quebrantamiento de la ley de la Florida 828.122, subsección 3.
Count 2 is a misdemeanor of the first degree, resisting an officer without violence in violation of Florida Statute 843.02.
El segundo cargo es poner resistencia al arresto sin violencia en quebrantamiento de la ley de la Florida 843.02.
Find probable cause for the counts in this case. State.
Your Honor, on count 1, state seeks a bond of $2,500 and a bond of $500 on count 2.
Su señoría encuentra motivo fundado de los cargos que se le imputa. La Fiscalía solicita una fianza de $2,500 para el cargo 1 y $500 para el cargo 2.
At this time, the court finds $2,500 bond as to count 1 appropriate and count 2 $500. Good
Su
luck.
señoría encuentra que es adecuada la fianza de $2.500 para el cargo 1 y $500 para el cargo 2. Buena suerte.
Next case.
One second, Judge, I'm sorry. Just I need a moment before we move on to the next case, that's all. One second, Judge, we're almost ready. Your Honor, we have Mr. Barrios present and he also needs a Spanish interpreter.
Thank you. Mr. Barrios, you've been charged with a third-degree felony, aiding in the escape of the apprehension by police officers of individuals in violation of 843.12.
Señora, usted se le imputa un delito mayor de tercer grado, el cual es ayudar a escapar a personas que iban a ser detenidas o aprendidas por la policía. Esto en quebrantamiento de la ley de la Florida 843.12.
You've also been charged with count 2, third-degree felony, having a weapon in your possession while committing an offense in violation of Florida Statute 790.07. A machete.
A machete, Your Honor. Y también se le imputa un delito mayor de tercer grado, que es tenencia de un arma en quebrantamiento de la ley de la Florida 790.07, un machete.
State, I find probable cause after reading the arrest form.
Your Honor, the state is seeking a bond of $2,500 for each charge.
And in this case, the court finds that that is a reasonable amount in these charges and enters same accordingly. Moreover,
Your Honor, I'm pausing for the interpreter. I don't know if she wanted to add something before I jump in.
yes, thank you.
Su señoría encuentra que los montos solicitados por la Fiscalía de fianza son los adecuados. Encuentra causa probable y la fianza es de $2.500 para cada uno de los cargos.
Your Honor, Mr. Barrios, according to the four corners of the arrest form, is not involved, or he hasn't been charged with the animal fighting charge that the other co-defendants were charged with. He's also, I think what they're actually referring to is the spring-loaded knife on page 2, but that's actually attributed to a different defendant. So I don't think that we can count the machetes as the weapon because he's not charged with the animal fighting like the other folks are. I think that there's no probable cause for count 2. It should be released outright, as the little 3.7-inch knife is attributed to another person, but I don't have probable cause arguments as to count 1.
Lo que dice lo que dice su defensa es que no deberían encontrar causa probable para el cargo 2, ya que usted no se le imputa el cargo que tienen los otros coacusados, que es haber participado o organizado peleas animales. Así que el cuchillo de 7 centímetros, de 7 pulgadas que se le encontró, le pertenecía a otra persona, no debería encontrarse causa probable y dejarle en libertad inmediata.
You look at the last paragraph of the last last sentence. It says, Mr. Barrios and Lucero were charged with aiding in the escape. Barrios was apparently the driver of the vehicle.
Si usted lee el último párrafo, dice que Barrios fue que ayudó a escapar. Aparentemente, Barrios era el conductor del vehículo.
Right, so there's no allegation that he's at the scene of the fight with the machetes, nor that he's arrested with any weapon.
Por eso mismo, no hay nada que diga que él se encontraba en el lugar del incidente con el machete ni que él es dueño de dichas armas.
No probable cause as to count 2, correct?
That is correct, Your Honor.
Muy bien, entonces no causa probable para el cargo número 2.
Release outright on count 2.
Con respecto al cargo 2, libertad inmediata.
Count 1 stands at $2,500 bond. Good luck to you, sir. Thank you.
El cargo 1 se mantiene con una fianza de $2,500, señor. Buena suerte.
Next case, Castor Abreu Lemos.
Your Honor, I am going to be waiving the reading of the charges. In this case, I don't have any probable cause arguments.
Your Honor, the state would be seeking a bond of $5,000 in this case.
$5,000 bond. Approved. Probable cause found. The court concurs with the assistant state's attorney and the state. In this case, Mr. Abreu Lemus, if you were able to secure your release, I have some conditions related to your release. At no time hereafter will you be engaged in any criminal activity. You shall not use or possess any illegal drugs. You shall not use, possess, purchase, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms and ammunition and concealed weapons permits to the nearest police station upon your release and file a receipt with the court. Defendant is prohibited from having any direct contact with the following persons, in this case, JB, the victim, minor, I believe, including contact by person, writing, or telephone through social media or any electronic means, or third persons. Defendant must stay at least 500 feet from the victim's home, place of employment, and or school at all times, and may not be caught within 500 feet of the victim themselves. Do they cohabitate, Madam Public Defender?
No, they don't cohabitate.
You. Good luck to you, sir. Do you understand the provisions that I just read to you?
Yes, sir.
Good luck. Next case, Derek Jackson.
Your Honor, Corrections has asked me if we could call a case out of turn. LeBoot on page 15, Joaquin.
What was the name?
Joaquin Labout, Labaut. I don't have any probable cause arguments.
Is that VILLOT?
No, Labaut. Joaquin is the first name with a J. The case ends in 0101. Yeah.
I don't think it's in here, but
Yes, I have it over here. And I think you say it was on page 14?
15.
Thank you.
Not near the bottom, far enough. Not yet. Sir, in this case, you've been charged with being in possession of a controlled substance, in this case, methamphetamine, in violation of Florida statute 893.13. And this is a third-degree felony. And co-possession of cannabis of 20 grams or less in violation of municipal ordinance 21-81, subparagraph D, subparagraph 6. This occurred on Okeechobee Road in Hialeah, Florida, alleged. Thank you. I think I heard, if I'm not mistaken, from our public defender, no objection to probable cause. Is that what you said or no?
That is what I said. I do have, I would also agree to standard bond on count 1, but I have bond arguments to count 2.
Probable cause as to count 1 found.
And the state is seeking a bond of $2,500 on each charge.
Thank you.
Your Honor.
Your argument as to count 2.
Yeah, on count 2, I'm going to be asking for an ROR in this case, Your Honor. I'm referring to the memorandum that was provided to, or it's from the Office of the State Attorney, Catherine Fernandez Rundle. And I'm quoting that the Office of barring exceptional circumstances on a particular case will not be prosecuting some of the marijuana possession, misdemeanor marijuana possession cases. This is a civil ordinance. It's not a felony. So because it's 20 grams or less, I do believe that this would fall into the category of cases that by the state attorney's office own admission, they will no longer likely be prosecuting. And so for that reason, I'm asking for an ROR on count 2, and I'll stipulate to standard bond on count 1.
It stipulates.
Granted. Thank you. Good luck to you, sir. Next case, Derek Jackson. Mr. Jackson, you've been charged with a third-degree felony accessory after the fact in violation of Florida Statute 777.03, subparagraph 2, subparagraph C. This involved a burglary in progress with 3 other individuals in Homestead, Florida. I find probable cause for the arrest. In this case, state.
Your Honor, the state would be seeking the standard bond of $2,500 in each charge.
In this case, I only have one. Oh, there are 3 charges. I stand corrected. In this case, there were 3 sub counts within the first felony. So 2,500 and 2,500, correct?
That is correct, Your Honor.
Your Honor,
It's a total of 3 counts, Judge, 25 on each.
Yes.
would Your Honor be opposed to doing a reduced bond because there's multiple counts and this defendant has no priors, or to potentially doing pretrial services alternate standard bond?
Mr. Kaufman.
Your Honor, I do not know if the defendant currently satisfies or qualifies for pretrial services. However, the state is simply seeking the standard bond in this case.
Alternate bond set 2,500. Pretrial services, if eligible, will determine that. He does qualify? He does not. He does. Yes, thank you. Pretrial services says he does qualify, so I'm going to grant an alternate bond in this circumstance. Good luck to you, sir. Next case. Sean Mitchell. Mr. Mitchell, you've been charged with 4 separate counts. First count is felony in the 3rd degree controlled substance, methamphetamine, in violation of 893.13 subsection 6. Misdemeanor in the 1st degree drug paraphernalia with a possession intent to use, violation of 893.147. Misdemeanor in the 1st degree trespass of the property after warning in violation of 810.09. And lastly, loitering in the parking after hours on Miami Beach in violation of municipal ordinance 82.2. In this case, taking a review and look at the arrest form. Court finds probable cause as to all 4 charges.
Your Honor, in this case, the state would be seeking the bond of $2,500 for the controlled substance charge, $500 for the drug paraphernalia charge, $500 for the trespass, and $150 for the after hours at the park. And that would be a total of $3,650.
The last count 4 was 150.
That is correct, Your Honor.
The count 3 was 500 and count 2 500.
Count 2 500, count 3 500, and count 1 $2,500.
Thank you. Probable cause found. This time, sir, if you are able to secure your release, you must stay away at all times from the location at 300 block of 22nd Street, Miami Beach, where you were arrested. At no time may you go to that location until further order of this court. Do you understand?
Yes.
Good luck to you, sir. Next case would be the case of Tavari McCollum. Mr. McCall, you've been charged with a felony of the 3rd degree burglary of an unoccupied conveyance in violation of Florida statute 81002, and count 2, a felony of 3rd degree burglary with being in possession of burglary tools, violation of 810.06. Taking a look at the arrest form.
Your Honor, I will stipulate to probable cause on the burglary of an unoccupied conveyance. But again, I'm renewing my previous arguments that I had made regarding masks as counting as burglary tools. I believe that's what the officers were referring to in this case, gloves and a mask for count 2. So I would ask for release outright for no probable cause found on count 2.
Your Honor, the state stipulates.
No PC as to count 2. Outright release.
Yes, in regard to the burglary tools possession. However, we stipulate to the standard bond for the burglary charge.
So I had said I stipulate to the finding of PC on count 1. In this case, because this defendant is only 18 and his only priors are cannabis and a misdemeanor trespass, I'd be asking for pretrial services alternate standard bond in this case, Your Honor. You know, and if the pretrial service officer says he qualifies, of course.
No objection, Your Honor. The defendant does, in fact, qualify for pretrial services.
Standard bond.
So the standard bond would be $2,500, Your Honor.
Alternate bond, $2,500. Pretrial services referral granted. Is he eligible?
Yes, sir.
He is eligible from what we understand. So I think I got that. And this is the next one, or this one? In this case also, Mr. McCall, you may not at any time be near Sharpston Jean within 500 feet of him, his home, his place of employment or school. You may not contact him directly or indirectly in person, in writing, or by telephone, pager, or fax, or through third parties. Do you understand?
Yes, sir. I understand.
Good luck to you. Next case, Timothy Brooks, Jr. Mr. Brooks, you've been charged with 3 counts First count is kidnapping with a weapon, firearm, or aggravated battery in violation of Florida Statute 787.01. Count 2, felony of the first degree, burglary with assault or battery in a public PBL. I'm not sure what that abbreviated.
Yes, Your Honor, it means.
Light
State has the motion for pretrial detention in this case.
in violation of Florida Statute 810.02. And misdemeanor in the first degree, concealed weapon carrying on his person in violation of 790.01.
Your Honor, I don't have any arguments as to probable cause. I would just ask that the pretrial detention motion be reset for division for tomorrow.
Thank you, Madam Public Defender. If you could move the mic a little.
Oh, yes, I have no arguments as to probable cause. I would just ask that the pretrial detention motion be set in division as well tomorrow. And that standard bond be given on count 3.
State stipulates, Your Honor.
Count 3 standard bond would be Mr. Kaufman.
Your Honor, it's $1,000.
No bond as to the other 2?
Yes, Your Honor, and it will be reset tomorrow for the hearing.
Good luck to you, sir. Mr. Brooks, before he runs away, Madam Public Defender, excuse me,
Oh, I'm sorry. Do we need Mr. Brooks back?
momentarily.
Okay.
Oh, court.
I've also set the order granting pretrial detention for now. Mr. Brooks, if you're able to secure your release, sir, you may not at any time be near Bantaya or Kahaya, if I have spelled that correctly or pronounced it correctly. You may not be within 500 feet of her, directly or indirectly, and writing in by telephone, page, or fax, or third persons. You may not contact her. If you were to be in her presence within 500 feet of the victim's home, place of employment, or school, you subject yourself to arrest. Do you understand?
I understand.
Good luck, sir. Next case, Sean Sanchez.
Your Honor, we have Mr. Sanchez present. He needs the services of the interpreter. I don't have any arguments to probable cause, but I'll have bond arguments once we get there.
Madam Interpreter is present. We have Mr. Sanchez. You've been charged with a felony of the third degree cocaine possession, which was crack cocaine in violation of Florida Statute 893.13, subsection 6.
Señor Sánchez, a usted se le imputa un delito mayor de tercer grado, tenencia de cocaína en piedra, en quebrantamiento de la ley de la Florida 893.13, subsección 6.
$2,500.
Madam Interpreter.
Fianza $2,500 solicita la Fiscalía.
Madam Public Defender, probable cause. You said you had something also to bring to the court's attention.
I do, Your Honor. I agree that there's probable cause in the arrest form. However, I'm going to be asking for an ROR in this case for 2 reasons. First, based on Mr. Sanchez's local priors, he has 1 petty theft that was no frost. So from what I can see, he's never been convicted of a crime in Miami and has only been arrested once for a second-degree misdemeanor petty theft. More importantly, however, I'll pause for interpreter.
Su señoría, con respecto a causa probable no tengo nada que decir, pero sí me gustaría solicitar que se le ponga en libertad bajo palabra, y esto por 2 razones. Uno, debido a los antecedentes locales. Tiene un solo caso que es hurto de menor cuantía, el cual no procedió. No tiene ninguna condena en el condado de Miami-Dade. Y aún más importante,
In reading the arrest form, I don't believe that this will survive a motion to suppress. It says that Mr. Sanchez allegedly dropped a belonging, but not that he abandoned it by any means. The officer says that he actually approached Mr. Sanchez and then picked up the belonging that he had dropped and searched it for no other reason. So because I don't believe that this case will be filed on, and I don't believe it would survive a motion to suppress should it be filed on, and because he has essentially no real priors, I'm asking for an ROR in this case.
Y lo más importante, su señoría, si usted lee el atestado de arresto, este caso no sobreviviría a un recurso para suprimir evidencias, porque se alega que fue el señor a que se le cayó una pertenencia, no que él la dejó, sino que se le cayó y el agente se ayudó para ayudarle, se acercó para ayudarle. Es ahí donde sucede la búsqueda, sin razón alguna. Así que esto no sobreviviría la moción para suprimir evidencias, por eso pedimos libertad bajo palabra.
Your Honor, the state would be objecting to ROR, but has no objection to pretrial services.
La Fiscalía se opone a la libertad bajo palabra, pero no al programa Pretrial Services.
In this case, the request by the public defender is denied, but I will grant pretrial service with an alternate bond of $2,500. Good luck to you, sir. Thank you.
La solicitud de la defensa ha sido negada, pero se le va a liberar bajo la supervisión del programa Pretrial Services o de manera alternativa paga la fianza de $2,500. Buena suerte.
Next case, Marquise Curry.
This is an added charge, Judge, for Mr. Curry.
Thank you. Mr. Curry, you've been charged with felony in the 3rd degree cocaine possession, suspected crack cocaine.
Oh, wait a minute.
Felony in the 3rd degree, count 2, substance possession, suspected OxyContin. Case on first charge and second charge are subject of Florida Statute 893.13, subsection 6A. Having read the A form, probable cause found. 8.
Your Honor, state's requesting a standard bond of 2,500 in the first count and 2,500 in the second count. Also a felony hold for the other case. Oh, my apologies, never mind.
In this case, the court enters a $2,500 bond as to count 1, count 2, finds probable cause as to both. Did we have to put this felony hold here?
No, Your Honor.
Good luck to you, sir. You're free to move to the other room. Juan Sanchez, we've already dealt with, and I have done his pre-trial release order just now.
Judge, what was the bond for count 2 for Mr. Curry?
2,500 on 1, 2,500 on 2. Thank you. Next case would be Gilberto Rivera. Good afternoon, sir. You're charged with felony of the 3rd degree assault and aggravated battery with a deadly weapon under Florida Statute 784.021 and felony count 2 on the 3rd degree criminal mischief, $1,000 or more in violation of 806.13. This occurred in Lakes on the Green at 87th Avenue Northwest and 189th Street Northwest, allegedly. Give me a moment.
I have no probable cause arguments.
Thank you. Bonds? The court finds probable cause based on the arrest form. Ms. Mueller.
Your Honor, state requests a standard bond of $2,500 per count.
That's granted.
My apologies, Your Honor. It's actually $5,000 per count. My apologies.
Count what?
1 and 2.
The state has modified its position. They are seeking 5,000 and 5,000, count 1 and count 2.
Your Honor, I'd be asking for standard bond on count 2, which is 2,500.
Your Honor, the state's argument would be that this is done with violence, so standard bond would actually be $5,000 for the criminal mischief.
If the state can point me to the statute they're referencing criminal mischief with violence, I'll verify. But if they don't know the statute number, I'm just asking for standard bond.
Yeah, at this point, the state will stipulate to $2,500 for count 2, just for reference though, with the admin order for the new bond conditions. felonies of the third degree are separated by violence and nonviolence. Nonviolence is 2,500 and with violence is 5,000.
As to count one, 5,000, as to count two, 2,500. Thank you both for your input. Well argued at this time. There's going to be a stay away order. Mr. Rivera, if you're able to obtain your release, you have at this time to understand that you may not be at any time within 500 feet of Joshua Martinez. You may not contact him directly or indirectly or in person or in writing or by telephone or by pager or fax or through third parties. Defendant must stay at least 500.
Yes, I do.
What did he say?
He says he understands.
He understands 500 feet away from the victim's home, his place of employment, and school. Good luck to you, sir. Next case. Case of Billy Estenos.
Mr. Estenos has 2 probation warrants, no bond.
Thank you. In this case, Mr. Estenos has 17 cases attached here too. And in this case, 17 stay away orders alleged attached there too. So give me a moment, please. Would the state like us to go one at a time? Very good. As to case 25010109, Mr. Estenos, you've been charged with a third-degree felony, grand theft, and in the third degree of a contractor in violation of 812.014. This occurred in a retail theft setting at Northwest 57th Avenue and 690th Street about.
I don't have any probable cause arguments in the case ending in 10109.
I see you said as to all 17, you have no probable cause arguments. Is that correct?
No, I said I don't have a probable cause argument as to the case ending in 10109.
We'll have to find that. Give me a minute.
I believe that's the one you just referenced.
Yes. 139, did you say? No, that's his jail number. 0109. Your probable cause argument is?
I don't have one. That's all I said. I don't have one for the case that you're on.
So, Your Honor, for the case ending in 109, state requests the standard bond of $2,500.
No objection.
So we might speed this along. Counsel, you may have had a chance to review all of the other 16 cases. Are you going to make the same declaration as to all 16?
I'm just triple checking. No, I have some probable cause arguments for some of them, but not all of them.
$2,500 bond approved. As to the case ending 109. And Mr. Estenos, I'm going to only say this once to you. To the degree that I were to do it again, it would be related to other cases, but you may not return to the CVS located at 690 Northwest 57th Avenue, Miami, Florida 33126 at any time without prior order of this court. Do you understand?
Yes, sir.
We're going to issue a probationary hold on all cases except those I might not find probable cause on if I get to that point. So do I need to write that here?
Yeah. The other case.
Thank you. Next case ends in 108.
No probable cause argument on 108.
The state would be seeking a standard bond of $2,500.
Stipulated.
Stay away order in case number 108 as similarly instructed. Do you understand, sir, to stay away from the CVS pharmacy at 650 Northwest 27th Avenue?
Yes, sir.
Yes, thank you. Next case ends in 107.
No probable cause arguments. I'll stipulate to standard bond.
State
State stipulates, Your Honor.
standard bond is
$2,500.
And 150 for count 2.
That is correct.
as to case number 107. Again, I must ask, sorry if it sounds like a broken record, but Mr. Espinosa, you understand you may not be at any time at the CVS at 5695 Southwest 8th Street, Miami, Florida.
Yes, sir.
Till further order of this court. Next case, the case ending in 106. 3 counts, count F2, felony second burglary of an occupied structure, felony of the 3rd degree, and count 2, grand theft 3rd degree. This is a violation of Florida statute 812.014. The first count was a violation of statute 810.02. The 3rd count is a felony of the 2nd degree retail theft, prior convictions, violation of 812.015. Again, CVS at 1200 West 68th Street, Hialeah, Florida. I find probable cause.
Your Honor, I stipulate to probable cause on count 1 for burglary, and I would argue, or I'd be stipulating to standard bond of $7,500 at that time. However, a defendant cannot be charged with both grand theft and retail theft. It's duplicitous. It's essentially charging someone twice for the same conduct. And so I'd be asking that Your Honor make a probable cause finding for grand theft, and I'll stipulate to probable cause or to standard bond of $2,500 on count 2. But for count 3, I'd be asking no probable cause, release outright, and that's the same argument I'll be making in all the cases where he's charged with both grand theft and retail theft.
State stipulates all of his arguments, Your Honor.
No, thank you. Release outright, no PC. As to count 3, retail theft, correct?
That is
Yeah.
correct. So we would be seeking the $2,500 bond in the burglary charge and the grand theft charge.
7,500 count 1, 2,500 count 2.
That's correct.
And a stay away order, again, Mr. Estino, CVS at 1200 West 68th, Hialeah, Florida, until further order of this court. All right, this is ending in 104. It's a Navarro Pharmacy, 4410 West 16th Avenue, Hialeah, Florida. In this case, court finds probable cause for the 3 counts. In this case, felony in the, I'm sorry. This is burglary of an occupied structure, grand theft to 3rd degree, same as the 2 prior counts and same as many of the prior counts we've already gone over. The same argument to be made, I presume.
Yes.
Public defender has to count 3.
State stipulates, Your Honor.
All right.
So 7,500, 2,500, release outright.
State stipulates.
Stay away order, Navarro, 4410 West 16th Avenue, Hialeah, Florida. Until further order of this court. Next one, Estinos, charged with retail theft. 750 coordinates 30-day previous conviction within 30 days. In violation of 812.013. And felony in the 2nd degree criminal mischief over 1,000 with prejudice, violation of Florida statute 80613 subparagraph 1.
Your Honor, I have no probable cause arguments as to count 1, but to count 2, there's no dollar amount for the criminal mischief alleged, so I would stipulate to misdemeanor criminal mischief, but not felony.
Your state will stipulate to the misdemeanor criminal mischief $200 or less, since there's no amount.
So the standard bond for count 1 would be 5,000.
Count 2.
Your Honor will be $250.
And that is as to, instead of criminal mischief, felony 2, it's what?
It's a second degree misdemeanor, Your Honor.
Count 2 is 150 or 250?
250. Stay away order from CVS 4000 Collins Avenue, Miami Beach. Is that the one we were just on? Yes, yes, so. The next one, Mr. Espino's, is again the same charges we have been discussing in all 3 cases. Florida Statute 810.02, 812.014, and 812.015. Retail theft, grand theft, and burglary. Court finds probable cause as to all except the retail theft charge. Are we similarly treating this one, Madam Public Defender?
Yes, please, Your Honor. I would do 7,500 count 1, 2,500 count 2, no PC release outright count 3.
It stipulates.
Judge, are we on case ending in 082?
Yes.
Yes, we are. Thank you. Stay away order from CVS 1525 West 49th Street, Hialeah, Florida, until further order of this court.
That's 7,500, 2,500 release outright?
Correct. Yeah. We now have the same allegations on a different date at a CVS Walgreens located at 101 Hialeah Drive, Hialeah. All 3 charges. He's been charged with violation of Florida Statute 810.02, 812.041, and 812.051. Are we similarly situated in this, Madam
Yes.
Clerk? Thank
Yes.
you. 7,500, 2,500 as to count 2, release outright as to count 3.
Judge, is this case ending in 081, correct?
Yes, and I'll start announcing it. 8-1 is correct. Stay away order from 101 Hialeah Drive, Hialeah, Florida, CVS until further order of this court. Next case. Case of Estenos, Billy Estenos, same 3 charges as we just stated. In this case, this is case number ending in 80, CVS 101 Hialeah Drive on a different date. Same thing, Madam Public Defender.
Yes.
Date stipulates, Your Honor.
7,500 count 1, 2,500 count 2, release outright as to count 3. Stay away order from CVS 101 Hialeah Drive, Hialeah, Florida. Next case, Estenos, case ending in 7-9, retail theft, prior conviction, violation of Florida statute 812.015 subsection 9. Incident occurred at Alton Road.
Your Honor, I have no probable cause for arguments. I'll stipulate to standard bond of $7,500.
They'll stipulate to 2,500. Any objection, Mr. Kaufman?
No objection, Your Honor.
Probable cause found after reading the A form. Stay away order from 1421 Alton Road, Miami Beach, Florida. until further order of the court. State versus Billy Estenos, case ending in 078. Felony in the second degree retail theft, prior conviction, 812.015.
I have no probable cause arguments. I'll stipulate to standard bond of 7,500.
Again, occurred at a CVS. Standard bond 2,500, Mr. Kaufman.
That is correct, Your Honor. State stipulates.
Stay away order, Mr. Estenos, from the CVS at 9031 Southwest 107th Avenue, Miami, Florida 33176 until further order of this court. Next case, State versus Billy Estenos. In this case, it's a felony in the second degree retail theft, coordinated $750 in loss, and within 30 days of previous conviction in violation of Florida Statute 812.015, subsection 8.
Your Honor, I believe this is the case ending in 7-7. I have no PC
Thank
arguments.
you. 077.
I have no PC arguments. I'll stipulate to standard bond of 5,000.
Any objection, Mr. Kaufman?
No objection, Your Honor. State stipulates.
I've read the lengthy narrative in this case, which occupies 2 pages, single spaced. Find that the probable cause is supported by the arrest form and vice versa. In this case, stay away order from the CVS at 2780 Northeast 8th Street, Homestead, Florida, 33033 until further order of this court. Next case, State versus Billy Estenos, F2, felony in the second degree, retail theft, prior conviction, 812.015, subsection 9A. CVS Pharmacy, 7199 Southwest 117th Avenue. Any objection or any input from the state?
No objection, Your Honor.
How about the public defender?
No, Your Honor, I think this is the case ending in 074. I have no PC arguments. Stipulate to standard bond.
This one is 074. Yes, thank you.
State stipulates to the bond of $2,500, Your Honor.
Thank you. At this juncture, there is a stay away order being issued by the court as to the CVS 7199 Southwest 117th Avenue, Miami, Florida 33183, as to defendant Estenos. In this case, State versus Billy Estenos ends in 013. Retail theft, prior conviction, 812.015. In this case, the court finds probable cause.
State seeks standard bond, $2,500.
No objection.
Stay away order from the CVS at 227 Southwest 8th Street. Was that case number 013?
Yes, Your Honor.
Thank you. So order,
And that's 2,500, Judge?
yes. Bond was 2,500. State versus Billy Estenos, case ending in 4284.
That, I think it ends in 012.
Speak up, I'm sorry.
It ends in 012. The 4284 is the police case number. The court case number ends in 012.
I don't know why I do that. Thank you. 012 is our case number. He was arrested at 6,000 Crandon Boulevard, Biscayne, Florida. In this case, we find probable cause.
The state seeks a bond, $2,500.
Stipulated.
In this case, Mr. Estenos has to stay away at all times from 650 Northwest 27th Avenue, Miami, Florida. I thought it was at Crandon Boulevard, but maybe that was a different location than the arrest. I mean, different location than the incident. So if I misspoke, may I see that back again? Correct. I apologize. The theft allegedly occurred at 650 Northwest 27th Avenue. He was apprehended at a different location. Next case. He's charged in case number ending 011, retail theft, prior conviction, 812.015, Florida statutes. Court finds probable cause.
State seeking a bond of $2,500.
No objection.
This time, stay away order issued in favor of CVS, State of Florida, and against Mr. Estenos at 2500 Southwest 22nd Street, Miami, Florida, 33145, until further order of this court.
Is that 2,500 for both counts, Judge? It's 2 counts for that case.
Oh, yes.
That is correct. The state is requesting the standard bond of $2,500 in each count.
That's fine.
I'm sorry, I missed that. Thank you, corrections. In this case, 2,500 as to the second count. Case ending in 010, 4 counts, burglary of an unoccupied structure in violation of 810.02, retail theft, coordinated within 30 days of a prior conviction, 750 in amount, 812.015, misdemeanor of the first degree, false name after ID arrest, in violation of Florida statute 901.36. There's a 4th line item under charges, which indicates probation warrant violations.
Yes.
For
Your
this
Honor.
case, Judge, is 3 counts.
So I have no probable cause arguments. I'd stipulate to standard bond in these 3 counts, and then a hold is going to be issued on the probation cases.
Yes, Your Honor, and you already issued the probation hold for all cases.
Thank you. Count 1.
Your Honor, count 1 is going to be $2,500.
2.
Count 2, $2,500. Count 3 is going to be $500.
Very good. And if I have completely bored you to death, Mr. Estenos, one more last place you can't go to, and that is 726 Crandon Boulevard, Key Biscayne, 33149, CVS, at any time until further order of this court. Do you understand?
Yes, sir.
Thank you. Good luck to you, sir. Dennis Moreno.
Mr. Moreno has a hold for immigration.
Your Honor, Mr. Moreno's present. He needs the services of the Spanish interpreter. I don't have any probable cause arguments.
Your Honor, the state is seeking standard bond of $2,500 in charge 1, $2,500 in charge 2, and $500 in charge 3.
As this is a similar looking A form as to the other 2 defendants, I've read through it very quickly. In this case, Mr. Moreno, you've been charged in count 1 with animal fighting, baiting, and attending such a fight, 3rd degree felony in violation of Florida statute 828.122 subsection 3. Being in possession of a weapon and committing an offense in violation of Florida statute 790.07, felony of the 3rd degree, and a misdemeanor of the 1st degree, resisting an officer without violence, 843.02 Florida statutes. Court finds probable cause in all 3 counts.
Señor Moreno, como en los otros casos, a usted se le imputa haber ayudado o asistido en una pelea animal, lo cual es considerado un delito mayor de tercer grado acá en el estado de la Florida. También tenencia de un arma durante la comisión de un delito, también es considerado un delito mayor de tercer grado acá en el estado de la Florida. Y el tercer cargo es un delito menor, que es poner resistencia al arresto sin violencia. Su señoría encuentra causa probable con respecto a los 3 cargos en su contra.
Thank you, Madam Interpreter. I apologize. Good luck to you, sir.
Buena suerte, señor. La fianza se queda como lo pidió la fiscalía: $2,500 cargo 1, $2,500 cargo 2 y $500 el cargo 3.
Judge, that's 2,500 counts 1 and 2, 500 count 3.
Yes. We have 2 cases in the case of Jose Luis Velo, Villot. Actually, let me restate that. Yes, we still do have 2 cases for Mr. Velo. If we wish, we can start with the case ending in 058. Mr. Velo, you've been charged with cocaine possession in violation of Florida statute subsection 3. There he is, Mr. Velo.
Yes,
You've been charged with cocaine possession, count 1, third-degree felony in violation of Florida statute 893.136A. Second count, misdemeanor in the first-degree drug paraphernalia with the intent to use in violation Florida statute 893.147. At this time, having read the arrest form, I find probable cause.
Your Honor, the state is seeking standard bond of $2,500 in charge 1 and standard bond of $500 in charge 2.
Objection.
For which case?
Case involving 058, ending in 058, Jose Velo. In this case, Mr. Velo, I'm issuing a stay-away order from, that would be the next case, excuse me, hang on. All right. He has a second case. It ends in 057. The first count is second-degree felony robbery, strong arm in violation of 812.13 subsection 2. And the second count is felony in the first degree, battery aggravated on a person 65 years or older in violation of Florida statute 784.08 subsection 2.
Your Honor, I have no probable cause arguments to count 1, but count 2, there's no age listed of the victim, so there's only probable cause for misdemeanor battery.
Sorry, just to clarify, counsel, did you say no probable cause argument for count 1?
Correct.
Yeah, regarding the age, the state will stipulate that it doesn't give the age in the 4 corners of the A form. So the state would be requesting a bond of $7,500 for count 1. And for the battery, the aggravated battery, state would be requesting a bond of $2,500.
With a recognition of the charge now being what?
Aggravated battery, Your Honor.
And that?
I mean, my apologies, aggravated, right?
It's to be aggravated battery, just.
Which is a second-degree felony? No.
I believe so, Your Honor.
We're taking out the 65-year-old.
Correct, Your Honor, because in the 4 corners of the A form, it doesn't give the age.
Probable cause as to that stipulation by the state is found as to, we believe, felony and second-degree aggravated battery only. In this case, Mr. Velo, at no time may you be within 500 feet of the victim in this case. If you are, you may subject yourself to arrest. You cannot directly or indirectly, in person, in writing or telephone or page or fax or third persons actually be within 500 feet of this victim or have any contact with this victim. You also will have no contact and stay away at least 500 feet from the victim himself, victim's home, place of employment, or school at all times. Do you understand?
Yes, sir.
Thank you. Good luck to you. Next case. Demetrius Paul. Mr. Paul, in case number ending 05, case number ending 060, you've been charged with felony of the second degree retail theft with a prior conviction involving Florida statute 812.015, subsection 9. This occurred allegedly at a Marshall's at 1099 North Homestead Boulevard on May 12th, 2025.
Your Honor, in both of these cases, I'll be arguing that there's probable cause for felony petty theft by 2 prior conviction and asking for standard bond of $1,500 in each case rather than retail theft.
So you concur that probable cause exists? I just read the A form, yes?
For petty theft, felony petty theft by prior conviction, not for retail theft.
Date?
Your Honor, I believe the standard bond is $2,500 for a third-degree felony without violence, but the state will stipulate to the felony petty theft by prior conviction.
Which is a felony of the
third degree, Your Honor.
court finds probable cause as to count 1, $2,500 bond. Is that what we said? Yes?
That is correct, Your Honor.
That's for which case, Judge?
That would be for case ending 060. Case ending 059, also at Marshall's, also at the same location on a different day. Felony in the second degree retail theft prior conviction, same situation, Madam State.
Your Honor, same stipulation and same request of $2,500 bonds.
Any objection by the public defender?
No objection.
At this time, Mr. Paul, if you're able to secure your release, at no time shall you return to the Marshals at 1099 North Homestead Boulevard, Homestead, Florida, 33030 until further order of this court. Do you understand?
Yes, Your Honor.
Thank you. Good luck. Okay.
2,500 each, correct, Judge?
2,500. Thank you. Emmanuel Tucker, case ending in 063. There's only one case, I believe. Mr. Tucker, you've been charged with count 1, second degree felony cannabis, selling, possessing, intent to sell within 1,000 feet of a school in violation of Florida statute 893.13 sub 1. Count 2, tampering with physical evidence in violation Florida statute 918.13. This is a third degree felony. Count 3, cannabis possession for more than 20 grams. Felony of the third degree in violation of Florida statute 893.13 subsection 6. And loitering in smoking cannabis, marijuana, hemp in a public place, in a public property in violation of municipal ordinance, Dade County 70.7. This occurred in actually Miami Beach, municipal ordinance of Miami Beach, 900 block of Ocean Drive, May 17th, 2025. Taking a review of the arrest form.
I have no PC arguments, Your Honor.
In that case, the state would be seeking the standard bond of $7,500 for charge 1, $2,500 for charge 2 and charge 3, and $150 for charge 4.
Court, having reviewed the arrest form, finds probable cause and agrees with the state and the PD as to the bond and as to the probable cause finding as to all 4 counts. Good luck to you, sir.
Let's go.
Next case.
He's present, Your Honor. He needs the services of the Spanish interpreter. I do not have any probable cause arguments.
Mr. Gutierrez as a whole for immigration.
Thank you. This is a case of Delvis Roa Gutierrez, case ending in 072, the only one we have. He has been charged in count 1 with a felony in the 3rd degree battery on a person 65 years or older in violation of 784.08.
El señor Roa Gutiérrez tiene una retención migratoria y en el caso que termina en 072, el único que tengo frente a mí, en el cargo número 1, se le imputa un delito mayor de tercer grado, que es agresión física contra una persona de 65 años de edad o mayor. Esto en quebrantamiento de la ley de la Florida 784.08.
Second count is count 2, misdemeanor in the 2nd degree, disorderly intoxication in violation of 856.011.
El segundo cargo es un delito menor de segundo grado, el cual es embriaguez pública en quebrantamiento de la ley de la Florida 856.011.
Your Honor, the state is requesting standard bond of $5,000 for count 1 and standard bond of $150 for count 2.
La Fiscalía solicita a su señoría la fianza estándar. Cargo 1, $5,000. Cargo 2, 150.
No objection.
Thank you. Court enters count 1, 5,000, count 2, 150, finds probable cause.
Perdón, me corrijo. Causa probable encuentra a su señoría. El cargo 1 son $5,000 y el cargo 2 son $1,500.
There's going to be a stay away order issued as well. In this case, sir, if you are able to secure your release, you shall remain and stay away from within no closer than 500 feet from the victim in this case, whose initials are JCR. You shall not get near the victim's home, place of employment or school, no closer than 500 feet, and you shall not contact the victim directly or indirectly in person, writing, telephone, pager, or fax, or through third parties. Do you understand?
Señor, también voy a emitir una orden de alejamiento. Si usted llega a ser liberado, usted tiene que mantenerse en todo momento a no menos de 500 pies de distancia de la víctima, cuyos iniciales son JCR. Usted no puede estar cerca de la residencia de esta persona, el lugar donde ella viva, trabaje o estudie. Usted tampoco puede contactar a esta persona de manera directa o indirecta, en persona, por escrito, vía telefónica, a través de las redes sociales o a través de terceras personas. ¿Usted me ha entendido?
Good luck to you, sir.
Buena suerte.
Casey Edward Bryant. Mr. Bryant, you've been charged with a felony in the 3rd degree, petty theft, with 2 prior convictions, 812.014 subsection 3 Florida statute. This occurred in Homestead, Florida.
And Your Honor, I have PC arguments.
Yes, thank you. We'll hear from you at this time.
So within the 4 corners of the arrest form, there's no allegation that Mr. Bryant has any prior arrests or convictions for theft. Because of that, there is probable cause for misdemeanor petty theft. But because we're relying on the four corners of the arrest form, there's no probable cause for a felony. I'd be asking for a $500 bond with an alternative of pretrial services if he qualifies.
Your Honor, state stipulates and has no objection unless they don't qualify. So Your Honor, we could do alternate tap.
That'd be fine.
All right. Court finds probable cause for the felony of the, or misdemeanor?
It's a misdemeanor, Your Honor.
Misdemeanor of the
First degree.
first degree. $500 alternate bond with the TAP program approved. You, sir, if you are able to secure your release, you shall not return to the location of 120 Northeast 8th Street, Homestead, Florida, that business establishment at any time until further order of this court. Otherwise, you subject yourself to be rearresting by violating this order. Do you understand?
Yes, sir.
Thank you. Next case. Jonathan Valdemar.
Mr. Valdemar is out on felony bond F257217.
Your Honor, state requests a felony hold.
Your Honor, I have Mr. Valdelomar here. I don't have any probable cause arguments.
Your Honor, state would request a bond of $7,500.
That's fine.
Out on felony bond, and you're requesting
Felony hold, Your Honor.
granted.
Okay, well, what's the bond?
And then a bond of $7,500, Your Honor.
Bond on count one is $7,500. Good luck to you, sir. Next case, Romello Mays.
Bond out.
Bond out, Judge.
Thank you. Next case, case of Dante McLean.
He's a bond out. I have Mr. Rodriguez here. He would need the services of the Spanish interpreter. And I do not have any probable cause arguments.
Thank you. Ray Del Lazaro Rodriguez Vergara. He has two cases before the court. Let's deal with the case ending in 092 first.
La defensa no tiene ningún argumento que hacer con respecto a causa probable. El señor Lázaro Rodríguez Vergara tiene dos causas frente a este tribunal y vamos a comenzar hablando de la causa que termina en 092.
In this case, Mr. Rodriguez Vergara, you've been charged with grand theft in the third degree in violation. Florida statute 812.014. This is a third degree felony.
Señor Vergara, en este caso usted se le imputa hurto de mayor cuantía, un delito mayor de tercer grado en quebrantamiento de la ley de la Florida 812014.
You've also been charged in count two of trying to use anti-shoplifting devices in an attempt to obtain the merchandise in question. This is occurring at the Burlington store at 1645 Northwest 107th Avenue.
El segundo cargo es tratar de usar dispositivos antidetección de robos, esto con la finalidad de obtener la mercadería de la tienda Burlington, ubicada en la 1645 del Northwest y la 107 Avenida.
Court finds probable cause as to both counts.
Your Honor, the state is seeking standard bond of $2,500 in the first count and $2,500 in the second count.
Su señoría, la Fiscalía pide fianza estándar de $2,500 en el cargo 1 y $2,500 para el cargo 2.
No objection.
No nos oponemos.
All right. Count two, and excuse me, count one, 2,500, count two, 2,500.
Yes,
Probable cause found. In this case, Mr. Rodriguez Vera, as to case number 092, you must stay away at all times from the location of the retail establishment at 11401 Northwest 12th Street, Sweetwater, Florida, until further order of this court. Do you understand?
Muy bien, señor Rodríguez Vera. En la causa que termina en el 092, usted tiene que mantenerse en todo momento alejado del negocio ubicado en el 1145 en Sweetwater, Florida. ¿Usted me ha entendido? Yes.
As to case ending in 091, we have the identically same charges. In this case, I find probable cause. State.
Your Honor, the state is seeking standard bond of $2,500 for charge 1 and $150 for charge 2.
En el caso que termina en 091, son cargos realmente idénticos, encuentro causa probable y la fiscalía solicita fianza. Cargo 1, $2,500 y en el cargo 2, $150.
Count 1 was how much, Mr. Kaufman?
Count 1 is $2,500, and count 2 is $150.
Very good. This time that was the same location, so he's under the same stay away order. Next case of Daniel David Parson.
Como es el mismo lugar, se tiene que mantener alejado.
Bond down, Judge.
Thank you. Case of Mario Savon. Is this Mr. Savon?
No, Mrs. Savon, Judge, is reset medical for tomorrow.
Thank you. Case of Fernando Bell Tagar Mendea.
Mr. Fernando is a fugitive from Manny C County with a no bond. He also has an immigration hold.
Thank you. In this case, ending in 116, you've been charged with a second-degree felony burglary of an occupied dwelling, violation of 810.02, and a second count of burglary of an unoccupied conveyance attempted, third-degree felony in violation of Florida Statute 810.02. Having a moment here to review this.
I have no probable cause arguments. I'm asking for standard bond.
State stipulates, Your Honor, that would be $2,500 for both charge 1 and charge 2 each.
If you're able to secure your release, I'm granting probable cause in this case as to both counts. I've set the bonds as 2,500 count 1, 2,500 count 2.
Your Honor.
Your Honor, correction, for count 1, the state is actually requesting a bond of $10,000 for the burglary of the occupied dwelling. And for count 2, $2,500 for count 2.
Madam Public Defender.
No objection.
Excuse me, I'm not doing all the talking, but most of the talking. All right. 10,000, you say?
Yes, for count 1, Your Honor.
Ms. Mueller? Granted. So the count 1 will be 10,000, count 2 will be 2,500. In this case, sir, if you are able to secure your release, you must at all times not return to the location of 1731 West 56th Terrace, Hialeah, Florida, which relates to the incident that we just discussed. This case will be as to the case ending in 117, State versus Fernando Bell Tagar Mendea. Identically same charges, it looks like. Location of this incident was 5626 West 17th Lane, Hialeah, Florida. Burglary of an occupied dwelling, count 1, 810.02 Florida statute. Felony of the third degree grand theft, 812.014 subsection 2 subsection C. Madam Public Defender, any probable cause.
No.
Court finds probable cause based on a review of the arrest form.
Your Honor, the state would be seeking a $10,000 bond in charge 1 and a $2,500 bond in charge 2.
Granted. In this case, Mr. Beltran Garmendia, you shall not return at any time until further order of this court into the location of 1718 West 55th Place, Hialeah, Florida. Do you understand?
Yes, sir.
Thank you. Next case, with the case ending in 114, burglary of an occupied conveyance, Florida statute 810.02. This occurred at 1718 West 55th Place, Hialeah.
Your Honor, I believe there's only PC for an unoccupied conveyance, not occupied.
I think it's a typographical, but maybe not.
State stipulates, Your Honor. In that case, we would be seeking standard bond of $2,500.
The court finds that what was set forth in the arrest form is an unoccupied vehicle, correct? Thank you. At this time, I find probable cause as to count 1. Standard bond again.
Standard bond of $2,500.
Is this? Yes. Again, Mr. Beltran Garmendia, you must not at any time and be found at 1718 West 55th Street Place, Hialeah, Florida 33012, until further order of this court. Do you understand?
Yes, sir.
Did I forget? I read it, but I didn't sign it. Thank you. Next case, Beltran Garmendia. This is a violation of Florida statute. Excuse me, this is case 113. Felony of the 3rd degree burglary, unoccupied conveyance 810.02, subparagraph 4. Court finds probable cause.
The state requests standard bond of $2,500 in both counts 1 and count 2, Your Honor.
That case has 5 counts.
There's 5 counts in this case.
For case ending in 113.
Case ended in 113 has 5 counts.
Correct.
And it would be $2,500 in each count, Your Honor.
In this case, Mr. Beltran Garmendia, you mustn't be found again at the location of 1702 West 55th Place, Hialeah, Florida, where these incidents are alleged to have occurred until further order of this court. Do you understand?
Yes, sir.
$2,500 each count, Judge.
2,500 per count, all 5. And last but not least, the case of Beltran Garmendia Fernando, count 1, felony of the 3rd degree, burglary of an occupied dwelling attempted in violation of Florida statute 810.3A, and count 2, misdemeanor of the 1st degree, resisting an officer without violence to his person in violation of 843.02. This occurred at the location of 7260 Southwest 9th Street, Miami, Florida. Court finds probable cause.
Your Honor, the state is requesting standard bond of $2,500 in count 1 and $500 in count 2.
Court grants $2,500 bond, count one. $500 bond, count two, after review of the arrest form. Again, finding probable cause supporting both in the narrative. And lastly, Mr. Beltran Garmendia, you mustn't return at any time to you mustn't return at any time nor be within 500 feet of 7260 Southwest 9th Street, Miami, Florida, 33144 until further order of the court. Do you understand?
Yes, sir.
Good luck to you, sir. At this time, unless the state or the public defender or the clerks have anything further for the court to consider, we are in recess.
Nothing on the state counter.
I would like to thank our state's attorneys today. They've done an excellent job. I would like to thank, in this case, Ms. Chateria. Very, very well done. Thought all three of you did a fine job. Our clerks is always the unsung heroes of every program every time I'm here. And our police liaison officers, as well as our folks on the video court computer. Trust me, made it a lot easier for me. I was trying to memorize the instructions on how to load all this, and I tell you, we'd still be here if I had been trying to do that. Nice to meet you all. Madam Interpreter, thank you so much for helping us. You did a wonderful job as well.
Thank you, Judge.
Thank you, sir.
You're welcome.
Thank you.
Yes. Are we off the record now?
That's gonna come in now.
Thank you. I learned one thing about Mr. Estones. The addresses were creeping closer and closer to my CVS. And I'm going, oh no, here we go. Thank you. Second, he must have web Googled, and I'm saying this absolutely knowing nothing of the case, every CVS in Navarro Pharmacy in Dade County. I don't think there was one left, was there? I don't know. Oh my goodness. And someone along the line, well, I can't